Are we starting to come up with hearing? Oh, sorry, starting now. Cheryl, you want? I had one. Oh, okay. Yeah. Yeah. That works. Oh. What? Yeah, well, I would, they have to call that a function in order to tell yourselves to order. They seem to want to address something. I would just. Okay, so I'll put you guys everyone here to the mic. It was culturally okay. I thought we were. Okay. Yeah.
It is. I'm just going to interrupt. It is very hard to hear you guys talking. I heard something about the order of us calling each other to order.
Right, right. Allergies. Good morning, everybody. Everybody in the room, on the platform today. This is the EIB meeting and joint public hearing. It is 9:04 on March 22nd, 2024. Please excuse me having allergies. So sorry, sounds stuffy here.
Start off.
I would like to do roll call first. Miss Jones, would you mind doing roll call?
Yes, I will. I'm just looking online. We have 2 remote members, and I don't see them, but okay. Member Bitzer, are you present? Member Ely?
Present.
Member Garcia?
Here.
Member Honker? Vice Chair Trujillo?
Present.
Chair Sweeney?
Present.
I think we need to work on, Mr. Honker's working on getting in through the link I sent him.
Okay.
And it sounds to me like we're getting an echo. Buddy, can you handle? Something's muting us, or something should be muted.
Unless someone has their. Okay, I'll hold the right seat.
So are you thinking those that we wait to see if we get the IT?
We could, did you say that the Albuquerque board needed to do a roll call as well? We could let them do theirs.
Yeah, we'll let them do theirs too, and then maybe turn it over to the Albuquerque board. So I see legal counsel Cedilio, and I see Chair Paul. So the floor is yours.
Great. Can you guys hear me okay? No? I'm not on mute.
I can hear you, Chair Paul. This is Vice Chair Richards.
Okay, glad you can hear me. Can the hearing officer, Ms. Lushworth, hear me? Oh.
Oh, we can't hear them.
Yeah.
No,
Give us a call if we can't hear you.
I'm not sure what to do about that. Should I just keep talking? Testing? Nope, not getting anything. No thumbs up. Thumbs up if you can hear me. No? Okay. I'm not sure how to help you guys. I could try. Is there a call-in number? Yeah, okay. So folks on the platform can hear me, but thank you, Mr. Maxwell. They can't hear us. Okay. How are we gonna do this? We could call in by phone if that's an option.
Madam Chair, they are getting an IT person, so
Well,
I,
please,
since they
because
can't
that's
hear you,
where
might as well just
trying to
wait
get-
until the IT
get,
person addresses it.
IT.
Thank you.
Conference,
while we're-
resolved. Oh, yeah.
No.
And Chair Paul,
Well,
we'll
probably
Yes.
see you in a minute to see if we can do another test. So. Hey, Isaiah, this is David. Yeah, we're not down, just text. But, yeah. What changes? Yeah. Sure. I guess. Legal counsel. We can't take her. Okay, Ms. Bowen, can you hear us? Put a thumbs up.
I hear Chair Sweeney talking,
Okay.
but I don't really hear what you're
So
saying.
what we're thinking, just in the essence of time, is that we could, and we have member Holger as well. Member Holger, would you mind doing your videos? We can see.
I did not fully hear that. I'm not sure if you're talking to me.
Member Holger just,
Yeah,
email
it's very garbled.
online. Oh, it said speaking, member Holger goes out.
Yeah. The hearing officer, Felicia Orth, her voice came through fine. Everyone else's voice is coming through garbled.
We have IT testing.
You want a different layout? Is that what I'm hearing?
Yeah, can we try the layout where we want to see the videos?
Oh, it's the bottom one, I participants without video.
Which one?
It was the bottom one in the drop down. I participants without video, so down, down, down. There you go.
And you make sure they have the video when they speak.
Make sure they're in
They're speaking. Now on video, I don't know who it is.
There's also an option there to do, for whoever is speaking, that their picture comes up. The people focus.
Yes.
Okay, but no, the voice is to speak.
Yes.
So true.
And I think they let Mr. Hooper in. Let me just check if he's in.
Yeah, see,
He's on the screen. He's just here. Tell you.
Or Miss Chair Paul, could you do the test 1, 2, 3?
I heard Chair Paul, and then it got digital. And maybe a little of one other word.
Well, we can hear you now. Can you hear me?
You sound like a robot. But I did hear what you said.
One, two, three. Do I sound better, Chair Paul?
Yes, much clearer, quite quiet. If you can turn up the volume, I can turn up my volume too, but I think I usually have it on.
Do another test 1, 2, 3.
Perfect. There we go.
Okay, great. Thank you. Okay, I think there's a echo though.
There is a bit of an echo, but it's not as bad as it was before.
Let me do another test 1, 2, 3. Somebody their computer on? Just coming from us.
Got a lot of talking to do today.
Somebody in the meeting room may have the volume up on their laptop if they've got it on the laptop, and just turn your volume all the way down on the laptop. I think that's where the echo comes from.
Want to do another test 1, 2, 3.
So if we remain muted, if everyone in the WebEx remains muted, unless they're speaking, we should be able to do this.
I'll do a test 1, 2, 3.
Clear over here.
Sounds good to
Okay.
me.
Does that work?
I think so.
All right. Okay. Thank you to our IT specialist here at the Capitol. Appreciate that. Appreciate her help. So we will get back to our meeting agenda. All right. I would like to just redo our roll call vote since we do have another board member on the platform here. Ms. Jones, now that we have our IT issues worked out, can you do a roll call vote?
Yes, I will. Member Bitzer, have you joined us? Okay, Member Ely? Present. Member Garcia? Member Honker?
I'm here.
Vice Chair Trujillo?
Present.
And Chair Sweeney.
Present.
We have everyone but Mr. Bitzer, and we'll continue to try to connect with him.
Thank you, Ms. Jones. Appreciate the roll call. And again, thank you for everybody's patience as we navigated the IT issues. And number 2 on our agenda is the approval of the March 2020 or 2022, March 22nd, 2024 agenda. Is there any changes that we see, fellow board members? Nope. If we don't have any changes, I'd love to entertain a motion.
I move we approve the agenda for today's meeting.
Thank you, Member Honker. Thank you, Member Garcia, for your second. No further discussion. Ms. Jones, please do our roll call vote on Member Honker's motion to approve the agenda.
Member Ely, how do you vote?
Approve?
And Member Garcia,
Yes.
Member Honker,
Yes.
Vice Chair Trujillo,
Yes.
Chair Sweeney.
Yes. Thank you, Ms. Jones. All right, we're on agenda item number 3, which is the approval of February 29th, 2024 regular meeting minutes. Those meeting minutes have been distributed, and I'm looking around if there's any amendments, revisions, changes. Not? Looking for a motion.
Yeah, wait a minute. This is Member Hunker. I've got on item 7, I think the language is confusing. It's that was the hearing that I acted as hearing officer, and 3 times in that discussion, it refers to me as chair instead of hearing officer. So I think we ought to change that to hearing officer just for consistency and to avoid confusion with the chair of our board.
Thank you, Member Hunker. So those would be the revisions to incorporate. Are there any other revisions that folks saw? All right. Looking for a motion.
I move we approve the minutes for the February 29th, 2024 meeting with the 3 changes that I just proposed.
Thank you, Member Hunker. Thank you for a second. Thank you, Member Garcia, for the second. No further discussion or revisions. Ms. Jones, would you please do a roll call vote on Member Hunker's motion?
Yes. Approve the amended minutes. Member Ely, how do you vote?
Yes.
Member Garcia,
Yes.
Member Honker,
Yes.
Vice Chair Trujillo,
Yes.
and Chair Sweeney.
Yes.
Minutes are approved.
Thank you, Ms. Jones. With that, we will be going to agenda item number 4, which is public comment. And these are general comments not pertaining to any meeting agenda items for today. Looking in the crowd and then toward Ms. Jones, is there anybody or Adai on the platform that would like to make a public comment?
No one has reached out to me to make general public comment this morning, Chair.
Thank you, Ms. Jones. And so I'm looking around the room. I don't see any other individual raising their hand. So we will move on to agenda item number 5, which is EIB 24-12 in the matter of proposed repeal and replacement of 20.2.71 NMAC, operating permit emission fees, and 20.2.75 NMAC construction permit fees. Request for hearing, appointment of hearing officer. And we have Mr. Prince, counsel for NMED. And thank you for coming today. Ms. Keene. Thank you so much. The floor is yours.
Thank you. Good morning, Chair Sweeney, members of the board. My name is Michael Prince. I'm Assistant General Counsel with the Municipal Environment Department, representing the Air Quality Bureau in EIB 2012. We're here this morning before the board on the petition that was filed earlier this month to repeal and replace 20.2.71 and 20.2.75 Mexico Administrative Code. Those two parts, Part 71, 75, and the permitting fees that Air Quality Bureau collects as part of its regulatory duty to carry out the Clean Air Act, state air quality control regulations. Also, at the table, I meant to introduce our Elizabeth Kuhn to my right. He is Air Quality Bureau Chief. Left, Michelle Miano, Director of the Environment Protection Division. Okay, so we're just here before the board to request that the board take this matter up and schedule a public hearing. We are requesting the dates of June 10 and 11, which are a Monday and Tuesday. And also the appointment of a hearing officer. I think this room, if the board takes it up, this room is probably adequate for we do expect some public interest in these whole changes. With that said, I mean, unless you have, I stand for questions this time, or if you have colleagues.
Thank you, Mr. Prince. Do you have any questions? Yes, Member Ely?
Mr. Prince, do you anticipate any petitions being filed in opposition to the
Thank you. At this time, I don't personally. So, yeah, my colleagues say no.
Thank you, Member Ely. Do you have any questions? Yeah, Vice Chair Trujillo?
Yeah, just a quick one here. When was the last time these were updated?
Oh, thank you, Vice Chair Trujillo. It's been about 20 years since these fees have been updated. And since that time, especially over the last 12 years, there's been a significant increase in the number of permits, oil and gas permits that have been, applications and permits that have gone out. Also been some changes to federal and state air quality regulations. For example, the ozone precursor rule that this board adopted a couple years ago. And so there's been an increase in workload in the complexity of the work the Quality Bureau has to do in order for it to effectively and efficiently do its job. This revenue be updated.
Thank you for that response, Mr. Prince. Any other questions from members of the board? I also want to note that Member Bitzer has joined us. Good morning, Member Bitzer. Thank you. For members on the platform, do you have any questions of our presenters this morning? Oh, yes, Ms. Bowen.
Good morning. I just wanted to check, are the dates requested for the hearing flexible, or are those, they need, I believe you said 13th?
Thank you. Question. Those are our preference for the two dates. Bureau's eager to try to get this as quickly as possible. We'll, of course, work with the board. Those are our preference.
Okay, great. Thank you.
Great question, Ms. Bowen. And can you repeat those dates again? I think you said June 10th and June 11th?
Correct.
Okay. All right. Is there any other items, other presenters would like to share comments that we consider? So members of the board, we have a request for hearing from the department for June 10th and the 11th. And just checking one more time that you do think both days will be needed or sufficient?
Yeah, I think 2 days will be sufficient.
Okay. Wonderful. Ms. Bowen?
Yes, Chair. Oh, I'm sorry. My hand is still raised. That was an accident. Thank you, though.
Chair, I have I guess, a point. Seems like if it's going to be a 2-day hearing and since we're talking about increasing fees, I would guess the universe of permittees and folks impacted by this would be substantial. There may indeed be some opposition or comment from the regulated community. So it sounds to me like we should probably get an external hearing officer for this rather than one of the board members doing it.
Thank you, Member Hunker. I appreciate that input. Is there any thoughts to that? Yes, Vice Chair Trujillo. Okay. Wonderful. So with that, I think what does the board think about the dates? Are those dates amenable? Yes, Vice Chair.
I believe we've done it. It would,
I can't hear any of the discussion that's going on.
oh, okay. Sorry, Member Honker. I was just suggesting that we couple it with the end of the month hearing or regular meeting, so the June 27th, 28th.
Would that be amenable to the department?
Yes, that would be.
Thank you. And Member Hunker, can you hear us now?
Yeah, very clearly. Thanks.
Okay. Yes, so with that, we have a couple of different dates, looking at our end of the month meeting date. Is that amenable to fellow board members? Is that a good date for you? Yes, Member Ely?
Sorry about that. Don't touch your mic. I can probably be available at the end of June remotely, but I don't know that I will be here in Santa Fe. So I guess we need to determine if we'll have a quorum. Dates being considered.
Okay. Yeah, so looking at the other board members, Member Hunker, Member Garcia, Member Bitzer, Vice Chair, thumbs up, the end of the month, either day? Okay, same for me. And I think we might still have a hybrid option, so you could participate. All right, so I think we've got a number of items and consideration and details, logistics on the floor. And as Member Hunker discussed and commented that maybe a hearing officer, is there a Ms. Jones? Oh, okay. A hearing officer that would be available toward the end of the month in June?
I would have to poll them,
Okay,
find out if those dates are available.
okay. All right. So we would probably have to determine the outside hearing officer if that's the way the board would like to proceed. So just want to put that on the table for any potential motion that's framed. Thank you. Member Garcia?
If you don't anticipate this
I can't hear Member Garcia.
Can you hear me now? No? Can you hear me?
Yes.
Okay. So my question is, if this is non-controversial, why do we need 2 days?
Yes, thank you, Garcia. So at this time, yeah, we've done some public outreach and we haven't, generally the reception has been fairly positive. We figured 2 days, these are two different sections. Just basically to build in extra time if there is opposition or just to be sure to cover, all the bases, questions from board members. So that's why we figured, just to be sure. Do it in one day, possibly.
Okay, thank you. So you've run it by industry, obviously.
Yes, I
and
did.
So far, there's no opposition.
Correct.
Okay, thank you.
Thank you for that clarification, Member Garcia. With that, do any of the members want to propose a motion regarding this NMED's request?
Sure.
Yes, Member Ely.
I move that we move forward with the petition as proposed by the department with a hearing date that coincides with the EIB's regular meeting in June, and that we consider or look for an outside hearing officer.
Thank you for that. Ms. Bowen, do we need to define a specific date? What's your guidance?
In order for me to write the order, a date would be helpful. It sounds like everyone had agreed on the 27th and the 28th. And I can write it as we have in the past, where it starts on the 27th and continues as needed, if that's how you folks want it. As for the hearing officer, it doesn't need to be specified, it just needs to be specified that you folks want to appoint a hearing officer.
Thank you, Ms. Bowen. Yes, Member Hunker. Yes, Member Hunker. Your hand up.
Sorry. I would amend the motion to authorize the Chair Sweeney to work with NMED to identify a hearing officer.
Thank you, Member Hunker.
And
Yes,
if we
Member
need
Ely.
specific dates, hold the hearing on June 27th.
Okay. So for the record, Member Ely, would you just want to amend your motion for those two amendments?
So I move that we hear the petition as proposed by the department, and that the hearing be held on June 27th and June 28th as needed, and that Chair Sweeney work with the department to find an outside hearing officer for that hearing.
I'll second that motion.
Thank you, Member Ely and Vice Chair Trujillo. Looking for any further discussion, motion on the floor, none seen. Ms. Jones, would you please do a roll call vote on Member Ely's motion for setting the hearing date and a hearing officer?
Yes. Yes. Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
Motion passes.
Thank you, Ms. Jones. Appreciate the discussion, and thank you, Mr. Prince, and the guests for being here this morning for this request. And have a wonderful rest of the day. With that, we'll go to our next agenda item, which is EIB 23-56 joint public hearing with the Albuquerque Bernalillo County Air Quality Control Board in the matter of proposed amendment to 20.2.91 NMAC, new motor vehicle emission standards, NMADA, motion for stay. Armando de Garcia, motions for stay. We do have a number of attorneys here this morning for this item. And before we get to that, I did get a notification that the Albuquerque Bernalillo County Air Quality Control Board needed a logistical matter to address too as well. So I will turn it over to Chair Paul.
Thank you, Chair Sweeney. Wanted to make sure that we address an OMA issue that came up. I think I don't know that we have to go through maybe council can help me here. Do we have to go through our entire agenda, or is some of that supposed to be in parallel with what's already happened at EIB? So should we be calling for our own public comments and our own agenda items here, or can we just address the issue and then move on to the hearing?
I think that you should first call roll and see whether you have a quorum. And then
That's correct.
I think you should address the logistical issue first, because then and then go through the agenda.
Okay, great. So I'll call this March 22, 2024 special meeting of the Albuquerque Bernalillo County Air Quality Control Board to order. The time is 9:40 in the morning. Ms. Estiarmijo, would you please call the roll?
Good morning, Member Armijo.
Here.
Member Kalman.
Here.
Member Eberline. Absent. Member Galuski.
Here.
Vice Chair Richards.
Here.
Chair Paul.
Here.
Madam Chair,
So-
you have a quorum if 4 or more people are present.
Great. So we have a quorum. We can move forward. Our second item is approving this agenda for today. I'd like to add this additional issue. I'd like to put it first on the agenda. So can I have a motion to approve the agenda with the addition of addressing an OMA issue?
So moved.
Moved by Member Galuski. May I have a second?
I'll second. This
I
is Member
second.
I got Member Kalman first. Sorry, Member Armijo. On the second there. Assuming no further discussion, please raise your hand if so. We can move on to a roll call. Ms. Estiarmijo, would you please call the roll on approval of the agenda with that addition?
Member Armijo.
Yes.
Member Kalman.
Yes.
Member Eberline. Absent. Member Galuski.
Yes.
Vice Chair Richards.
Yes.
Chair Paul.
Yes. So I believe that's correct me if I'm wrong, 5 yeses, 0 no's, and 1 absence. So the amended agenda is approved. So now we can address this first new item. My understanding is our notice for this special meeting was about 2 hours late. That's just to the best of my knowledge. We don't have an exact timestamp on that. Council, do you want to expand on this issue?
Yes, Madam Chair. I'm not sure exactly how late it was because, well, as you know, I had sent out the wrong notice to the board the night before, or to Ms. Estiarmijo, and then she doesn't even start. She wasn't there, but she starts the day very early, and so she correctly found the right notice on, I believe, on the website for EIB. But my understanding, and I'm still not clear about the timing. My understanding is it did not go out by 9 a.m. And maybe due to the just delay in looking at the EIB, looking for the EIB thing. And then my understanding is the notice to the parties and the notice to the public went out. I mean, I got it at 11. And so I did some research, not exhaustive research. I did some quick research, and I didn't find a New Mexico case on substantial compliance. I did find other states that look at substantial compliance and excuse it, especially if there were just technical glitches. But in New Mexico, what it does have is it has the ability to cure. It very clearly, you can cure a problem with notice and by just republishing. And so, because this hearing is a unique joint hearing, my suggestion would be to go ahead and have this hearing, but not vote, but republish the notice. And then have a special meeting. You could have it, if the notice went out today, you could have it as early as Monday afternoon. Or we could also ask the hearing officer to decide whether that notice was sufficient and decide then whether you have, whether you want to decide today. It was a technical violation. It was not intentional. And when you read the cases, they really hate intentional violations. And, you know, that's basically where we are.
Thank you, Council.
I'm happy to answer any other questions.
Yeah, does anyone, any members of the board want to comment on this or have any thoughts? Open up the floor.
This is Member Armijo.
Go ahead.
I think we ought to just, as Antoinette suggested, is go ahead and let's hear the thing today. We don't have to decide whether we're going to vote on it right now or not, but we've got all these people sitting here waiting to hear this thing. And I think we ought to just get it over with. Thank you.
Thank you, Member Armijo. Anyone else on the board? Hearing no further comments. I agree that you know, it's strange for us to vote on our own issue. Perhaps Ms. Orth can make a determination as to whether or not we can proceed. But I also like this suggestion by council where we are here to listen, and maybe our vote comes separately later after a accurately published note or a timely notice. So that is what I'd like to hand to you, Hearing Officer Orth.
Thank you, Chair Paul. I'm going to decline to offer your board legal advice about the Good Meetings Act. I will note that there is complete identity of parties, witnesses, counsel, and issues to be decided in the motion for stay before the state board and the motion for stay before the city board. That's all I'll observe. There was, of course, timely notice for the state board. So I don't think there's any problem with hearing this morning, but I'll leave it to you all to decide whether you intend to vote later today or. So, is there anything else that the city board needs to do?
I think we just want to vote on whether or not we're going to vote now or perhaps at our next regularly scheduled meeting.
All right.
Is there a motion on that issue? I think that might be a way to solve this, is that our actual vote comes in our next meeting, which doesn't change the anyone's schedule, but we still get to hear all the arguments as they would be identical, as noted. Yeah, can I have a motion to that effect?
This is Member Armijo. I so move.
Thank you. Moved by Member Armijo.
Can I, this is Vice Chair Richards. I had a question for council. Are we, with this motion that we have to basically, I'm assuming, I'm not clear on the motion, is the motion to listen in and then vote at a regularly, a future special meeting? And if so, my question is, are we able to ask questions of parties during this meeting, or are we simply just listening and then voting at a future meeting?
Well, I would suggest that since you are going to make a decision, and if you have questions, that you go ahead and ask them. One of the things, one of the things that member Armijo suggested is waiting to decide when you're going to decide until after, because the vote by the EIB may influence whether you even need to have another meeting. You know, just depending on how it goes. So you may want to wait until after the hearing to decide when you're going to vote or whether you're going to vote.
Thank you for that information.
Do you
That's
have
all I
a
had.
competing motion? Vice Chair Richards, would you like to make a motion to not decide when we're going to vote, but know that we're not going to vote now? However you'd like to relay that.
No, I don't want to make a motion.
Okay, so we have a motion on the floor by member Armijo to delay the vote on this hearing until the next regularly scheduled meeting.
Madam Chair, the next
Yes.
regularly scheduled meeting is too late. You have to make a decision within 60 days, so
right.
you'd have to have a special meeting.
Thank you, Council. Okay, so that leaves us with special meeting in the next properly noticed before 72 hours of an undecided date as an option. Okay. Just to do the vote. So
Shall I
is there a
amend my motion?
Great.
Okay, I move that we go ahead and hear the evidence presented today, set a special meeting, and have a vote on the issues before us at the special meeting.
Great. Would anyone like to make a second or competing motion that says we will wait to decide? As Council reiterated, there may be if EIB does decide to do a stay, sort of our question whether or not we would decide to do a stay is moot because there would be a stay statewide. So okay. I will second your motion. Remember how move this along. Are there any comments or discussion? Okay, Ms. Esther-Mijo, would you please call the roll?
Member Armijo,
Yes.
Member Kalman,
Yes.
Member Eberline, absent. Member Galuski,
Yes.
Vice Chair Richards,
Yes.
Chair Paul.
Yes. All right, the motion passes 5 yes, 1 absent, 0 no's. So we will not vote today, but we will have another special meeting within the 60 days to actually decide on this matter. And thank you so much for your patience. I think we can hand it back over to the hearing officer, Felicia Orth, to continue the joint hearing.
Thank you very much, Chair Paul. My name is Felicia Orth, hearing officer appointed by both the Environmental Improvement Board and the Albuquerque-Bernalillo County Air Quality Control Board to conduct a hearing in this matter, which is 2 motions for stay in EIB 23-56 and AQCB 2023-01, both related to new motor vehicle emission standards. The motions for stay were filed by Automundo Garcia and the New Mexico Automotive Dealer Association. There were joint see, motions filed at the end of February. Joint responses came from the New Mexico Environment Department and the Advocate. Joint reply then was filed by Automundo de Garcia and New Mexico Auto Dealer. Hearing was set for today, March 22nd, again, as part of the EIB's already scheduled meeting. I met with council and Mr. Maxwell on a virtual platform and issued an order, procedural order, to try to proceed through the arguments and evidence on the motions for stay expeditiously. As part of that order, the parties each have 15 minutes for opening argument, 15 minutes for closing argument, right? And 1 hour each for the witnesses, all of whom had to be noticed up earlier this week with their testimony and full narrative. The rest of the board members have reviewed all of that for coming here. 3 witnesses from the movements, 4 witnesses from the climate advocates, 3 witnesses from the Environment Department. They each have 15 minutes to summarize their testimony, and we will proceed from there. There was also another order issued around Ortiz exhibit number 14, which will be offered as part of Mr. Ortiz's testimony. Testimony will be taken under oath, subject to cross-examination pursuant to both boards' procedural rules. We'll ask counsel to exercise restraint in your cross-examination. Again, so that we can get through this matter today. So, move-ins. Would you like to offer your opening statement? Well, let me ask for appearances first, and then invite opening statements. Mr. Domenici?
Mr. Domenici, I think you have to push the button.
Good morning, Madam Chairs of both boards, members, Madam Hearing Officer. I represent both movements, Automundo Garcia and the New Mexico Auto Dealers, on the motion for stay.
Thank you. Mr. Knight? Thank you. And going forward, Mr. Knight, we have to ask you to speak into the microphone. Otherwise, the folks on the platform cannot hear you. All right. All right. Mr. Bach.
Thank you, Madam Hearing Officer. Chair Sweeney, Chair Paul, members of both boards. David Bach, representing the climate advocates. Co-counsel Carly DeSalen. Carly, would you like to? Or Coalition for Clean Affordable Energy.
Thank you very much, Mr. Bach. And I believe I saw Mr. Maxwell on the platform. Mr. Maxwell?
Nicholas Maxwell, for the record. Thank you, Your Honor.
Thank you. All right, Mr. Domenici, if you would like to offer your opening statement, and you will see me using my cell phone here as a timer.
Thank you, Madam Hearing officer, I've given an abbreviated version of this argument to the Air Board. But since this is the sort of the formal record, I'm going to go back. I apologize to the Air Board if some of what I'm saying is repetitive. My clients have a statutory right to request a stay under the Air Quality Act, and it's more than a right, it's an obligation. So if we want to stay any part of this regulation, we have to go in front of both of the boards that issued the regulation to request that stay. If that is denied, we have a right then to ask the Court of Appeals for a stay. So we are following our statutory right and frankly, our statutory obligation. There is a well-founded purpose as to why stay motions like this are allowed. They're put in statute, recognized by the legislature. They're part of the administrative process of rulemaking. They're also used in other circumstances, but I'll focus just on this rulemaking. And the basic purpose is to give the appeal time to be determined before the parties affected by the rule suffer irreparable harm. And they what the courts have done is set up a balancing test or a test, so they don't say every rule automatically is stayed. They could have done that as a legislature and said the board passes the rule, but then it doesn't take effect until the appeals are finished. But they chose not to do that. So some rules certainly do take effect and don't meet the burden that I have to establish for my clients. I have to establish good cause for you to issue a stay. I also am allowed to ask for a very defined stay, a restricted stay. So I have to ask that everything you decided be stayed. And we are asking for only a very narrow relief. And in fact, the EIB board rules require that we submit a proposed order when we file a motion like this, so that we actually have an order that sets out what we are specifically asking for. And in essence, we are asking only that the ZEV portions of ACC2 be stayed until the Court of Appeal has a chance to hear my client's appeal. We are not asking you to reverse your decision and to say we made a mistake. That's not our burden. And of course, if that was our burden, then we wouldn't have any possibility of success because you already made a decision. We need to show that we have a likelihood of success. That's been interpreted to indicate that we don't have a frivolous appeal, that we have some merit to our appeal. And I'm going to sort of jump ahead and indicate the reason that we are, and then we also have to show irreparable harm is a possibility if the rule takes effect and is not stayed. And the circumstance that we are extremely concerned about is that a rule of this nature, which we have, Bill, and I'll describe several very key appellate issues, will take effect, and the manufacturer mandate of delivering 43% electric vehicles or ZEV vehicles by model year 2027 will actually be occurring while this appeal is still pending. If that takes place, and this is testimony from Carlos Garcia, he will indicate that he's already put this in his written testimony. Model 2025 models are arriving now. One of the parties indicated that they look at Garcia's website. They have 10 Model 25 models currently, but they will extremely rapidly receive 2025 vehicles. The same will happen in 2027. So in the spring of 2027, 2 years from now, 2027 vehicles will be delivered. And under this regulation, and we understand there's a system for credits, taking into account credits, which might provide some benefit, there will be an enormous shift of what's been occurring and what we think the market supports. Manufacturers will have to deliver 43% ZEV vehicles to all of the dealers in New Mexico for that model year 2020. What Carlos Garcia says is if that occurs and then your regulation is overturned by the Court of Appeals, it will take years to recalibrate to correct the market conditions. Those vehicles will have arrived on lots that are unable to sell them. There will be financing attached to those vehicles that will place those dealerships in extreme financial hardship. The manufacturers will have had to gear up and allocate those kind of units to New Mexico for their model year 2027. And all of that could occur while this appeal is pending. So we are not asking you to stay several portions of this rule that have been indicated and we haven't disputed will provide significant benefits. The ACT portion, the NOx portion, we're not asking to have any effect whatsoever on that. We also think that the credit portion of this rule can continue as it is anyways. Manufacturers always record their sales and they would be able to come in and apply for the credits, whether it's after this appeal is decided or during the pendency of this appeal. If the appeal is decided favorably to the petitioners. So the credit portion of this, we don't think will be affected. What will be affected is there may be multiple valuable vehicles delivered, expensive vehicles delivered that will not have a market for them in the spring of 2027, 2 years from where we are. And you have the ability to stay that obligation while the Court of Appeals hears the decision. We filed our docketing statement yesterday. And that's sort of one way to identify what we think are the likely issues we have a likelihood of success on. Our first issue we mention is we don't think that either of these boards received the right advice and performed the right analysis as to how the equivalency requirement or identicality requirement of Section 177 of the Clean Air Act applies. You were told that once California adopted Clean Cars 2, Clean Cars 1 would not be in effect in New Mexico. That is simply incorrect. More importantly, you were told that you did not have the ability to divide out ACC2 from ACT and HDO, or those three components. Those are three separate regulations being promulgated through California. Completely different regulations. They all have separate waiver requests to the EPA. We ask that you look at the evidence and determine that the evidence did not support Clean Cars 2. And we informed you that much of the benefits you've been heard about applied to the other portions of the regulations that we were not challenging. You were told you could not separate out those three actually completely separate, unrelated regulations and had to vote on all three as a block. That was how you were informed, and that's how you voted. That is incorrect. And we think the Court of Appeals will indicate that when a rulemaking occurs, you are allowed to go into that rule and adopt portions of it and reject portions of it. You were allowed to reject the ACC2 portion and adopt the others. In fact, there was no evidence opposing the others, so you certainly would have. The climate advocates actually thought the same thing and requested that. In their closing argument, they thought the exact same analysis and requested that take place. You were told you couldn't do that. You were not allowed to vote separately on ACC2. We think we have a likelihood of success on that issue. Now, I'm just going to very briefly summarize the evidence you're going to hear today. And you're going to hear a lot of evidence that sort of carries forward from what we heard at the hearing. Questions about how electric vehicle marketplace is performing, questions about how manufacturers are performing, and infrastructure. Frankly, none of those really matter, in our view, anywhere close to the issue of will there be irreparable harm? Can we establish irreparable harm? There is simply nothing to show that there will be a demand for 43% electric. The most telling evidence of that is what the US EPA did 2 days ago. This was mentioned in the testimony of the climate advocates. On March 19th, the EPA rolled back their target, which was 60% electric vehicles in 2030. Our target, or your requirement, it's not a target, is 68%. But the EPA was their proposed rule was even less than that. They rolled that back to between 31 and 44% is now the current federal rule for 2030. Your rule is 68%. So the EPA, the federal rule, which came out 2 days ago and looked at all of the same elements you're asking to be looked at, indicated that what you're trying to do is about twice as aggressive as the federal government is willing to try to mandate. And they provide more flexibility in that. It is not a manufacturer requirement, it's an emissions requirement, but they clearly indicated that they heard that 60% was too aggressive. They heard that the manufacturers did not believe the market was there, that the market isn't there, and they rolled this back significantly. Our dealers are going to show the same thing. They're going to show the market. Our testimonies show the market has been flat. We've only been 4 months since we were here before, but it's remained flat. Yes, some of the infrastructure is moving forward as expected. That infrastructure may support the numbers like the EPA has proposed, may support something quite short of what you are mandating, but it's going to be helpful. So we're not going to dispute that some infrastructure is going in. It's not sufficient, and it's not going to change the needle anywhere near enough that there will be no irreparable harm if my clients all have 43% ZEV vehicles in 2 years from now. The market is supporting 8%, 10%, and this regulation remains on appeal, and 6 months later or 9 months later, it gets reversed. And my clients have already had to have those vehicles sit on their lots, sell their ICE vehicles, not be able to replace those, have to lay off employees, close businesses, default on loans, all of those aspects. This is a conservative, cautious, middle ground, narrowly focused, that allows everything you're trying to accomplish to continue, all of the infrastructure efforts to continue, but protects from this potentially irreparable circumstance that the appeal is successful, but the damage is already done. So in light of that guidance, that opportunity, frankly, for you to take a narrow view and eliminate one of the potentially harmful impacts of this rule while allowing virtually a huge part of it to proceed and allowing the infrastructure to continue to be built up, allowing people's knowledge and comfort with electric vehicles to continue. All of that can continue. What we're asking is for you to stay this potentially irreparable effect while the appeal is pending. Thank you very much.
Thank you very much, Mr. Domenici. Mr. Maxwell, I'm not sure if you have testimony you'll be offering later, but let me ask you if you had any kind of opening statement prepared apart from the testimony to add to Mr. Domenici.
Yes, Your Honor.
Okay, please go ahead.
Ladies and gentlemen of the boards, today, an intervener, I address a matter of ethical integrity that underpins the validity of these proceedings. The crux of my concern is the involvement of Member Ely's spouse with Western Resource Advocates, notably as a lawyer and a lobbyist. This association, extending beyond her stated end of his employment in 2022, raises substantial questions about potential conflicts of interest, directly challenging the impartiality expected in the state's regulatory deliberations. Our decision-making process, especially in cases as pivotal as the Advanced Clean Cars 2 regulation, determined, I remind you, by a slim margin, where each vote, decisively including member Ely's, was critical. And it must be beyond reproach. The rules governing our conduct clearly mandate recusal in situations where impartiality might reasonably be questioned, a directive underscored by 20.1.1.111 NMAC. The oversight in addressing this conflict not only challenges the ethical framework guiding us, but also beckons the scrutiny of the New Mexico State Ethics Commission. It is essential that our actions reflect not just regulatory compliance, but also a steadfast commitment to ethical governance. Thank you.
Thank you, Mr. Maxwell. Mr. Knight? That's fine. Mr. Bach, you have the same choice. Alrighty, thank you.
Before I begin, I know my witnesses had the same question. Are we going to be able to see the members who are not? I don't need it for the opening argument, but I know witnesses would like to see, if there's questions.
So at one point, I had thought that the staff indicated that the screen could be cast to these additional screens up in the ceiling. Pam, would you be willing to ask them if they could do that? Okay. While she works on that, though, why don't you go ahead?
Yes. Thank you very much. Madam Hearing Officer, Chair Sweeney, Chair Paul, and members of the board, both boards, David Bach on behalf of the Climate Advocates. With me today is my co-counsel, Charlie DeSalen. Also with me are Climate Advocates technical witnesses, Kathy Harris from Natural Resources Defense Council, Aaron Kressig and Deborah Kapoloff from the Western Resources Advocates, and David Bradley from Magpie Motors in Albuquerque. It is important to remember why we are here today. We are here to consider motions to stay the Advanced Clean Cars 2 regulation, pending a ruling dealer's appeal. We are not here to reconsider the decision to adopt the rule in the first place. In November, we had 4 exhaustive days of technical testimony, public comment. The Environment Department and Climate Advocates submitted thousands of pages of detailed analysis showing that the rule would deliver immense benefits for New Mexico, saving lives, reducing costs to consumers, helping avoid devastating climate change. The boards voted to adopt the rule, finding that it was in the public interest to do so. The dealers haven't asked to reopen that decision, and it would be improper to do so. Rule changes must go through a stakeholder process that allows all interested parties an opportunity to participate. That's not happening today. Members of the public are not being permitted to comment at this hearing. We have dozens of members who would like to voice their continued support of the rule, but are not allowed to speak today. So that just kind of underscores the importance of not relitigating the merits of the rule this time. And that's not what the dealers have asked us to do. Even though their testimony talks a lot about why they disagree with the rule, wish it hadn't been adopted in the first place, what they are asking for is a temporary stay while the Court of Appeals considers their appeal. Because we are here on a stay motion, the dealers bear the burden of proof. They must show that each of 4 equitable factors supports granting a stay. Those factors are a likelihood that they will succeed on their appeal, irreparable harm or the appeal can be decided, that a stay will not substantially harm other persons, and that a stay is in the public interest. New Mexico law is clear that if any of these factors is missing, the motion fails. It's very difficult to prove all 4 factors, which is why stay motions are rarely granted. The dealers have to prove all 4 of these factors, but in fact, they can't prove any of them. Let's start with the likelihood of success. The dealers certainly have not shown that they are going to win their appeal. Court of Appeals is very deferential to agencies like the boards here in reviewing regulations. As best I can tell, the New Mexico Court of Appeals has never set aside an EIB air quality regulation before. The dealers haven't identified any legal error in the rulemaking occurred. Their main argument seems to be that the board adopted the rule based on an incorrect interpretation of the Federal Clean Air Act. But that is just a complete mischaracterization of what happened in November. No one in November ever said that the EIB and the Albuquerque Bernalillo board were legally required to adopt Advanced Clean Cars 2. Nor does the evidence show that the boards voted to adopt the rule based on a misunderstanding about how the 3 rules work together. The evidence is very clear. Both boards voted to adopt Advanced Clean Cars 2 because the weight of the evidence showed that this rule delivered important benefits to the state and Bernalillo County. But this argument is not likely to prevail. Beyond this mischaracterization, the dealers argue that the record does not show that the rule is technologically achievable or economically reasonable. There is ample evidence in the record that supports the board's findings that the rule is both achievable and likely to deliver substantial economic benefits to New Mexico. For example, climate advocates presented evidence that companies like General Motors, Volvo have committed to transition to 100% EVs by 2035 or even earlier. Countries in the European Union have seen dramatic increases in EV sales in just a few years. Fully 80% of new electric car sales in Norway now. EV sales are growing rapidly across the United States as well. So the evidence shows that a rapid transition to EVs is not only achievable, but being achieved. As to economic reasonableness, climate advocates presented evidence that EV costs are falling rapidly. With federal incentives in the Inflation Reduction Act, new EVs are projected to be cheaper than new gas vehicles by model year 2027 when the rule takes effect. The evidence also shows that an EV owner may save about $17,000 in fuel and maintenance costs over the lifetime of a vehicle. There is ample evidence in the record that the rule is achievable and economically reasonable, and the Court of Appeals will not second guess the board's decision to credit that evidence. On the second factor, the dealers have not shown the likelihood of irreparable harm. We don't know exactly when the appeal will be decided, but the dealers could ask the Court of Appeals to expedite consideration of the appeal, and I don't think any of the parties supporting the rule would oppose that. If the Court of Appeals decided to expedite the case, there's no reason they couldn't decide the appeal this year. Certainly, they could have decided before the end of next year. The dealers fail to even articulate, much less explain, why a rule that applies to vehicles in model year 2027, which won't go on sale until 2026, will affect them at all in 2024 or 2025 while the appeal is being decided. Even when the rule does go into effect, there is no concrete evidence that the dealers will suffer irreparable harm. Dealers speculate that they will have trouble selling EVs in model year 2027, but that is just speculation. The world will be a very different place by the time these vehicles start showing up in New Mexico. We heard extensive testimony in November that EV technology is improving every day. EVs are becoming more affordable, range is improving, the charging network in Mexico is rapidly being built out. There's plenty of time for the dealers to adapt to the changing market before these vehicles come to New Mexico in 2026 and 2027. So there's no showing whatsoever of irreparable harm in the short term. All the dealers have is speculation that they may have difficulty several years from now after the appeal is likely to already have been decided. That doesn't come close to the burden of showing irreparable harm. Finally, the public interest and the interest of the other parties weigh strongly against granting a stay. As Claudia Borchert from the department will explain, automakers are already taking advantage of the voluntary early action credit program. That is something that everyone should be happy about. It means we're getting more EVs to New Mexico.
Did not.
We heard a lot of public comment at the hearing about how many New Mexican consumers are having to leave the state to purchase an EV. The early action program will keep that business in the state.
Notice said the
Entities that
hearing
choose to participate.
would be an hour. Some of our.
Sorry, hold on, Mr. Bach. We're hearing something, Chair Paul, sounds like you weren't muted. Go ahead, Mr. Bach.
Can I have a time check? I think
No, I was on mute.
You have 6 minutes.
Oh, okay. I don't need that. Early action credits mean that it's easier for manufacturers to apply in model year 2027. If a stay were granted, the primary real world impact would be to disrupt the efforts of companies that want to voluntarily get ahead of the game. Now, I heard Mr. Domenici say that they're not trying to block the early action program, but it's unclear how a stay, if a stay doesn't interfere with that, it's unclear what the impact the stay would have. It certainly is going to cause confusion for entities that are trying to get ahead of the game. And it's going to undermine the certainty that the manufacturers have expressed that they in knowing where to deliver their vehicles. All of this is going to mean that the significant environmental and public health benefits of the rule could be delayed or disrupted. All of these negatives clearly outweigh the dealers' speculative concerns. So to recap, the dealers need to show 4 things. They need to show that they are likely to win their appeal, even though that would be unprecedented. EIB's decision was supported by volumes of evidence, and firmly grounded in the agency's authority. Second, they need to show irreparable harm that will be decided that will happen before the appeal can be decided, which they cannot do, because the vehicles subject to this regulation won't go on sale until 2026, and the appeal can certainly be decided before. Even in 2026, there's no reason the dealer should be harmed. There's plenty of time for them to adapt to the changing marketplace and continue to drive and sell vehicles in Mexico. Third and fourth, dealers need to show that a stay would not harm other interested parties and that the public interest supports a stay. Neither factor can be established. Stay would be disruptive, cause confusion, and potentially complicate voluntary early action compliance. That might mean fewer New Mexicans able to purchase an EV in the state, delaying or at least frustrating the tremendous public health and environmental benefits of the EV transition. For those reasons, we urge the boards to deny the stay motion. Thank you so much.
Thank you, Mr. Bach. Some of us have been at the dais for about 2 hours now. So let's take a 15-minute break and come back at 10:40. Please. All right, when we broke for a short break, we had finished the opening statements other than departments, which is reserved. So we'll turn now to the move-ins for the presentation of their witnesses and exhibits. Mr. Domenici.
Madam Hearing Officer, I have one short preliminary matter before we put our witnesses on. In that I understand the court's ruling was there's no rebuttal testimony, but there was quite a bit of direct rebuttal of my client's testimony in the testimony that was filed on Wednesday. So I would request that so long as my clients stay within their 15 minutes, that after they give their direct testimony, they'll be allowed a couple of minutes to respond to statements that have been made about their testimony.
I see. All right. Does anyone want to argue this, or can we just agree to that? You want to argue this? You do not want to argue this. Climate advocates want to argue this. I'm intent on keeping them in their time, certainly. He's going to keep it in the same 15 minutes. So, yes,
Oh.
Mr. Domenici.
Thank you, Madam Hearing Officer. We will call Ken Ortiz.
All righty, Mr. Ortiz, if you would raise your right hand, do you swear to tell the truth? Thank you.
Please introduce yourself to the boards.
I'm sorry, hold on. I'm very sorry to interrupt. Chair Paul, you have a question?
Thank you, Hearing Officer Orth. Really quickly, I just wanted to make sure that this meeting will be recorded so that members of the Air Quality Control Board, if they have to leave and come back, they will be able to review the recording so that we can all,
Yes,
make sure that-
absolutely. I
Okay,
spoke with the Environmental Improvement Board's administrator, Pam Jones, and she has assured me that she has already said that she would, as soon as the WebEx recording was available to her, she would share it with your board administrator, Ms. Esty Armijo.
Thank you so much. Thank you for addressing that question. That's all I had.
Sorry, Mr. Domenici, go ahead.
Please introduce yourself, sir.
My name is Ken Ortiz. I'm the Executive Director of the New Mexico Auto Dealers Association, and I just want to thank you for the opportunity to be here.
Go ahead with summarize your testimony.
Sure. Thank you. So once again, thank you for the opportunity. I want to start off by maybe doing a little bit of a reset based on the testimony submitted by our opponents. I felt, and I was pretty disappointed in reading the testimony where they're trying to portray our dealers and our association as in fact, our dealers are investing hundreds of thousands of dollars across the state for the installation of EV infrastructure, the tools, the training. We're being prepared. We see EVs as part of the transportation pie, definitely not the end all be all because of Mexico's unique circumstances and transportation needs. But what we're talking about and what you all should be focusing on is emissions controls. And one of the glaring weaknesses in the proposed rules is allowing New Mexicans to leave the state, often traveling hundreds of miles, purchase a vehicle of choice, and bringing it back to New Mexico. How is that controlling emissions? What we're doing is forcing New Mexicans to leave the state, possibly spend more money traveling, purchasing vehicles out of the state losing tax revenue, dealerships basically losing business to out-of-state dealers, and yet they're employing thousands of New Mexicans. Another common misperception is that we are not supportive with all the great work that's been going on with the transition to electric vehicles. We have a great working relationship with a public service company in Mexico. They're working with us to basically train sales staff, getting the infrastructure in place, etc. We're all working together collectively as it should be done. But what you all have been presented is speculative data, anecdotal data, often data from outside of New Mexico. And we're not taking into effect, the real circumstance. Shortly after the session, or after the hearing, I'm sorry, we heard from several legislators where they were asking us, hey, we're hearing from the Navajo Nation, and they have no idea what's going on. They have not been communicated. Can you meet with them and at least try to explain the rule and the potential impacts? So we had an opportunity to visit with President Dr. Lou Nygren with the Navajo Nation. And, one of the first things he said is like, me or my team have not heard about this. Why haven't they come to us? What does this rule mean? So as we explained, the 43% in year one, increasing year after year, he indicated, my main focus, if you will, is infrastructure as it pertains to water, electricity, broadband, paved roads. He goes, A lot of my members of my people have to travel hours and hours every week with vehicles loaded with supplies, with food, with water, traveling over unpaved roads. He goes, how does this help us? You know, he goes, and one of the things that we were stating during the hearing is that by limiting the choice, of vehicles, New Mexicans basically in their purchase of vehicles has three opportunities. They can special order a vehicle, for example. They can leave out of state and buy the vehicle of choice or opt for a slightly used vehicle. So if more and more used vehicles are in demand because of limiting of choice, what does that do? It raises the price of used vehicles. So quoting, Dr. Nygren, he says, this rule is forcing my people to keep older, dirtier vehicles on the road. How is that helping emissions?
Let me interrupt you. Let me ask you to look at Exhibit 14. Do you recognize that as a letter from the Navajo Nation, Dr. Boo Nygren?
Yes.
Describe to the board how that letter came to be from your understanding.
So after the conversation with some of our dealers, he was very, very concerned and wanted to reach out to the governor of his concerns. So the letter that is filed within testimony is a letter from Dr. Nygren expressing his concerns on the proposed rules and offering, like we all are, to work together for the transition.
And is it your understanding that that states the official position and concerns of the Navajo Nation?
Absolutely. They were very interested in submitting comments to the board for consideration on their views. Unfortunately, the hearing order did not allow public comments. So we were able to, with the permission of President Nygren, to include this in the testimony.
Can you describe what you have seen as the executive director with data from dealers to the electric vehicle market since the hearing? And if you want to refer to your exhibit, please do.
Sure. So what we have been doing is we've been following motor vehicle division data from the state of New Mexico. And some of the data that I present, even though it's described in the testimony, is cherry picked. It's data. Data is data. And what that data is basically new vehicles sold that were titled and registered with the New Mexico Motor Vehicle. How accurate more of a picture than. So the data that we show, we started tracking in January 1st of 22 all the way through current. And what that data shows is that the electric vehicle new car market, vehicles sold, we're tracking EVs, we're tracking plug-in hybrids, we're tracking regular, even though regular hybrids are. And what we're seeing is that EV market penetration, if you will, has been less than 4% for the last 25 months, except for 2 months. We had 2 months that were over 4% in September and October of 2023, but yet it's declined to an average of about 3.6 since then. A lot of my testimony that was included, or some of my testimony that was included that's before you, is various different articles from national publications related to what we were mentioning in November, is that the EV market has flattened a bit, has been not moving forward to the projection that we all thought it would maybe a couple of years ago. And, our biggest concern, or one of our biggest concerns, is that at 4%, and in less than 2 years, we're looking at 43%. You all have implemented a mandate that is going to expect or hope that the EV market is going to increase by 1,000% in just 2 years. I'm not sure how it's possible. So one of our recommendations is we should let the market work naturally. We see EVs as part of the transportation future. we see technology ever increasing as far as range. We see DOT's work and other private businesses work in installing electric vehicle charging stations. And as all of that comes together, including the dealer's work in providing electric vehicles, in training, all of that is going to work naturally, if you will, and not have some mandate that is imposed that ultimately hurts New Mexicans. Since the hearing, we've seen 2 states try to implement the rules and their regulatory bodies fail to pass it. And that is most recently Maine, and prior to that, our council here, elaborated and provided information of what President Biden did in the last couple of days. Another point that's not being mentioned is ACC2 has still not been approved by the EPA. And now we have doubts with what has occurred over the last couple of days. Will they even certify this? The Clean Air Act and some of the thoughts behind it and case law behind it is that emissions should be at a federal standard, and it makes it easier for manufacturers where we all are working together on climate change. But being able to leave the state and buying a regular vehicle and bringing it back in doesn't make sense. You're hurting New Mexicans, hurting businesses, hurting jobs, and that's our main concern in our request for state. That's the irreparable.
Let me ask you to focus on 2 pieces of data. So look at your Exhibit 1, please, which is your bar chart of sales.
Okay.
And I'd like you to just focus on the November and the January data. I'm not sure if we had the November data at our hearing. Do you recall?
No, the data that we receive is probably 4 to 6 weeks behind from what we get from MVD.
So you have 2 new points of data since the hearing.
Yes.
And you label those as November 23 and January 24 in Ortiz Exhibit 1. Please identify what those show as far as any kind of upward trend or downward trend or anything else.
Sure. So jumping back to September 23, which is about the latest data that we had prior at the November hearing, we saw through motor vehicle division data here in New Mexico that the EV market share was 4.4% and the plug-in hybrid market share was 1.8%. 2 months later, in November 23, the EV market rate decreased from 4.4 to 3.53, while the plug-in hybrid increased from 1.08 to 1.61. And then in January, it pretty much stayed flat from 3.53 in November of 23 to 3.65 in January of 24. Meanwhile, the plug-in hybrid decreased a bit from 1.61 to 1.37 respectively.
And the other information I'd like you to share is what happened in the legislature with respect to incentives for purchase of electric vehicles?
Sure. So during the 2024 legislative session, there was a bill that was introduced on both the House and the Senate side that provided some EV tax credits for the purchase of qualifying EVs and plug-in hybrids. Like to state that, first of all, we are disappointed because in our discussions, even before the hearing, we were told that we were going to be provided a draft of the bill and they wanted our input. Well, none of that came to be. So the bills were introduced, and when we saw the bill and we heard some of the testimony, it was being billed in committee hearing, testified that it was a cash on the hood incentive, and it's not. Cash on the hood incentive is an incentive where the dealers can offer a discount at the point of sale or at the time of purchase. What this bill requires is that in order to receive a certificate of tax credit from the Energy, Minerals, and Natural Resources, a consumer has to provide proof of purchase or proof of lease, along with registration in New Mexico or application for title and registration. It's basically a form right before it gets titled and registered. After those two documents are submitted to the Energy, Mineral, and Natural Resources, they will issue a certificate of tax credit back to the consumer. That tax credit does become transferable. However, that is several weeks after the sale. In visiting with our dealers on the makeup of this bill, basically all the dealers said, we'll never accept that, because that, how are we supposed to give a discount at the time of sale and hope that their customer is going to apply for that EV tax credit certificate, hope that they're going to come back to us? And then all that does for us is it offsets tax liability when we file our taxes. Unlike the federal program under the Inflation Reduction Act, that dealer can offer the $3,750 or $7,500 discount at the time of sale because IRS has developed a portal where the dealer would enter vehicle-specific information, customer-specific information, and a check would be issued from the Department of Treasury back to the dealer within 48 to 72 hours. We met with the sponsor of the bill. We met with Tax and Rev to understand that Taxation Revenue Department to make sure our understanding was correct. It was correct, but they didn't want to. They weren't interested in making any amendments to really work as a true cash on the. So we feel it's going to be underutilized. It is going to be utilized for sure if a person files it and offsets their tax liability at the end of the year. But to us, does it incentivize the purchase of EVs? We're highly skeptical.
Mr. Domenici, please wrap up.
This will be my last question. What's the amount of
the tax credit? It starts at $3,000 for the qualifying EV or plug-in hybrid, and that's for the purchase price of $55,000 or less. It is in place for about 2.5 years. It becomes effective May 15th for tax year 2024, and it expires 2.5 years later. The next year, it offers about half of that amount, and then the last year, it offers another half of that amount, and then it sunsets after about 4 years.
I have nothing further. This witness.
Okay, thank you. Let me ask, there's cross-examination. Hold on, Mr. Ortiz, by Mr. Maxwell.
Your Honor, I have no cross-examination.
All right, thank you. Mr. Knight? Thank you. Questions, Mr. Bach? All right. Thank you very much, Mr. Ortiz.
Could we see if the board has any questions?
Oh,
for the board.
I think I did this last time as well. Let me ask those in the room first this time. Member Ely?
And Mr. Ortiz, I hope you can answer this question. It's kind of related to Mr. Domenici's opening regarding the focus of stay. It's really centered on ZEVs and not full rule. And I'm sorry I missed that in your filing. I did not see that. Specifically, which section of the rule do you want stay? Or sections?
I don't have the section citation number to answer your question, but I'm hoping. So it looks like section 20.2.91 NMAC to 20. I'm sorry, it's 20.2.91.108 through 20.2.91.10.
So you are proposing, I think 109 is the early act. So you are proposing to stay the early act portion of part 90.
That's correct. It can certainly be implemented voluntarily by all the dealers, but it's part and parcel of the portion of AC2 we're asking to be stayed.
Thanks for explaining that.
Thank you. Vice Chair Trujillo.
Apologies, I got off here looking for that citation. I had a question about the sources that you use when you're pulling data. I was just curious if you ever use the source Evaluate New Mexico Atlas tool.
Member Chair, Vice Chair Trujillo, I'm aware of that and we look at that, but our data is through the originator is New Mexico Motor Vehicle Division, and there's a third-party administrator that a lot of state associations use, including the state of California. That vendor's name is CrossSell, and they receive their data from various states, and they provide access to a tool that allows us to run reports of various different needs, and that's what we use for my chart and my data.
Okay, thank you very much. And just for my clarification while I review the information, I was wondering if Mr. Domenici could write down the sections that were wanted to specifically look at, so I make sure I look at them correctly.
We filed a proposed order, excuse me. I looked on the docket. I'm not sure on the docket or not.
Yes, and I apologize. I've got like a
But,
whole bunch of windows here up with
But,
Vice Chair Trujillo, it is on the exhibit, the Automundo de Garcia and New Mexico Automotive Dealers Association Joint Consolidated Reply.
Okay, thank you. I do have that one open as well. Okay, thank you.
I'll say both.
Thank you, Chair Sweeney. Question?
No, I don't. Sorry.
Member Garcia.
I have a question. I always thought that model years out. What I'm reading in the testimony is that did I hear model year 2025 is already showing up?
Madam Chair, Member Garcia, yes. In fact, so I would say depending on the manufacturer, and there's different times during the preceding year that the next year model comes available. But what I've seen so far this year is that dealerships already have model year 2025 vehicles on their lot available for sale, and it is in March preceding year. So I defer to our dealers that will be testifying how early they get, but my thought is somewhere in the February to early March timeframe, dealerships are starting to receive the next model year's inventory available for sale.
Thank you. All right, thank you. Let's go to the board members on the platform. Member Bitzer.
I have no questions, no further questions. Thank you.
All right, thank you. Member Honker.
I have no questions.
All right, thank you. Now let's turn to the Albuquerque board. Chair Paul, I see you on the screen.
I have no questions. Sounds like other board members do.
Yes, all right. Let's go. Let's go to, I think your vice chair was Richards, right? Ms. Richard, Vice Chair Richards,
I have no questions. Thank you.
right? Member Galuski,
No questions. Thank you.
okay. Member Armijo,
No questions.
Member Coleman, may have stepped away. Okay, is there anyone that I missed on the Albuquerque board who has a question? No, all right. Thank you very much, Mr. Ortiz.
We'll call our next witness, Terry Garcia.
Ms. Garcia, if you would raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you.
Ms. Garcia, will you reintroduce yourself to the board?
Yes. Madam Hearing Officer, boards, members of the board, my name is Terry Garcia. I'm an automotive dealer in Gallup, New Mexico, which is rural in the Four Corners, borders the largest border city on the Navajo Nation. I have a Chevrolet, a Toyota, a Chrysler, Dodge, Jeep, and Ram store. We've been in business for 42 years. I've been the dealer principal for about 5 now, executive manager, general manager, finance representative, pretty much anything and everything. Round up. I was 6 years old when we opened it, so child labor law didn't really. I did a lot of odd jobs.
And you summarize your testimony for the boards.
To summarize the testimony, first off, we are not opposed to tailpipe emission reduction. Being born and raised in rural New Mexico, unfortunately, this mandate has forgotten anybody outside of the I-25. So what I'm concerned with is that recently adopted advanced clean car rules will cause irreparable harm throughout New Mexico, and especially in the rural and tribal areas of our state. I have firsthand knowledge of many of these challenges to my customers who live in rural New Mexico and or on tribal land on a day-to-day basis. My customers, my employees, myself, we've got 150 miles in any direction except south, because there's no facilities in Zuni, and that's 38 miles south. It's 165 to Flagstaff, 147 to Farmington, and 150 to Albuquerque for any medical, airport, shopping, big box retailers, hospital. I mean, our hospital's on the verge of closing. But for rural New Mexico, mileage is a huge issue. And being a rural dealer, I've got customers, I've got employees that drive from Farmington, New Mexico to work for me in Gallup, New Mexico. I have 4 of them. I've got employees that drive from Ganado, Arizona, from Kayenta, Arizona. I don't know if you understand, Kayenta is 96 miles from Gallup. Ganado is 60 miles. I've got employees that drive from Window Rock, Salee, Sheep Springs, Rama, Finns Lake, Zuni, that come to Gallup to work. That's just employed with me. We've got students that travel these same distances daily with their parents on those roads. One of the main obstacles that we see in rural New Mexico is range anxiety. And your manufacturers are going to tell you, and I'll tell you right now, the Silverado, they're touting it's 400 miles. That's with no electronics on in the vehicle, and that's at sea level. Gallup is at 8,100, we're at 6,500 feet, 81 areas. That range automatically is going to be cut by 35 to 40%. So without the infrastructure available, especially on the Navajo Nation, 27,000 square miles is the Navajo Nation that surrounds my rural part of New Mexico. There is the infrastructure out there. I did meet, it was testified to in November that the Navajo Nation was talked to. Well, the Navajo Nation president, Dr. Bunai, I reached out to him through his chief of staff, Alvin Trujillo. He's so adamant and worried about this. He drove from Window Rock, Arizona, left at 4 o'clock in the morning to meet with me and Mr. Garcia to discuss this. He's in absolute opposition, wrote a letter to the governor, and would have liked to have an opportunity to speak today in opposition. His worries for his Navajo people to reside on the reservation, infrastructure that he is focused on is bringing water to his people, electricity, and broadband so that they have 911 emergency services. EVs are not on his radar because, number one, how are you going to ranch How are you going to haul water to your homes? How are you going to charge these vehicles if there's no electricity within 5 to 10 miles from you? How are you going to drive 90 miles to take your kids to school? How are you going to drive 90 miles in one direction to go to work? Not to mention the health, safety, and welfare of his people. He was adamant in this meeting, if something happens, where they're stranded. There's been no infrastructure. There's been no training on first responders. This is another issue for the Navajo Nation Police. Dr. Nygren hammered home about. They don't have the training. They don't have the technology. If they go to a wreck and they're not trained properly and try to retrieve an individual out of a vehicle, they could kill themselves and the individual with electrocution. These are issues Dr. Nygren is extremely concerned about, and everybody else in rural New Mexico. Half of our areas are provided by volunteer firefighters on a volunteer basis. That's 20,000 square miles. What ifs? And right now, the infrastructure is not there in rural New Mexico to support this. Now, if you live in Gallup and want to purchase one, that's fine. But just like I testified in November, I still have the same Toyota battery electric vehicle I testified to sitting on my lot 6 months later with a $5,000 discount, bringing it to right about $39,000. And I still don't have anybody interested. My plug-in hybrids with Stellantis, the Jeep 4xEs. The only way they'll qualify for the tax credit, both state and federal, is if you lease the vehicle. If you lease, you're capped at 12,000 miles a year. I live a mile and a half from my stores. I can't meet 12,000 miles a year. The mileage that we drive in rural New Mexico. Where am I going to charge this vehicle back and forth on the road when there's not even electricity in the areas that I'm driving through or cell phone service? I don't think they're going to build a generator big enough to put enough chargers along some of those corridors. And these are the concerns we have. These, like I said, again, rural New Mexico tribe and pueblos have not been talked to or conferred about these. And again, meeting with President Nygren, he is extremely concerned about the areas. President Nygren feels at this time that an electric vehicle is not a viable choice due to the lack of paved roads, the lack of charging stations on the reservation. President Nygren indicated that his priorities are providing water, electricity, and broadband to his people. In addition, he's concerned with the affordability of EVs and fears his people will not be able to afford them. Will be forced to drive their older vehicles longer, and this rule will increase the price of the vehicle. This issue appears to be counterintuitive to the goals that we are trying to achieve.
Ms. Garcia, you understand we're not asking to redo the board's decision. We're just asking to stay it while we appeal it. What irreparable harm could occur if the rule takes effect, you are delivered electric vehicles, and then perhaps sometime after that, the rule is reversed?
Irreparable for my community. My Dodge store, Stellantis store, employs 70 people. I have not ordered a vehicle Stellantis since October of 2023. Because as of right now, I don't know if I'm going to keep that franchise, because if they're going to mandate to me what I can and cannot sell my customers or what's best for my customers to drive, then I'm not going to represent a manufacturer that does that. So there will be 70 families, 70 jobs lost if I terminate my contract. And that's what I'm contemplating at this point in time. Because I cannot look at my consumers and tell them that they're forced to drive a vehicle that will not meet their needs. Is being mandated to me by a manufacturer. Therefore, I would terminate the franchise. That my town of 20,000, 70 employees, that's a huge loss. We don't have jobs to fill those 70 people.
Would the loss of those choice of vehicles affect your customers?
Absolutely.
Describe that, please.
90% of my customers come from the reservation or low income. And my Chevrolet store alone, tracks, the 2024 tracks that's on ground right now, I can't keep enough of them in stock. I don't have any of them. That starts at 24,000 MSRP, and we sell within 3 to 5 days once we get those in. But we're getting maybe 5 to 9 of those a month. By reducing the number of vehicles that our customers and purchase, it's going to force them to go out of state, which is going to force a price gouge out of state. And any other dealer is going to see that they can't purchase that vehicle in New Mexico. Price of the vehicle is going to go up, but then they're going to turn right around and re-register that in New Mexico. It's forcing business out of here, which in turn will make us as the business owners downscale the amount of employees we have. Therefore, it's going to take a huge economic impact on the state of New Mexico and the people that we employ if we don't have the business to keep them there.
That's all the questions I have. Thank you. Or other people or the board may have.
Thank you. Mr. Maxwell, do you have questions of Ms. Garcia?
Your Honor, I have no questions for this witness. Thank you.
Thank you, Mr. Knight. Thank you, Mr. Bach. We need you to speak into a microphone.
About, I just wanted to ask a question. I think you said that you would consider terminating your Stellantis franchise agreement. Is that correct?
Yes.
And that's because of what Stellantis is telling you they want you to sell. Okay. So not because of this rule then.
Well, this rule would mandate what as of March 19th,
So-
they have made a dealer communication to make PHEVs, BEVs, ICE vehicles available to all dealers. By doing that, they still have not given us an allocation spread of what will be able to be ordered. And if I'm cut to 20% ICE, can't keep a store open at 20% vehicles that are sellable.
Okay, but to be clear, it's based on what Stellantis is telling you they're willing to sell you that you would terminate the.
Only,
Yeah, yes or no?
Only in a CARB state are they going to do that.
Okay, I think we'll hear some other evidence on that later. That's all I have. Thanks.
Mr. Bach. Let me start with the city board this time. Chair Paul, do you have questions?
No questions for me. Thank you.
All right. Vice Chair Richards.
No questions.
All right. Thank you. Member Armijo.
No questions. Thank you.
Thank you. Member Galuski.
No questions. Thank you.
Thank you. Member Coleman. Did I miss anyone from the city board? All right. We'll come back into the room then. Member Garcia.
Yes, I have a I think part of the issue we're looking at with the stay when the harm might occur, harm that would occur. So between now and the time that the bill is decided, here to explain to me what would happen at the end of the year, let's say.
Currently, we're ordering 2025. 2024 is model year on ground. We are now ordering 2025s. Come the fall, that would go to 2026, which puts us less than a year to be able to meet the mandates. Have that. With Chevrolet, I can speak. They've pushed back to 2050 on going, you mean zero emission. They're not, the Bolt isn't even been decided if it's going to come back and if it is what model year. And that was from our dealer communication and it's called a go-to-market meeting. We have the first of every single month. They haven't even come out yet with if they're even going to bring the Bolt back. The EV, Blazer EV, I'm sure you guys see the news. It was on a stop sale for battery issues again. They've cut production down on that vehicle as well. So being able to meet the needs of this mandate just by having the inventory there, Toyota will not do it. It's already, and I think I testified to that in November, Toyota is going away from BEVs and going plug-in hybrid. So Toyota is not an issue with this, but for all three manufacturers and the business-wise, being able to meet with the inventory is going to be almost impossible to meet the mandate. I won't have the supply there to be able to sell it to meet it. The supply has been cut, and you know what I mean? And if they're not producing them, then I don't have anything to sell.
you. Ms. Garcia, I'm sorry to have to ask, but the folks on the platform are occasionally struggling with sound. So just make sure that you keep your mouth pointed at the microphone. All right. Chair Sweeney.
No questions.
All right. Vice Chair Trujillo.
No questions.
Member Ely.
I have no question.
All right. Member Bitzer. Member Bitzer, do you have questions of Ms. Garcia? Okay. He shook his head no. Member Honker?
No questions.
All right. Thank you very much.
Thank
Ms.
you.
Garcia.
I believe Member Hunker recused himself for this issue. I don't know if you want to. Oh, because he wasn't here.
Oh, I'm very sorry. I didn't realize.
Yeah.
Okay.
Put that on the record.
Thank you.
Thank you.
We'll call our next witness, Carlos Garcia.
Carlos Garcia. Thank you. Do you swear or affirm to tell the truth?
Please introduce yourself to the board, reintroduce yourself.
Madam Hearing Officer, Madam Chairs and members, both boards feel like we got the band back together here. Good to see everybody. My name is Carlos Garcia. I'm here representing Automundo de Garcia, asking that the EIB and the Air Board grant our motion for stay on the clean cars portion of ACC 2. It was discussed breaking up the three parts of the ACC 2 in the hearing, despite what Mr. Fox said. And Mr. Knight alluded to it in his closing, and board members did ask that question, and Ms. Cedillo Lopez did give counsel on that to the Air Board. But I don't feel that there was proper clarification for those different portions, and probably obviously didn't get the consideration they should. Granting a stay does not mean that the EIB is admitting it was wrong, or the Air Board. It means that these boards believe that there are good reasons to wait to implement the regulation by allowing the legal merits of our case to play itself out in the Court of Appeals, which they will one way or another. Especially, I think that Mr. Domenici has put forth a compelling argument, and as well as what's going on in the world and everything that's changed since our November hearing, I think we have an excellent chance of winning our appeal. We have much more information now that was not available at the time of the hearing. We know it was rushed. We know why it was rushed, for reasons to try to get it in under a time crunch, but that didn't give everybody the chance to properly consider what was happening. I feel that with this EV mandate, there's a tremendous risk of what we call a failed launch from a retail standpoint. A failed launch normally means a quality or readiness issue with a vehicle that results in a consumer outcry and bad media reports. In our industry, it's virtually impossible to recover from something like this. We didn't have the advantage of rebuttal testimony like the climate advocates, but Mr. Bradley talked about a failed launch. And to be honest with you, I mean, our decades of experience in the new retail car business, my dad was a DeLorean dealer. We know what a failed launch is. And not doing this right for New Mexicans and the EV market in general, with all the bad press that's coming through it now, is really hurting that as much as we want it to be successful for our businesses. I think that we all have so much at stake here, including the boards. We all want some cover from this mandate, and I really am hoping that the stay will soften the blow of this rule, and a failed launch really doesn't help any of us. A vehicle on our lot was developed 5 to 7 years ago. Ordering of parts, manufacturing quotas, and retooling plants occurred 2 to 3 years ago. The lead time for a vehicle to come from concept to reality is really long in auto manufacturing. Distribution doesn't change on the flip of a switch like you were told in the November hearings. It takes years to change production plans for any automaker, even the slightest change from changing out the type of a seat. We saw this in COVID and supply chain issues, it takes years. The industry, we've still never recovered as an industry from supply chain shortages. Many industries still haven't, but especially the auto industry and especially the auto industry in New Mexico with all the shutdown. We do have 2025 models are arriving. I think that's clear. It's going to take years to recalibrate and correct the market conditions that this type of mandate will take when the government 2 days ago cut their forecast in half. That really, I feel like even my testimony, if someone reads an article on what the Biden administration and the EPA passed, it's pretty clear what they're signaling. They cut their forecast in half for 2030. So I think it greatly diminishes the impact of trying to put these crazy numbers out there because their EPA and the administration are acknowledging that they're just not possible to hit, whether it's California, New Mexico, or anyone else. So the board, this rule has taken on such a life of its own. It's now creating economic and social policy, which you're here to affect policy on air quality, and that's what your expertise is, and we look to you for that. But this has become so much more than just air quality issue, which we're 100% in support of improving with EVs. I've had great conversations with people on the other side of this. We agree on 85% of what's going on. It's just the business structure and the harm to the business, being able to take care of New Mexicans and customers. It's really problematic, and the manufacturer production relations are nearly impossible here. During our hearing, I feel like it's deja vu here. You heard speculative claim after speculative claim from the NMED's so-called experts that were based on a myth. Now you're hearing that everything we said was speculative when we told you what was going to happen, and it did. It's sort of ironic to me that that's the argument being used against us. There were so many assumptions that were unfounded that were made to you and promises that you heard over and over. Those promises didn't happen. Now we have to deal with the unintended consequences of this rule. The auto dealer's testimony during our hearing was based on facts. We didn't try to bog you down with a million charts and things that were not relevant to the case. The NMED's witnesses were speculating what would happen with more infrastructure and heavy financial incentives. 6 months later, we have answers. The speculation has now been filled with knowledge, not by hired guns that never even came to New Mexico for our hearing, but what the marketplace has told us. There's an indisputable fact here. The EV market is flat. We were sold a bill of goods that there was so much EV demand that these cars were flying off our lots. We told you this was untrue. Since our hearing, Toyota, Honda, General Motors, Ford, and even Volvo, who committed to be 100% EV by 2030, cut off all funding to their EV arm. All these companies cut their forecasts in EV spending. This was on the horizon during our hearing, and we brought it up. Just days after our hearings, much more media coverage came out, and I know Ms. Harris says that newspaper articles aren't valid, but national media and the president of Toyota giving quotes to me seems like a pretty credible source. Toyota is the largest automaker in the world. Honda and Toyota and Subaru are 65% of the market of what we sell here in Albuquerque, and the hottest segment out there, hybrid vehicles, which we said are clear segue to zero emissions vehicles, which we all know they're in the not too distant future. But hybrid vehicles are selling with no federal subsidies right now, and most dealers are sold out of hybrid vehicles. That's showing that consumer demand is there for those vehicles that are concerned about the environment, or those customers that are concerned about the environment. They're not fully ready to adopt an EV for whatever reason. Toyota is the world's largest automaker. They rarely make mistakes, but their non-action on EVs is what lets us know that there's not a sustainable market for these vehicles. Toyota's president on March 4th gave an interview and said they would rather buy the EV offset credits rather than waste money in investing in EVs without consumers ready to buy them. That and the Biden administration reducing their goals are the two most telling things to me. If Toyota's saying, we're not going to build these cars because people don't want them, we're just going to go buy credits from Tesla, that's far more telling to me than anything else I've heard from any other manufacturer. This directly contradicts what you were told by the NMED regarding automakers' commitments to achieve these imposed mandates. The fact that automakers are reaching out, trying to get clarification on the lead up credits, they're all going to do that. Everybody doesn't have a choice in any ACC state. BMW sending an email or any other manufacturer, they're all going to do that. As part of even during the stay, they can still accrue credits because they're going to keep track of their vehicles. We heard the EPA is still not granted California's waiver for ACC2. Why? They're waiting to see what happens, just like all of us, just like Toyota, just like every customer that we have that's on the fence about these things. There's just too much doubt. And the longer we wait to right the wrongs of the mandate, especially in New Mexico, the more irreparable harm will be caused. There's no amount of money down the line that's going to be able to fix what's going to happen to the auto business and the tens of thousands of employees. They're not just in dealerships, but down the line in automotive services. Everyone sees that the 43% mandate is not achievable in any state, much less New Mexico. It'll be too late. Without a doubt, the most baseless claim you were led to believe was that of huge EV incentives the legislature was going to pass in this most recent session. You heard it from every witness, the NMED, legislators, supporters of the mandate. I heard the governor say, we're going to pass huge EV incentives. I mean big. She spoke in July and October. What did we get? Next to nothing. $3,000 reducing incentive that's income restricted and capped at a new vehicle price, which excludes 75% of the market. And I'll add in there, Ms. Harris didn't like my number of 75% of the EV market. Put in a chart about the top 10 EV sellers. Well, it was an outdated list of base MSRP prices, but it wasn't reflective with transaction prices. And if you take every vehicle available EV on the market from the cheapest one to the most expensive one, about 75% of them are over the New Mexico incentive threshold. So arguably 75% of what manufacturers are building and think people want aren't even going to be applicable for our law. Not one pickup truck qualifies for this incentive. There were 3 2023 model Ford Lightnings for sale at the biggest Ford dealerships in New Mexico yesterday when I looked. Those are pre-price increase cars. None of those cars would qualify. The F-150 is the number one selling car in New Mexico, has been for decades, yet we don't have an incentive that covers a pickup truck that we're all supposed to believe solve everybody's problem. It's just more speculation that you were fed that's totally untrue. When I was asked what it would take to move EVs in New Mexico, I said it would likely be like the $10,000 per car like they have in Colorado and California. I told legislators on both sides of the aisle, ask for 15,000, hope to get 10. Instead, we got virtually nothing. You were promised earth-shattering incentives on new EVs, used EVs, and hybrid vehicles. $3,000 on new EVs, half of that on used, is not earth-shattering, and it decreases over time. Top of that, if the customer qualifies, despite what Ms. Harris says, it's not an on-the-hood incentive. The tax incentive, which our legislator, Hockman Vigil, who could not articulate how the incentive was paid and had to be saved by the Secretary of Tax and Revenue, it's a $3,000 incentive that goes to the customer that they can transfer to the dealer. So it's not an on-the-hood right-away incentive. Best case scenario for us is we're able to work out a deal, the customer brings it back. You could be 11 and a half months away from getting that money. So you are being a tax collector and we are being a 0% interest bank. That's how this actually works. So it looked to me like it was a kind of a canned response. So this was just a huge failure by the governor and the legislature and everybody that promised you these huge incentives. It's an embarrassment to the administration and an embarrassment to the state that after all that, everything you were led to believe about these huge incentives that were going to move the market, we got $3,000. So you were promised this great program and all you got was the smallest state EV incentive in the United States after everything you heard and all the testimony that was based on it. The fact that ZEV sales would have to increase 1,000% in 3 years in New Mexico just sounds preposterous and impossible now that we can sit back and look at it. It sounds crazy to anybody. Nobody thinks that can, or at least very few people would think that. Last point is New Mexico is a captive orphan in terms of sales volume in the United States. We're the smallest of the small. We get the last choice already when it comes to vehicle allocation because we just don't sell many cars as a state. 0.5% total U.S. new vehicle sales is is nothing, especially after what we did in COVID and basically shut off the pipeline to manufacturers. Again, years to try to get us back to where we were, and we're still not there. Manufacturers start trying to produce vehicles in this way. Basically, the only state they have a real shot at this at is California. If they're retooling for that major market, our amount of vehicles are going to be cut so heavily in gas cars that it's going to be a declining number of vehicles that we sell and offer to customers that will never have a chance to recoup all those losses. It's the best definition of irreparable harm that I can think of if we keep moving forward with this. Auto manufacturers are worried about the large states that move big volume. They're not worried about New Mexico. Right, what you were told, calling the manufacturer or sending them a letter about New Mexico is going to do this doesn't do anything. Right? We need to be part of something that is broader, that helps more states. Last couple of things were to address the rebuttal testimony. Ms. Harris, the fix at our websites, I know said that we only have 2.8% of our vehicles or EVs on our websites for all the Garcia dealerships. That's true. But what she doesn't ask is how many EV vehicles we have turned down from all of our dealerships that sell them. None. We take them all because we know that we need to sell them. We need to have them available. It's just a fact that and some manufacturers are making us take them, but the ones that allow us to turn them down, we're still taking them. Try to give a good selection to our customers, as our family has for many decades. Told you the truth. Told you the truth on the incentives. Totally not given the truth about. Covered everything else. The last thing was she also made comments about the public comments and how decided to print up some comments in their testimony about people that are in support of it. Well, we're 2,164 comments filed on your website opposed to this and 248 for. We're not told that because the computer shut down magically during the hearing, plus the over 2,000 or 3,000 box comments that were rolled into our last hearing that most of you never even opened or took the boxes home. There were thousands of comments against in those. Of the New Mexico legislators, there's 112. 65 of them sent you letters. 42 of those were in opposition. So those are the real facts. It's not the 20 comments of people they to support it. It was over 90% reached out on comment or against this. Appreciate the time and the extra minute.
Thank you, Mr. Garcia. Mr. Maxwell, do you have questions of Mr. Garcia?
Your Honor,
Thank you. Mr. Knight? Mr. Bach? All right.
Thanks, Mr. Garcia. I think this should be pretty straightforward and simple. I think it sounds like you reviewed our rebuttal, so probably saw that we had gone to your look at the breakdown model years, correct? Right. You're shaking your head, yes, for the court reporter.
Yes, sorry. I did see that.
I always forget that too. Court reporter got to get a. And were those numbers correct that we had?
Yeah, I'm sure they were for the time you look at it. We sell lots of cars every day, so they're probably still pretty close to accurate since you did it 2 days ago.
So I'm looking right now, and it looks like for the model year 2025, you have 10 lot. It's out of a total of 728 new vehicles.
Yeah.
Okay, so about 3.5% of the selection right now is model year 2025.
But it's only March 22nd. I mean, it's 9 months before the calendar year starts. That's what the whole point is. It's not about how many cars I have on the ground. It's that the manufacturers are already building 25s. So that means that we'll be getting 26s on the March 2nd of next year and 27s on March 2nd of 2026. That's what my point was.
Understood. But so I think that we're on the same page that.
But by June, it'll be well over half of our inventory would be 2025. So
but
just a couple months. would be my guess.
But as of right now, you only have 10 2025 vehicles, model year 2025.
Yeah, and I'm sure we've
Yes.
sold some already too.
Okay. That's all I have. Thanks.
Mr. Bach. Let's start with you this time, Member Bitzer. Do you have questions? Mr. Garcia. Can't hear you if you're speaking. So the answer presumably was no.
Sorry, I have the headphones plugged in. No, I do not. Thank you.
All right, thank you. Member Ely.
Yes, I do. Just one, Mr. Garcia, I'm focusing on the next couple of years. 2 years from now, you'll start to get, sounded like, is when you'll start to get model year 27 vehicles onto the lot.
Yes.
So you also talk about a failed launch. Over the next 2 years, how would you experience a failed launch if you're not receiving any of the 27 model years, which is when the rule goes into effect?
Member Ely and members of both boards, that's a great question. And the way that would be experiencing the failed launch is if the state continues to push the mandated numbers, the manufacturers keep pushing EV vehicles in terms of advertising and trying to get these vehicles to sell when there's not the market for them, and the concerns of the public and of New Mexicans are not overcome by forces totally outside of our control, such as charging infrastructure, the cost of a legitimate home charger going in, not the $100 P&M one that we hear about. All those things will contribute to it. The range anxiety and charge anxiety aren't changing. So recently I started taking a much bigger interest in our EV business and talking to so many customers that we sell these cars to. And the people that have them, what I've found is about 70% of the people that I'm selling my EVs to have already had an EV. It's not a new, we've taken EVs and on trade on EVs. So it's not a new market. So if it's not growing, and like I said, the sales are flat despite all the media coverage, it already kind of is a failed launch. Mr. Bradley wants to talk about $25,000 EVs, flying out of the stores. Well, we've been in the car business for almost 100 years. I will tell you, cheap used cars, the name of the game for everybody. That's not even an argument. So it's the new car adoption and the overall customer perception of EVs and what's going on. And if you're driving down the street and you see chargers everywhere, like you do in California, I drive a lot all over town. We have a lot of properties all over town. I haven't seen another charger go in besides the one that's downtown by the old hotel there right by Civic Plaza. So I think customers have the same thing. It's in the perception and the minds of the customers where that failed launch really occurs, because if there's not broad adoption, they don't see their neighbors buying them. Then they read stories about the Chevy that was on stop sale for 6 months, or another vehicle that's supposed to get this great range, and then the New York Times tests it and they get half. All those things contribute to the failed launch. And so that's just sort of in the background, but I think it gets progressively worse if the state taking away choices of gas-powered vehicles and trying to push people to buy more EVs, and they don't deliver with what people want. My example again is on the truck. Can't say it enough. That's going to be a failed launch. If there's no truck that can do what the F-150 does in New Mexico, I can't tell you how devastating that is to the industry and to dealers, but just to people trying to do their job. So all those things contribute to the, sorry, that was
Just one follow-up question. So the failed launch is just all the preparation leading up to the delivery of the model year 27, which would be affected by this rule. Is that what I hear you saying?
Member Ely and members of both boards, yes, but I'm also talking about it more in the context from a customer perception and marketing and sales standpoint. It's not a pinpoint launch of, hey, we're going to roll out the mandate this date. It's all those things that lead up to trying to get that tipping point of when people are going to start buying the vehicles, like we had with hybrid cars. They were a little slow to take off, and then when they hit, they've been fantastic. So that's really what I'm talking about, it more from a standpoint of car buying public, if we want broad adoption and we want everybody buying these cars for cleaner air, that's what we need to try to.
So if you prevail at the appeals court and they reverse the ZEV portion of this rule, and you aren't required to take, or the manufacturers aren't required to deliver a certain percentage of ZEVs, would that then negate the failed launch because you aren't receiving more EVs than perhaps you or your perception of the public wants?
Member Eli and members of both boards, that's correct, because what that would do would open the market for the manufacturers to have the time to develop the product in a proper cadence to where it can be delivered to people in a timely fashion. We all know this is happening. I absolutely unequivocally know that we're going to be at some point in the not too distant future, heavily selling PHEV vehicles. It's just too quick. It's too fast. The infrastructure can't get put in quick enough. And the technology, like Mr. Bach said, he's 100% right. It's getting better every day, but it takes a lot of days to get it to where it's actually feasible for most New Mexicans and their needs. Average New Mexican drives 19,000 miles a year. An average Californian drives 12,000 miles a year. We have different needs. So if our state prevails and we go back to ACC1, which is still valid, or the new federal guidelines, I think it's really going to take out a lot of that failed launch, because the manufacturers can do it right, the state can do it right for charging stations, the federal government can get it right for charging stations on interstate highways, and the state can get this incentive thing right. So I think all those things with a little extra time, right, and just delaying it and pushing it back a little bit, gives everybody the opportunity to achieve what we're all trying to achieve. It's just too fast. And the federal government acknowledged that by cutting their forecast by half 2 days ago. Very telling to me.
So I was just trying to understand if the failed launch was part of your concern of irreparable harm over the next 2 years, and it wouldn't be if you prevail in the appeals.
Member Eli and members of both boards, I don't think it would be as big of a concern, because like I said in my testimony, the manufacturers, it takes years to develop this product. They know 5 years from now what cars they're going to be building, what they look like, what color is going to be popular. We get these yellow and blue cars that come in. Where did this stuff come from? And all of a sudden it's the hottest thing out there. And so, their research and what they do is so many years ahead. But now, as we're going into this now, I feel like there already is irreparable harm happening, because manufacturers such as General Motors, and I'm a General Motors dealer, rushing to get this product out is resulting in stop sales, software glitches. All these things are happening at a much higher rate than they do on internal combustion engine cars. And it's not just because of the technology, it's just because they're trying to go so fast. So there is irreparable harm already. I admit it, but we've had EVs that had manufacturer buybacks with under 200 miles on the odometer. I know every manufacturer's had that. So that failed launch that you're talking about is already happening, and I think it'll continue to get worse if we don't prevail and the manufacturers keep trying to produce cars and send them to us to try to build up credits to make California happy. I think it's going to happen 100%. And it will still happen even if we do prevail, because what happens for California and the other ACC2 states like Colorado that are big, we're such a leftover to them. They're not going to retool or start sending us a bunch of internal combustion cars, because California is so massive. Colorado is a big market, and all the 11 ACC2 states together really are going to push these manufacturers to have to build cars to cater to those markets, and we're just an afterthought. And that's part of the good of being a car dealer in New Mexico, and part of the bad. The good part is we're not over dealered, and there's not a crazy amount of competition, and we still have local dealers that have been in business for decades, like us and Gary and other family stores. Where in major markets, you just don't have that anymore. And so we're able to do great things for our community, whereas these multinational companies don't care, don't do anything to support the community. In my mind, that's going to be a real loss.
Vice Chair Trujillo.
I'm curious. I've heard two stories throughout this process, and one is um, that people can't find these cars. They want them and they can't find them. They have to go to other states to get them. And I've also heard that these cars will sit on lots for 6 months and they're not moving anywhere. So I'm just kind of curious what prevents a consumer from walking into any dealership or let's say GM and saying, I want this particular GM model. Realize you don't have it here, but I want it. Can you get it for me? Is there something that prevents that mechanism?
So, Vice Chair Trujillo and members of both boards, I think I have an easy way to explain that. And, we're talking about two totally different things when we talk about this rule, which 99% of it pertains to new vehicles, that type of production, those cars delivered to New Mexico, and used cars. So, as I mentioned before, people talking about having to go out of state to buy EVs, certainly understand that. But as I said, inexpensive used cars that are clean, that have good mileage, that's always going to be the hottest segment in the industry, whether it's an EV or an ICE powered car or a diesel truck. So acting like this is a revelation that you're hearing from the other side that people can't go find EVs. I mean, I have 100 people that have a $5,000 or $10,000 budget, and they all want a Honda CRV with low miles and service history and everything else. It's not any different from any other part of the industry. Now, what I will tell you is we do have customers like that all the time that have that budget in mind on cars. And, I love sourcing used vehicles. I love finding people cars. I get tons of calls every week from people having me find them anything from a super expensive car to a commuter car. We do try our best to find those cars and source them. There are just not enough of them out there, just like there aren't in regular cars. It's, you're getting told that this is unique to EVs. It isn't. I mean, people go out of state. If they find a low mileage Honda Accord, in Southern Colorado with service records that meets their price, they're going to go buy it. It's the same thing for an EV. We definitely, and I know most dealers, somebody tells us this is what we're looking for, we're going to do everything we can to try to find it. That's how we make our living, and we want to make customers happy. So I know I do it, and I can't always find them on EVs. I wish I could. Again, as more of these cars get sold, have greater availability, but singling this out to cars under $25,000 is a fallacy because I have 40 times the demand for under $20,000 gas cars as I do for EVs.
Thank you for explaining that further. And I just wanted to circle back to a comment. You talked about that box that was delivered to us. And I just want to let you know that I did take my box home and I did go through the box. And I know a number of my fellow board members did as well. And look at the comments that were in them. Because as many of the members of the board here, we care about what the public has to say on issues. I will say that most of those comments were the same comments. They were auto-generated. Actually, they even had the same typos throughout the letters. But I just wanted you to know, I hear you, and we are taking in this information to make sure I looked through that box.
Yeah, Vice Chair Trujillo, members of the both boards. That's why I said almost. I know some of them didn't look because the boxes never moved, and you voted before they were there. And I know that it wasn't one. It was a canned message sent by every person that went and signed up to send them. But ones that were submitted on your website were not. Were sent. They were all sent by IP addresses. But issue there.
Chair Sveda? No questions at this time.
Very much. Did I go to the city county board yet? All right. Chair Paul?
No questions from me, but I do think Member Galuski has a question.
All right. Member Galuski?
Yes, hi there. I think you mentioned this. Did I hear you say that the EPA has not yet approved the California waiver for Advanced Clean Cars 2?
Member Galuski and members of both boards, that's correct. The EPA is not, unless it happened in the last 10 hours, the EPA is not granted the waiver for ACC2 California, which is what these boards voted to adopt in 23.
And so what does that mean for the status of the rule currently? Does that mean that even California can't start implementing it?
Member Galuski and members of both boards, I mean, that's my question also. I mean, it seemed like this was awfully premature to go through all this and all the hemming and hawing from the governor and the legislatures about incentives when California, and even going back to our May 22 hearing about ACC1, when ACC2 was being considered. I mean, we've spent all this time and tons of us have spent resources on something that still hasn't been approved. The Biden EPA ruling, I think, is going to have a major impact on what ends up happening with this EPA waiver. I mean, you have a great question. I mean, what do we do if it still hasn't been approved? We're doing all this planning, and you're going to hear a ton of testimony this afternoon about speculation about we're going to do this and that, but it still hasn't been approved. So I think your guess is as good as mine, but there's, again, nothing concrete. As we said, it was pure speculation from the other side that it was going to get approved, and now we're the speculators. But either way, it hasn't been approved yet, and I think we could end up back here in another hearing depending on what the EPA does for California.
Okay, yeah, it sounds like it is an important piece of complexity in this. I hope somebody can comment more on what that means if California hasn't, that the EPA hasn't approved this yet. But that's helpful information. Thanks.
Member Armijo?
I have no questions. Thank you.
All right. Vice Chair Richard?
Hi, yeah, I had a couple of questions. One was in terms of the question that was asked by Member Galuski. Generally, do you have the time frame for when a rule is passed, for example, by the state for Clean Cars 2, and when EPA actually approves it? Do you have knowledge of that?
Vice Chair Richards and members of both boards, I don't. I'm not this is my first foray into EPA regulations, other than the basic thing of 50 state cars and things that happened, which were much simpler. So I don't know what the timeline is. Not at all. I know California did approve their ACC2 right after we did ACC1. So it's been almost 2 years ago that they approved ACC2, and the EPA still hasn't granted the waiver 2 years later, which is telling to me. So.
Thank you. I just know, having been on the board, that sometimes we'll make changes, for example, to state implementation plan, and it takes a while for EPA to sign off on it. It's sometimes delayed significantly. So the other question I had was whether or not it concerns kind of sort of a graphical element, which is early adopters and then mainstream, and finally they call them late adopters. And it's typical for any kind of behavioral change. I'm a public health specialist, so you see that kind of change occurring almost for any kind of intervention. And I'm just wondering whether you have noticed that for other government implemented policies in terms of car sales. For example, you think of public health things like seatbelt usage, or now we're looking at there's these things that prevent you, electronically from tailgating somebody who's in front of you and keeps a safe distance. Do you feel there's a role for government intervention in those types of public health interventions?
Member Richards or Vice Chair Richards and members of both boards, I absolutely do. Senator Ben Ray Lujan called me and called my brother very early on when he was talking about mandated breathalyzer devices in all cars, because we just shouldn't put the public health at risk. And why should something so simple not be in a car, just like a seatbelt? So when seatbelts were made part of federal legislation, or 10-mile-an-hour crash bumpers or child seats, there's always going to be some person that's going to object to it or whatever. But in terms of public health and safety, I think the government definitely has a role in it. I think that the government is right to address the climate crisis and to try to move zero emissions vehicles along 100%. Now, when it's safety related, it's much easier and people are going to adopt to it much quicker. Now, when you're telling someone how to spend their money, such as this EV mandate does, that's totally different. So I think that the air quality issue is the most important thing out of all this, 100%. I absolutely think that, and I think the government subsidizing these chargers and vehicles is very important. I think it's been a successful program. I think that if they really want it to happen, they need to do more. But you need a combination in something where it's affecting how people spend their money, unlike a safety-related item where there's consumer choice there. You have to have a balance of what the government's urging you to do and what they're telling you to do. And so they're telling you you're going to buy a car with a seatbelt is a little bit different than saying that you have to buy an electric truck that can get you to work in the morning. Those are two totally different things. So I do think the government has place in these types of issues, especially when it comes to safety issues. But when it comes to choice of how people spend their hard-earned money, just think that that's reaching a little too far. My
Thank you.
personal opinion.
Okay, thank you. I just had one more question. Have you done any kind of, or your industry for this clean cars rule, done any kind of cost benefit analysis? It seems like you have a lot of data, but a lot of it is just based kind of on the internally with your industry. Are you aware of any kind of cost benefit analysis reports that have been done, peer reviewed, that
Sure.
we might be able to access?
Vice Chair Richards and members of both boards, there is data published by the NADA and the Automotive Alliance. We can get those emailed to you. I know from my own experience in our dealerships, what I've seen and from talking to the larger EV dealers such as Ford, because their losses on the EV cars are so huge, there's no markup on them. So I know the margin is very small, like on Fords. The Mach-E, the dealer cost is higher than the window sticker, which is absolutely crazy. I know our margins on the $60,000 Cadillac are much smaller. $60,000 electric Cadillac are much smaller. So from our standpoint, the profit margin on the cars is a lot smaller. You hear opponents talking about, you don't have to service these cars and they're maintenance free. That's really not true. You're replacing tires twice as fast. We were able to make money on that. And these cars have so many problems. We're actually getting a lot of service work from them. I like the EV business. I've spent a lot of money training my people and sending them to class, buying the equipment because it's going to be a good revenue source. So for us, cost benefit analysis, we have certainly come nowhere near recouping over $1 million that we've spent in our company on EV training and equipment from our sales and service business, but it'll get there. And I think hopefully the initial investment lasts a little longer than it's appearing that it will. But the cost benefit for us, it's not there yet, but it does look to me like it's a viable business if we're able to get the timeline right and get consumer demand evened up with.
Okay, so you're
Standards
saying
are gonna be.
that I'm sorry, I lost you a little bit. Just to confirm, you're saying your industry does cost benefit analysis, but there's no sort of objective analysis that you've looked at from peer reviewed articles.
Vice Chair Richards and members of the board, I think that the NADA has them and the Automotive Alliance has them. That those would be considered peer reviewed. I know the climate advocates use some of their data, so we're happy to send those to you. I don't know what they say offhand. I just am in my bubble of looking at it.
Okay, great. Thank you. But it sounds like from the last part of your previous comments, eventually parity is met. You have kind of an initial investment hump, but once consumer demand starts occurring, that it evens out and your investment is, a return on your investment is achieved. So that's helpful. That's all I had. Thank you.
Thank you. Any other questions from either board? Thank you very much, Mr. Garcia.
We don't have any further witnesses. I would just move the exhibits that were attached to the NOIs into evidence.
All right, thank you. Do I hear any objections from anyone? All right, thank you very much. Your exhibits are admitted. Let's take a lunch break. We'll come back at 1:15, and I will ask Mr. Maxwell for his statement first, and then we'll turn to the stay opponent. Thank you. Thank you. We are back after a lunch break, and we'll begin with whatever statement Mr. Maxwell would like to make.
Thank you, Your Honor and board members. As we reconvene from lunch, I'll keep my remarks brief. I don't have any technical testimony or any statement to add, but I'm here to listen and learn from your deliberations. Let's dive back into the matters at hand with fresh energy. Thank you.
Thank you, Mr. Maxwell. Mr. Knight.
Thank you. Madam Hearing Officer and board members, good afternoon. Well, we are here once again, but this is not day 5 of the hearing. We are not here to reconsider or relitigate the rule. We are only here to decide if the movements have met the 4 factors from the Tenneco case, which is the standard for granting a stay in Mexico. Once again, they have misstated what the rule does, how the rule works, and what the rule requires. They don't talk about the flexibility that is built into the rule, flexibility that was carefully thought out and discussed with the manufacturers before the rule was proposed. I am forced to conclude that they just haven't taken the time to understand how this rule works. They don't talk about all the different initiatives, programs, plans, projects, incentives, and grants that are now in place and that are all a part of the implementation of this rule. Once again, they imply that the rule will make them spend money for upgrades they say they are already doing, or upgrades their manufacturers were already requiring before the rule was passed. Once again, they point to a business model that is admittedly under a lot of pressure and blame the rule for effects that started before the rule was adopted and that will continue long after the appeal is decided. They are still relying on misdirection and biased news stories to make their case, and we trust that you will give all of that kind of evidence the weight it deserves. Stays are granted very rarely and with good reason. Granting a stay of a rule like this would be very disruptive to the manufacturers, none of whom, I will note, are here today asking for a stay. Put yourself in the shoes of the manufacturer. The rule is adopted. They have to gear up to comply. The rule is stayed. Now they don't. The rule is later upheld on appeal. Now they do again. What the manufacturers have repeatedly told us they want is certainty. If they know what the standard is and they know the time frame, they can adapt and they can plan. What would be most harmful to them would be this ping-ponging back and forth. Staying the rule would, in fact, take away the manufacturer's ability to earn early action credits, which are critical to their ability to meet the delivery requirements during the first compliance year. Regarding the 4 Tenneco factors, we went into those in great detail in our written response, but I wanted to touch on just 2 of them here. First, irreparable harm. It is not enough for the dealers to merely say that they will be irreparably harmed. They have to show it. They have to prove it. And they have to prove the irreparable harm is to them and not to third parties, which is hard for them to do since the first compliance model year is not until 2027, and because the delivery requirements apply to the manufacturers and not to the dealers. It is also not enough for them to say that they have raised significant concerns with the rule. That is not the standard here. Irreparable harm does not mean inconvenience. It does not mean extra cost or effort. It does not mean an assertion or a belief that harm will occur at some future time. It means a showing that irreparable harm will occur specifically to them and only because of this rule, not because of global trends or business decisions made by the manufacturers. They have talked about harm, they have claimed it in very general terms, but they have a hard time coming forward with actual evidence of irreparable harm that is tied directly to a rule that does not impose any delivery requirements on them. The second factor I want to touch on is the harm to the public interest if a stay is granted. As you heard during the rulemaking, vehicle exhaust is made up of all sorts of pollutants, including carbon monoxide, particulate matter, nitrogen oxides, sulfur dioxide, and carbon emissions that are the primary driver of climate change. Exposure to particle pollution ages lung tissue and reduces lung function, and it can lead to cancer, stroke, heart problems, COPD, and other lung and vascular issues. It can aggravate asthma and is linked to neurodegenerative diseases like Alzheimer's, Parkinson's, and other types of dementia. Particle pollution led to more than 107,000 premature deaths in the US in 1 year alone. That's more than the number of people killed each year in homicides and traffic accidents combined. If a stay were granted, the air quality benefits of the rule would also be put on hold. What New Mexicans want is clean air and to be free from asthma and other respiratory diseases. That is what is in the public interest. When this board adopted Advanced Clean Cars 2, it made national headlines. It was a concrete step in the global effort to address climate change. It was one of the most significant single steps these boards have ever taken to improve air quality in our state. There are more EVs on the road now than there have ever been. More public chargers are coming online every week. The federal and state tax credits are in place. Incentives from P&M and other utilities are in place. The regulatory tailwinds are in place, and we need to keep that momentum going. The demand for fully electric cars is growing in the US. The nation crossed a key threshold at the end of last year. 1.2 million electric vehicles were sold, a 46% jump from 2022. Consumers are going to plug-in hybrids, which are a very important part of this rule, and which will be critical in helping the manufacturers meet the delivery requirements. Lower priced EVs are coming, but if this rule is stayed, New Mexico may not see many of those for quite some time because they are most assuredly being delivered to Section 177 states first. New federal standards were just adopted, but that makes having the rule in place even more important, as now New Mexico will be competing against all 50 states for those electric vehicles. And without the delivery requirements of the rule, we would definitely be left in last place. And that's what it comes down to. If the rule is stayed, New Mexico returns to the back of the line. There is no going back. We should not want to go back. For all those reasons, we are asking you to deny the stay. And with that, I would like to call my first witness, Mr. Jerry Valdez.
You would raise your right hand. Do you swear or affirm that you will tell the truth?
I do.
Thank you.
Thank you.
Mr. Valdez, would you state your full name for the record and introduce yourself to the boards?
Chair, board members, my name is Jerry Valdez, Executive Director with the Department of Transportation.
And Mr. Valdez, you submitted written testimony in this matter. Would you summarize that written testimony now for the boards?
Yes. Chairs, members of the committee, I submitted a statement that I'm prepared to summarize today. I wanted to give an update from the infrastructure questions that have come up regarding this rule. The Department of Transportation, under the Infrastructure Investment and Jobs Act, enacted in 2001, November of 2001, received New Mexico Department of Transportation received $38.3 million from $5 billion that was made available to states to advance a robust network of charging infrastructure across the nation. This $5 billion investment was broken down into two pots. One being the formulaic funding that each state received that was appropriated and apportioned through Congress. And the other was the discretionary grant funding that was provided for states to apply for additional funding for community and corridor charging along New Mexico's and other states' community and corridor locations. We received $38.3 million for the purpose of advancing our network of charging infrastructure along 3 designated alternative fuel corridors around New Mexico. It represented 2,200 miles of alternative fuel lane miles, them being primary, the corridors, your interstates, and primary arteries through New Mexico. We also, in 2021, received an appropriation from the New Mexico legislature for $10 million from ARPA, COVID relief funds. Those fundings went towards expanding EV infrastructure. And I think I spoke about that at the last hearing in regards to rural New Mexico. The strategy was to use that $10 million in areas and locations that otherwise would have not or may not have qualified for federal funding. So I'm happy to announce that we have approximately over 50 charging stations that have already come online with that $10 million, with an additional 36 stations scheduled to come online by the end of next quarter, June 30th. That represents the first $10 million of investments that went into the state with the $10 million investments made by the state legislature. The $38.3 million, which is the next pot of money, I'm happy to announce that the first phase has already been a call for project went out. We selected 20 locations across I-40, I-10, and I-25, approximately, but not exact, 50 miles apart from each other, represents 20 locations along all 3 of our major interstates. Those awards have gone out to contractors with an estimated construction completion of at least the next 12 months. Happy to also announce, as I mentioned, the $5 billion is broken out into 2 pots of funding, one of them being the formulaic funding, which we received $38.3 million. But the 40% of funding through BIL, IIJA was also discretionary grant funding, which allows states to apply for discretionary grant funding. And we were fortunate enough under the first call of projects under the federal NOFO, Notice of Funding Opportunity, to receive in the state of New Mexico an additional $67.7 million of discretionary grant funding to expand EV charging infrastructure in our state. That was broken up into 3 awards, one for Taos, which was $500,000, another for Santa Fe County, which was $3.3 million. And the Department of Transportation received the largest portion of the award at $63.8 million. That we have a contractor and we have project scheduled. We're actually negotiating our contracts right now to get that project off the ground. And it encompasses 2 large EV infrastructure locations along I-10 for medium to heavy vehicles in Vado and Lordsburg, which will have 9 high-level EV charging pull-through locations along that freight corridor. Because we only were able to get those 20 locations, which is what we called for, and it was only $11.9 million for those awards. That means we have the remainder of the $38 million, which a call will be going out in the summer for the additional 1,200 miles of alternative fuel corridors in New Mexico. So that gives us a little over $27 million to continue our build out of EV charging infrastructure along New Mexico's corridors. We anticipate that the cost to finish the alternative fuel corridors will not meet the $27 million because of the 20% match. When I'm telling you the numbers, it only represents the 80% that we've received formulaically. It also includes 20% that private companies that partner with the state of New Mexico also must put into the building of the infrastructure. So when we finish the alternative fuel corridors along the additional 1,200 miles, whatever funding is left over will be able to go into communities and to help fill the gaps with that remainder of the funding that was not used for the alternative fuel corridors. Also, in this year's legislative session, we were appropriated an additional $15 million. That $15 million will also go towards filling in those gaps in areas that do not meet the federal requirements for the formulaic funding under NEVI, National Electric Vehicle Infrastructure Program. So that $50 million will be utilized for rural communities with the focus on Justice 40 and ensuring that every community gets charging, and that even the most rural disadvantaged communities will be able to participate and take advantage of EV charging in their community.
Thank you. Sounds like DOT is on it. My witness is available for questions.
Mr. Maxwell, do you have questions of Mr. Valdez?
Your Honor, I'll pass on questioning to allow more time for the board. Thank you.
Thank you. Mr. Domenici.
Good afternoon, Mr. Valdez. Just a couple of quick questions. I think you've been here this morning, haven't you?
Domenici, yes, I have.
So you understand the request here is that my clients are asking that this board put a stay or delay of the implementation of the clean cars portion of the regulation in effect while their appeal is pending. Is that your understanding?
Yes, sir.
And whether or not this board grants that stay or denies the stay, all of the actions you've just described are going to continue full speed ahead, correct?
Mr. Domenici, Chairwoman and members, yes, that is.
That's all I have. Thank you.
Okay, thank you. Mr. Bach, do you have questions? All right. Let's start with the City County Board. Chair Paul, do you have questions of Mr. Valdez?
I don't have any questions. Thank you.
All right. Vice Chair Richards.
I just had one question, and I don't know if you know the answer to this since you're working with the state DOT, but have similar grants been provided to City of Albuquerque to strengthen the infrastructure for EVs here?
Chairs, members of the board, I'm happy to announce that just recently from a funding source outside of the funding sources I mentioned, we provided a grant to the City of Albuquerque under our carbon reduction program for $3.8 million to the City of Albuquerque to advance their electric infrastructure in the city of Albuquerque, as well as a project that they have designated at the Sunport.
Thank you very much. That's all I had.
Thank you. Member Armijo? Member Galuski?
No questions. Thank you.
Thank you. Member Coleman? Good, I'll move then to the EIB. Member Garcia.
Sir, do you ballpark idea of state? Yeah.
Member Garcia, members of the board. So we've been really focused on level 3 because we're really looking at the mobility and the ability for individuals to traverse our state. From a level 2 perspective, of course, it's going to take additional time to charge your vehicle, anywhere from 3 to 6 hours, depending on the type of vehicle. So let me first speak about what we have done, and that's level 3. Level 3 charger can range from anywhere between $100,000 to $250,000 per charging infrastructure. That means if you have two chargers, like we do in some rural locations, for example, in Zuni, and Picoris, and other Tierra Marias, other rural locations, we're only putting 2 rather than 4. Those projects could run anywhere between $400,000 and $500,000 for 2 levels. Level 2, of course, are a little different. You can get a level 2 charging station in your home for as low as $500. And of course, that's all dependent on the infrastructure of your home. And I know that we have, in fact, put tax rebates in place through this last year's legislative process to put, I think it's a $400 rebate, so to upgrade infrastructure if it's necessary. So those can be as low as $500.
Thank you. Appreciate it.
Chair Sweeney.
Yes, thank you. Just had a couple of questions that were also associated with some of the testimony we heard this morning. And you mentioned just in your response to Member Garcia about charging stations at Zuni, Pueblo, and Zuni's pretty remote, having traveled out there a number of times, as well as Picoris. Are there other tribes or pueblos that you might be coordinating with? Because I do know state highways do traverse through tribal and pueblo areas.
Cheswina, yes. So what we have done is we met with a number of our tribal partners individually. I actually drove out to Acoma, spoke to Mescalero. I was at the Huaque Pueblo, speaking with them, as well as the great opportunity to speak at a tribal summit where leaders from our pueblos and nation were present. And one of the things that we really did is Orlando Teller was there, who represents the federal program. And we spoke about, again, the opportunities and the eligibility that they had to be direct recipients of some of the federal funding. I also want to mention, and I didn't mention when the question came up about the city of Albuquerque, every local tribal governmental agency is eligible for that 40% of the discretionary grant funding that is made available outside of the formulaic process. So we absolutely have met with our tribal partners, Acoma, because of they're on the interstate, as well, of course, Hawaii and other corridor locations. We're looking at seeing what we can do to partner with them with federal funding, while in the process also discussing about their eligibility and ability to go after these funds on them for themselves, be direct recipients of funds that are being made available.
Thank you for that. And so I know a lot of discussion and testimony this morning about Navajo Nation area, being that it's very rural. I know we do have state highways that go through Navajo Nation reservation boundaries. Has there been any consultation or coordination with the Navajo Nation Department of Transportation or other, other tribal representatives?
Yeah, sure. The Navajo Nation has been present during discussions at the federal level. We haven't necessarily had the same type of discussions we've had with the tribes that are already on these designated fuel corridors. Unfortunately, and this is one of the glaring issues with the federal funding that I've brought up on a number of occasions with our federal delegation while visiting them in DC, as well as our US DOT representatives, is that these designated corridors don't always necessarily represent what we believe is a true need for a rural, geographically large state like New Mexico. And so what my hope was, and what I had been advocating for, was for a de-designation of some of those corridors, which were still in discussion, because what's required is to build out the infrastructure on those locations before we could move to a location like the Navajo Nation with those federal funds. But because we now have this $15 million that is discretionarily able to be used by the state of New Mexico without no federal requirements attached to it, we definitely want to make sure that we're engaging and continuing the discussions that we've had with them, more formal discussions through those tribal summit, and let them know that although that we were advocating for these discretionary grant funding, since they have not come to fruition, we in fact do have state funds that we could help subsidize some of those projects for them in those areas.
Thank you for that. No further questions. Vice Chair Trujillo?
Yes, thank you. I was curious if there's any factors that are possibly inhibiting your speed in completing any of these initiatives that you've set forward. Yeah, I see you've got a lot of moving parts going with these, and you're applying for a lot of different, or you're getting money from different grants and other funding sources. And I'm just curious if there's anything that's holding back the plans and the progress that you're making, if your group is able to be as efficient as can be.
Member Trujillo, members, early on, absolutely. I mean, we have a tremendous amount of lessons learned. We actually just put together a public EV user guide. We put together a working group with the governor's office to really begin to share some of those best practices that we learned the hard way. I mean, this is something new for the Department of Transportation. It's new for our energy providers. You talk about multifaceted. We're dealing with energy components like transformers in a way that supply chain issues were really an issue early on. It seems like because of now the high level of collaboration that we have. Matter of fact, yesterday I was in Las Cruces at an energy summit, meeting with all of the co-ops as well as our investor-owned energy providers. We've also met and had discussions from a broadband perspective. Think about connectivity, being able to pay for that charge with a credit card, making sure it's secure, right, over the network. Those are all issues. What DOT does really well is we can build things. We can build the heck out of anything. But now you're dealing with energy, you're dealing with connectivity, and there is such an amazing collaborative effort on every front, from energy, Drew Lovelace with the broadband group, as well as even our payment processing requirements from a state perspective, utilizing our merchant, which is Wells Fargo, and how do we navigate being able to collect funding through a third-party payment processor. There's a tremendous amount of lessons learned that we put together. I'd love to share that public guidebook that just got completed, that you can see that some of those lessons learned are captured, which will also allow, when we're talking about City of Albuquerque, Navajo Nation, and all governmental agencies, what we want to make sure is we're setting them up for success, that they don't have to figure this out. We already took the bumps and the bruises, and we can share those best practices. We put it together in a guide. It's actually in my pocket. And that way they can really learn from our experiences. And so you're right. We've learned, and now we're firing on all cylinders. I didn't print the book, but what we did is we did QR codes. We're utilizing technology, right, to make sure that we can put a URL, people can log in, and still be a resource for those communities that can go after those large buckets of money the federal government is making available, that they don't have to come to the DOT. We support them. We provide technical guidance and support, and we make sure that they have the tools to be successful in their own electrification plans beyond just the DOT, because we're only one part of this story. We have private investors like Tesla and others who just made available their charging networks to Ford and other manufacturers. So we're just supplementing, not supplanting this build out in a way that we are all working towards this.
And thank you for that. So kind of bring it back around, one of the thing that we're considering here is the stay of a portion of this rule. And so I'm wondering if we were to grant that stay, would that impact, would it have, in your opinion, would it have any impact on the progress that your group is making?
Well, and I think, so the quick answer is no. And I think, like even Mr. Garcia mentioned, electric vehicles are coming. They're on their way. The adoption rate is what it is. I mean, I can't speak towards that. I'm not a professional in that aspect, but it's not going to slow us down. I get calls from constituents about when I'm going to put infrastructure in their community because they're considering buying an electric vehicle. So we talk about the options. We talk about home charging. We talk about the ability that 80 to 90% of their charging is going to happen at home. So that, they have an understanding that there's rebates available for them to make these installations. And if it makes sense that we supplement a charger in their location, then we're absolutely willing to consider and look at it from a location perspective in our GIS planning that we're going. But it's not going to slow us down. The funding is made available. Right now, I'm sitting on, $132 million, not of potential funding, not of, I hope I get it funding. I have $132 million that I'm currently working for the build out of EV infrastructure in New Mexico, with the hope that I get more on the next round of discretionary grant funding. Imagine if I got another award, just like I did this last February, $67.7 million, that would put us at about $200 million of funding. But right now I have $132 million that I'm building.
Thank you very much. And I appreciate your enthusiasm for your job. You seem to very much enjoy it.
I absolutely love my job. Well, more than anything, thank you guys, because it's the same deal. We're all working to make New Mexico better, right? This is really what this questions are all about. And we're all part of something that's new. We're actually trailblazers into something that's generationally changing the fabric of what we're doing in America and in our state. And I want to make sure that I'm part of that. So thank you for recognizing.
Thank you. Member Ely?
No questions.
Member Bitzer?
I have no questions. Thank you.
All right. Thank you very much.
I have no questions.
I don't know if you guys wanted any of that guide, but I do have them. I'll leave them with. Thank you.
I would like to call my second witness, Claudia Borchert.
Would raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you.
And could you state your full name for the record and briefly introduce yourself?
How close? Really close? That good? All right. Good afternoon. My name is Claudia Borchert. I'm Climate Change Bureau Chief in the Environmental Protection Division within New Mexico Environment Department.
And Ms. Borchert, you submitted written testimony in this matter. Is that correct?
Yes, I did.
And would you summarize that written testimony for the boards now?
Yes. Good afternoon, Chair Swina, members of the EIB. Good afternoon, Chair Paul, and members of the Air Quality Control Board. It's nice to see all of you again. I am here today to confirm that there is no good cause to approve the movement's motion for stay on 20.2.91 and MAC, particularly sections 108 and 109. In New Mexico's adoption of California's advanced clean card. By staying this rule, substantial harm will result to the auto manufacturers, the primary regulated party, Part 91, and harm will ensue to the public interest. Let me elaborate. Staying the rule will result in harm to the auto manufacturers who will lose, and I want to repeat, lose the opportunity for an easier glide path towards the first 4 compliance years because of the suspension of all of the New Mexico and the ACC2 pre-compliance flexibilities that are built into Part 91. Auto manufacturers understand this advantageous economic opportunity in New Mexico's rules. And as our attorney pointed out, I note that not a single manufacturer is seeking to stay or appeal any sections of Part 91. New Mexico NMED's exhibits demonstrate that the Alliance for Auto Innovation, which is the trade group for around 98% of the manufacturers, have been educating their members on the opportunity and the actions that auto manufacturers must take to avail themselves of the early action credits. Manufacturers have already contacted the Climate Change Bureau inquiring about how to report model year 2023 deliveries so that they can earn those early action credits. The board may also be aware that earlier this week, Stellantis reached an agreement with California Air Resources, CARB, indicating their support of advanced clean cars too in California and other Section 177 states. They've committed to spending $6 million for infrastructure in Section 177 states, which would include New Mexico if the rule is not stayed. Also, because auto manufacturers know that every PHEV and BEV they deliver to New Mexico right now in model year 2024 and in model year 2025 will also earn early action credits, they are highly motivated to deliver vehicles now. This is by design. Staying Part 91 will disincentivize deliveries from manufacturers, reducing consumer choice in New Mexico and postponing the important health benefits from the rule. I would like to clarify a few points regarding the straightforward rule and the straightforward flexibilities therein. Movements continue to cite maximum percentage compliance delivery requirements under the rule. We keep hearing about 43, 51, 59, 80%, but specifically 43, 51, 59 for model years 27, 28, and 29. However, the more realistic scenario that NMED presented during the rulemaking showed that manufacturers could deliver approximately 17%, 22%, 30% for those model years. Another option that's come up today is that manufacturers could deliver zero, absolutely no ZEVs to the state and purchase credits from other manufacturers who have overcomplied. In that case, a manufacturer like Toyota, for example, could make a decision that their delivery to New Mexico for the first 3 compliance years would be 0%, 0%, and 0%. In which case I'm not clear on what the harm would be to the movements. Staying the rule today further harms the auto manufacturers by not allowing them to get the credits for the vehicles to deliver to New Mexico in this critical year as consumers take advantage of the up to 3 vehicle purchase incentives available to New Mexicans right now. The rule also harmed the New Mexican car consumers who, because of limited selection or long ordering wait times, may not be able to take advantage of the multiple rebates and tax credits available this year, and therefore are not able to benefit from the affordability opportunities of total cost of ownership. Right now, and this was not the case in November during the hearing, some income qualified New Mexicans can save $14,000, up to $14,000 in qualifying new electric vehicles by combining federal, state, and utility incentives. This qualified car buyer can also save, on average, an additional $7,383 from the lower fuel and maintenance costs over the next 10 years. That's over $24,000 in savings over 10 years. This is the cost benefit analysis that NME completed in support of the rule. At NMED, it is my job to understand a vehicle emission performance standard, which by definition do not have any references in the EPA technical analysis that show a percentage of compliance that now the federal performance standards have is only a scenario. It is not an actual mandate, and therefore has no direct correlation to the requirements under ACC2. I think it's important that we not confuse that. One point, and also on the point of the EPA waiver, waivers often take years to grant after they're requested by CARB. So it's not surprising that EPA hasn't acted on CARB's request yet. The waiver is ultimately only needed when California or any other ACC2 state wants to take compliance actions against a manufacturer who is not complying. So the absolute earliest that need arises is May of 2027. Here we are, 2024, 3 years away. And again, in the flexibilities in ACC2, a manufacturer can ask for postponement of compliance for years. So it's if a manufacturer is not in compliance with model year 2026, they could ask for forgiveness basically and comply years later. So the issue of the waiver is to me it demonstrates it means that people need to understand what waiver to be or not. Regarding public interest, staying the rule harms those New Mexicans who want to buy new cars, who will be left behind when manufacturers preferentially deliver a greater selection and more affordable options of these clean technology vehicles to those approximately dozen states with the ACC2 rule. Staying the rules also harms New Mexicans in the used car market, who will have fewer PHEVs and BEVs to choose from, and thus less opportunity to benefit from lower fuel costs and lower maintenance costs. Staying the rule also harms those New Mexicans who benefit from community mobility programs that will be developed under the rule. Not all New Mexicans choose or can own vehicles. Among all 50 states, New Mexico has the third highest percentage of families living below the poverty line, 13.8%. Mexico also has the highest percentage of its population receiving food stamps at 17.5%, and the highest percentage with public health coverage, almost 50%. Those individuals prefer or need public transit, ride sharing, car sharing, or other alternative options will be harmed by staying the rule and delaying the implementation of mobility programs that work for them. Finally, staying of the rule delays the rule's clean air. Staying the rule continues the emitting of soot and smog into the air that we all breathe here in New Mexico. This is particularly harmful for those 1 in 7 New Mexicans who suffer from devastating respiratory disease, asthma, and COPD, according to the American Lung Association. These New Mexicans spend on average $3,000 in medical. Delay in bringing more clean cars to New Mexico delays their relief. And to be clear, the federal rules will not have the same air quality impacts in New Mexico as Part 91. NMED brought forward Part 91, recognizing that the rule provides the choice for all New Mexicans to have access to the best clean energy vehicle technologies. Choice to access. As demonstrated by the objective science-based evidence presented at the hearing, the rule significantly benefits the health and environment for all New Mexican communities, whether they purchase a PHEV or not. Now, 4 months later, the weight of the evidence presented still stands, and both the auto manufacturers specifically and all New Mexicans generally will be harmed if the program is paused.
Thank you. Thank you very much. I would just like to follow up on a couple points there, just to make it perfectly clear. This rule does not require any manufacturer to deliver electric vehicles to any specific dealership in the state. Is that right?
Chairs and boards members. Yes, the rule is a statewide requirement and specific to any one location.
So a manufacturer can meet their requirement without delivering any electric vehicles to, say, Gallup, for instance.
Chair and boards, and yes.
Yeah. And one further thing, you saw the letter from the Navajo Nation president, is that correct?
Chairman and chair and members of the board, boards. Yes, I did.
All right. And you've read that letter, is that right?
Yes, I have.
Okay. Does that letter ask for a stay of this rule?
The board, no, it does not.
Okay, thank you. That's all the questions I have. The witness is available for questions from others.
Thank you, Mr. Knight. Mr. Maxwell, do you have questions of Ms. Borchert?
I forgo questions for this witnesses favoring further board inquiry. Thank you.
Thank you, Mr. Domenici.
Thank you, Madam Hearing Officer. Ms. Borchert, talk about Section 108. I know you talked quite a bit about Section 109. What does Section 108 actually require take place, and when?
I would like a moment to pull that up. Could you please repeat the question?
What does Section 108 require and when?
Does it require and when?
Let me break that up. What does that require manufacturers do with respect to model 2027 vehicles that they want to deliver new models in New Mexico?
Section 108A requires that they follow the CCR, which is the California Rule Title 13, Section 1962.4, which has the requirements of the delivery of it's the ACC2 rules.
I think you mentioned earlier that that is 43% ZEV vehicles, with the understanding that some of that 43% can be satisfied by credits. Is that correct?
The maximum is 43% for that year, for the model year 2027.
And that's delivered to dealers, correct?
They need to deliver that to the state.
Have any reason to believe that that delivery will go other than to dealers within the state?
I do. I think there are some examples where that would happen.
So perhaps a small part of that might go directly to customers. Is that correct?
Yes, and also to what are considered vertically integrated manufacturers that don't have dealers, that don't go through dealers.
And the ones that go to dealers, and you agree some of those will go to dealers, right?
Yes.
Those dealers, they don't have to sell them, right? They can let them sit on their lots.
There's nothing in this requirement that requires dealers to do anything with the vehicles that the manufacturers deliver to the state.
And if they don't sell them, they cannot get ICE vehicles. If they've already reached their maximum ICE vehicle in proportion to the ZEV vehicle, correct?
That's a distinction that this rule does not address ICE vehicles.
You understand that there is, you at least acknowledge from your position, there's a possibility that mandatory vehicles will sit on dealers' lots and there will not be a market for them in model 2027 vehicles that are required to be delivered to New Mexico. You at least acknowledge that possibility, don't you?
No.
So I just want to get your testimony. On behalf of the state of New Mexico, you're guaranteeing that all ZEV vehicles that are delivered to dealers in compliance with this regulation, model year 2027, will be sold by those dealers, correct?
I'm not making any guarantee.
You're not acknowledging that they possibly will be unsold, though. So let me just repeat. While not making a guarantee, while being unwilling to make a guarantee, you're not willing to acknowledge the possibility that those vehicles will remain unsold, correct?
The inner workings of the dealers and what happens on their lots and whether vehicles stay there or not, whether they get sold, is not the part of the work that I am an expert on.
And you don't know if those dealers will suffer irreparable harm if those vehicles sit on their lot and they're unable to sell them, do you? That's not within your expertise, right?
I am not making that determination on whether there is irreparable harm.
And have you done an analysis of the timeline that's likely to be involved in the determination of the appeal in this matter?
I understand that the appellate board has a lot on its plate and that the appeal process can take years. That's not an analysis of it's what I understand to be the case about the process in New Mexico.
If in fact the board stays Part 108 and the appeal decision comes down before any model 2027 vehicles are delivered, there will be in fact no harm whatsoever to the public interest.
No, I disagree.
There will be no emissions from vehicles that would otherwise have to be sold under section 108, if the appellate decision comes down before any of those vehicles are ever delivered to New Mexico, correct?
The Clean Air Act, Section 177, requires that the states give manufacturers 2-year notice that of the intent to adopt California's emission standard. My interpretation of that is that if a stay is granted, and even if the appellate court makes a decision, whenever the appellate court makes a decision, that is when the clock on that starts going. So that happens in calendar year 2026. Then the rules are stayed until model year 2030.
Are the rules stayed today?
No,
Were they stayed last week?
no,
Were the manufacturers on notice last week of the 2-year time limit?
yes,
And in fact, all of the timing for the rules was set up so the manufacturers would have notice in January of 2024, correct?
yes. Therefore, allowing the rules to go into effect by model year 2027.
And the manufacturers have all had notice for over 2.5 months of this rule, it having been in effect, correct?
Yes. I mean, we delivered letters to all of them, giving them notice, in addition to working through people like the Alliance for Automotive Innovation.
And kind of a final point, in terms of air emissions, air quality, and health benefits, that this request is only to stay the portion of ACC2, portion of the rule dealing with ACC2, which is set forth 108 and 109, correct?
I am aware.
And so this won't have any impact on the benefits from this rule or the other portions of the regulation.
I am aware.
Thank you. That's all I have.
Thank you, Mr. Domenici. Mr. Bach, any questions? We'll start with the City County Board. Chair Paul, do you have questions of Ms. Borchert?
I do, thank you. Good to see Ms. Portrait. Can you just restate what you said
We
about?
can't hear you.
Can't hear me. I'm not on mute.
Can see that you're not muted, but we still can't hear you. Also,
Members
the
online
screens
can
over
hear
our
you.
heads went black. You can hear me though, yes?
Yes. And online, they can hear me. Yeah.
We truly can't hear you, Chair Paul. Oh. Are you typing in the chat, Chair Paul? Mr. Maxwell's asking whether the speaker is in the room. Yes, Mr. Maxwell, the speaker is in the room with us. Chair Paul is indicating that her question is very long in order to be typed. Madai, would you please make contact with the IT folks again? Okay. In the meantime, Chair Paul, I will come back to you. I'm going to focus on the folks in the room first. So, Member Ely, do you have questions of Ms. Borchert?
Yes, I do.
Hold your face pretty close to the microphone without banging.
The last question from Mr. Domenici started to go down this path, but I'm just really curious what a stay would do to the 2-year time frame model year requirement under the 177 lead time under the 177 portion of the Federal Clean Air Act. if we stay the rule, does it move the lead time out, or is the rule having been enacted by January, or if there's a stay, would it still allow enough time or meet the requirements under the federal act to bring in Model 27 electric vehicles to the state? Is that clear?
Madam Chair and Member Ely, I don't want to opine on a legal question. Most people that I work with interpret Section 177 of the Clean Air Act very literally, and that the rules have to be in effect and give notice for 2 years. Some people could interpret that notice for 2 years differently under a stay. I would, from my understanding and working with the people that I talk to, I think that the rule has to be in effect, then you give notice, then the compliance period begins.
So it is possible that a stay for 2 years until the appeals court makes a decision, could delay the ZEV portion of the rule far beyond model year 27, but out to model year 29 potentially.
I think that is possible, yes.
Thank you.
Vice Chair Trujillo?
I just need you to help me understand this a little bit more. I'm kind of going down the same path Mr. Domenici was in his line of questioning. You mentioned that the requirement is 43% to be delivered to the state, and I think you said that's the maximum. Did I understand that correctly?
Madam Chair and Vice Chair, yes.
Is there a minimum?
Madam Chair and Vice Chair, there is considerable flexibility under ACC 2, and the minimum is 0. You can buy your way out of the delivery.
Okay, and I'm just walking through this. Okay, so I don't know if there's actually a question. So if there's not if there may not, in theory, be a delivery requirement, and the stay was granted, and the 2-year notice had to be pushed out, would there still be a violation of the rule when it does become? And if so, you just kind of walk me through that.
Madam Chair, Madam Vice Chair, are you saying that, okay, let's hypothetically say that the rule, the first compliance year is now model year 2029, and a manufacturer, well, all manufacturers have to comply with the rule. They have different ways in which they can do that. They could buy 100% of their delivery requirement through credits, and then deliver 0 vehicles and be in compliance. They could do nothing, and then they would be in violation of the rule. And however, the ACC 2 rules give manufacturers the ability to say, yes, we didn't deliver model year 2029. We plan to deliver more in 2020, 30, and 2031. We'd like to put a pause. We'd like to request pause on the compliance period and revisit it after the next compliance period.
Okay, and I'm not a big fan of hypotheticals in these particular setting environment. So I guess what I was trying to get to there was, okay, say it gets delayed to model year 2029, and that year comes up and only 30% get delivered, and the other 12% has to be made up in these credits, and perhaps that was an impact of a stay being granted. that's not a violation, correct? Is it? Or are we, I guess, I'm sorry, let me rephrase that for you. I realize it was a little when we're talking about the impact from a environmental perspective, and we find that we didn't get to the 42% that we're at, say 30%, and we're making up the other 12%, are we still having social impact or environmental impact? And if so, can you walk me through that?
Chair and Vice Chair. So I want to start by saying that these are compliance requirements. And there are considerable flexibilities in how one meets those that maximum number of 43% deliveries, both at ACC2 in the California part that Mexico adopted, mostly in Part 108. And then New Mexico added additional flexibilities with the early action credits in Section 109. The reason that that was included from the New Mexico perspective is because the sooner those vehicles get delivered to New Mexico, the greater the health, the economic, and the environmental benefits. So there is so when if we change the by granting the stay, those early action credits will go away. So it is unlikely that manufacturers are motivated to deliver vehicles this year, next year, all the way before that, before there is again certainty that the rules are indeed in place. And if they never go back into place, then as Andrew Knight said, we're going to be last again in the preferential delivery of new technology vehicles. I just also want to just be clear. So even if we take the first compliance year, even if you just take the first compliance year of model year 2027 for New Mexico, the credit, the flexibilities that already exist are that you can pool vehicles from other states, over deliver in Kansas, and have those come to New Mexico. You can take advantage of early actions, even under ACC2. You can also get credits for these clean mobility programs that I mentioned. And you can also get transfer credits that you have over-complied with under ACC1, use those in ACC2. So those are all the ACC2 flexibilities that already exist. What we've done in New Mexico are the early action credits and also the one-time values, where every early action credit doubles. And so for every car delivered early, manufacturers get 2 points, 2 values for those.
Thank you for walking about it one more time. And so my last question is just that if the stay were to be granted, the sale of EVs or the dealerships sales of EVs would rely on the local market. What the demand for that is? That correct?
Correct.
Thank you. That's all.
Thank you, Member Garcia.
Yes, I have a couple of questions. First of all, it was implied or actually stated that the Navajo Nation was not informed of the proposal for the rule and that they were not asked for input. Is that correct? Could you talk about what the tribal outreach was?
Chair Sweeney and Member Garcia. Yes, we did at least 3 outreach to all the tribal communities in New Mexico. Well, 4 actually. We reached out to all the tribal environmental directors. Those are essentially kind of my peers in all of the tribal nations and pueblos, alerting them of the rule and actually asking they wanted to learn more about them. This includes the Navajo Nation. We also presented. Well, I guess there's 5. We presented at IRAC and Interregional Governmental. Sorry, I don't remember what IRAC stands for, but that is again a group of tribal government employees, not necessarily leaders. We also presented to IAD hosts bi-weekly meetings for all tribal leaders. IAD being Indian Affairs Department, and we gave a presentation on these rules to those tribal leaders that, to a meeting that tribal leaders are all invited to. And then we also sent out by email and by paper mail letters addressed to each tribal leader, to all the 23 Pueblos, tribes, and nations in New Mexico. That includes the Navajo Nation.
Thank you. Moving testimony, written testimony, they seem very adamant that if a stay were granted, that New Mexico would revert back to INCARS 1, whereas Paul in hearing, Environment Department stated that that in our decision about the rule, it was either going to be in the federal rule. It would go back to the federal rule if we didn't approve 91. So there's a conflict there.
Okay, Chair and Member Garcia. So yes, that was the testimony we gave. We still believe that if EPA grants the waiver for ACC2, ACC2 then supersedes ACC1. ACC1 is no longer a rule in California, and ACC1 goes through model year 2025. When the waiver is granted by EPA, then ACC2 becomes the law of the land for model year, or no, I'm sorry, I don't mean the law of the land, the law of California and those following Section 177 states for model year 2026. And they are in conflict. So, and it's very clear in the California rule that when ACC2 begins, it sunsets ACC1. So in our case, if we do not proceed with ACC2, we revert to the federal standards, provided that a waiver has been granted for ACC2.
Thank you. So a waiver is not granted in the next stay. A stay were granted, would we revert to the federal requirements? And in that instance,
I think there's 2 things. I'm sorry, Chair Swina and Member Garcia, that need to happen for us to. Well, we have repealed ACC1, so we don't even have ACC1 on the books anymore. So I think the answer is yes. We would revert to the federal standards until during a stay, and if the appeal were successful, we would revert for either of those circumstances.
Thank you.
Sweeney? Thank you for that clarification. That was along the lines of, I was trying to figure out the timing of all this, and I know it's important. And I just want to bring up the last point you said about because we passed AC2, we are no longer can revert back to AC1. Is that correct?
I feel like that's a legal question.
Not without another rulemaking. That's what I would say.
Okay. And then how would that therefore affect the timing of notification to the regulated entities like the manufacturers?
Chair Sweeney, could you just make sure I know the notification of what?
Notification. Oh,
okay.
Sorry, I don't mean to talk over the court reporter or you. Yes, so I understand the notification of any change of current regulatory rule.
Chair Sweeney, so if we wanted to go back to ACC 1, we would need to do rulemaking again. We would need to notify them with 2 years. And by that point, I mean, it would be uncertain whether ACC 1 still existed. ACC 1 would not exist if EPA meanwhile granted a waiver for ACC 2. Am I clarifying your question?
You are to me, and I just want to go a little bit further in the timing. Hope I can hold my thought. My head is full of allergy stuff, but so therefore you made another statement earlier in your testimony about timing as well as so the the California rules going into effect. And then that then becoming a milestone in this timing. Therefore, if they go into effect, then that also is a milestone in terms of what can or cannot happen, meaning back to AC1 possibility. Am I understanding that correct?
Chair Sweeney, earlier what I said was that so all the manufacturers are on notice that California is planning on following their new rules, ACC 2, starting in model year 2026, right? They're 1 year ahead of us. Any manufacturer could essentially, and those other Section 177 states that are also following that, any manufacturer has to comply with the first year by May 1 after that year is over. So for model year 2026, the reporting and then the verification that all the manufacturers individually have complied happens sometime after May 1 of the following year. The waiver from EPA grants California the authority to take action on anybody who may not be complying. So my statements earlier were saying that only if people are not complying and only if California wants to take action on those manufacturers who are not complying, the earliest they would need that waiver would be May of 2027. Is that the timeline that you're asking for me to go over?
Yeah. Yes.
Okay.
So maybe a follow-on question is what would be the harm in terms of for the manufacturers if we kind of delay this process that we are currently in, could the state and then the manufacturers meet all the timelines going forward?
Well, Chair Serena, the first harm is what I would consider the glide path towards compliance in the early years. Right? One of the harms is that they have an economic incentive to provide early action, to deliver early. And so one of the great harms to them is that that glide path goes away until some kind of decision, uh, that whenever that stay is reversed or the rules are once again instated, that is when those opportunities would start again. So okay, so let me think through this. So the second part of your question is there any harm perhaps to manufacturers that whose first compliance year in New Mexico would be model year 2027? I think that is, I'm just going to be perfectly honest, I think is a question on whether, it's again a timing question, but is whether the notice requirement has been met. And again, just my professional opinion is that once the rules in place, the rules are in place again after a hiatus of some kind, that Section 177 of the Clean Air Act requires a 2-year notice. So it would, I suppose, potentially there would be no harm in the implementability of the first year compliance of model year 2027 if the rules were reinstated. Well, no, the rules would have to, if that is the interpretation that you need 2 years notice, then, and the notice always begins on January 1, right? So even if they just got stayed for a day, let's say, by my interpretation, that means that we're already into model year 2028. And if they get stayed into next year, we're into model year 2029.
Thank you.
Okay. All right. Chair Paul, I'm going to try to hear you again. We did have a little bit of IT attention since we last spoke. Can you hear me?
I'm okay. My question was addressed through Member Trujillo's questioning.
Terrific. Yeah, I saw your chat messages, but I'm glad we've established now that we can hear the people on the platform. Vice Chair Richards, do you have questions of Ms. Borchert?
Yes, please. Thank you, Ms. Borchard, for going through that. I think with these sort of hypotheticals, it gets very, very murky very quickly. So I just wanted to kind of ask a high level. What I'm hearing you say is that granting a stay actually would cause irreparable harm in the following ways, whether the stay is 1 day or several or years. One would be it would cause the auto manufacturers to essentially lose this glide path credit option, which has been built into the rule. And then I also understand from what you were saying that it would also impact the community, the public, because essentially you would be deferring benefits in terms of improved air quality by extending the implementation date. And then, do you agree with those 2 points?
Chair Paul and Member Richards, yes.
Okay. I think my question is also to you, whether or not by deferring through the state, deferring implementation, that we might not also lose some benefits associated with the kind of the momentum we have that one of the earlier expert witnesses spoke to, of the infrastructure, the charging infrastructure, as well as other funding opportunities. And I'm just wondering what your opinion is on that.
Chair Paul and Member Richards. Yeah, actually, that's I appreciate you bringing that up. We, I think that when New Mexico puts together a lot of the puzzle pieces that are necessary that lead to overall decarbonization of transportation, and there are many, right? This rule is just one. The infrastructure is another. Getting federal funding, uh, building consumer demand, educating the public, getting the right infrastructure in place, the getting the road fund to be solvent as we transition towards electric vehicles. There are many, but I think when we falter on any one of these pieces, and the clean fuel standard too that was passed in the legislature is yet another. When we falter in any one of these, I think that EPA looks at where is their money, or not just the EPA, but the federal money that's available through the IRA right now. It is massive. And whenever we falter on any one of those, I think the federal government has to wisely decide where can we put the dollars we have best to work in a state that's going to do something with it. And together with the clean fuel standard, these ACC2 rules, the ACT rules, HDO, the great work that Jerry's doing at DOT, the economic development opportunities that we're bringing forth in New Mexico, I think that right now, New Mexico is considered a good place for federal dollars to flow because we are being thoughtful and smart about the policies we're approving in this state. So a stay, I think, jeopardizes that momentum that we have. And I also just don't want to fail to mention, we are going after, I think maybe Director Mariano will testify to this. We're going after somewhere in the order of $400 million with an application that's due on April 1st. And again, when we start to roll back these policies, I think it jeopardizes our chances of getting that $400 million for New Mexico. And the money that we're going after is both for decarbonizing of transportation, but it's also very much focused on what the EPA defines as low income and disadvantaged communities, of which we have many, right? I think about landmass wise, 60 to 70% of New Mexico is identified as low income or disadvantaged communities. And we are taking those $400 million and really focusing it in those communities. That's what is also at stake here.
Thank you. I appreciate that. So I'm imagining that because we would be in a less competitive position through potentially a stay, and would lose that momentum, we would also lose the associated public health benefits in terms of health outcomes and improved air quality. Would you agree with that?
Chair Paul, Member Richards, I would, yes.
Okay. All right. Thank you so much. I really appreciate it. I just a general comment, and I guess it could be a question in terms of this. It's almost, I have background in economics also, and it's almost like a supply and demand thing, where, if you take a back seat because you lose momentum, the supply from what the opening statement was, the supply basically dries up and goes elsewhere. And so would you agree with that as well?
Chair Paul and Member Richards, I do not have a degree in economics. And I do, what I do think is that if we are no longer a Section 177 state, we will not have the supply in New Mexico that is delivered, the diversity and the variety and the affordability of the supplies that are delivered to other states. So I'm not sure if that
Okay,
answers your
thank you.
question or not.
Yeah, and I'm sorry, I didn't mean to put you on the spot. I was just, I think the opening statement to this series of expert witnesses was that that we could potentially become the last place for delivery if we were not a 177 state. So I was just asking your opinion about that.
Thank you, Vice Chair. Member Coleman, do you have questions of Ms. Borchert? Member Galuski.
My questions have been answered by the previous questioners, so thank you.
Thank you. Member Armijo. And let's go to Member Bitzer.
I have no questions. Thank you.
Thank you. Vice Chair Trujillo.
Yes, thank you. I just want to follow up on one of the questions I just heard. You mentioned that if the stay was granted, it'd be if I understood you correctly, I might have interpreted it wrong. So correct me if I'm wrong, but I believe you were saying that if the stay is granted, then it's like rolling back the regulation and the momentum loss of momentum. Did I understand that correctly?
Chair Sweeney and Vice Chair Mr. Hill. Yes, I think that if the stay is granted, then those before whom we are making our case on all the great work we've done in New Mexico will be like, huh, maybe not.
Okay. And I'm just trying to understand the legal map here. So whether the stay is granted or not, this is still going to the Court of Appeals, correct?
Correct.
So I'm just going to, if it were to be granted, would that be considered a rollback, or still moving? It still has to move forward to the Court of Appeals.
Really know how to answer that. It depends on who you ask, I suppose. I can't speculate as to how someone else might interpret the stay. It's up to them how they interpret it.
Well, I appreciate your candidness on that, and really what I was kind of trying to drive at there was that I understand, from Bouchard's perspective, the need to maintain that initiative and keeping the momentum going. And so I kind of wanted to put in perspective, like whether it is a rollback or whether it's a pause, and what the impact of that would be. So if that can't be answered, if it's really up to our own discretion at this point, then I completely understand that too, and I appreciate your candidness.
Thank you. Any further questions from either board? Thank you, Ms. Borchert. Oh, go ahead, Mr. Domenici. Over to the microphone, please.
Ms. Borchard, do you have your direct testimony available?
Would that be today from this process?
Yes.
Yeah.
I didn't notice anything in your direct testimony indicating that if the stay were put into effect, that the 2-year notice to the manufacturers would have to be restarted. So it's correct that you didn't consider that important enough to put in your direct testimony, right?
I will, it is not in my direct testimony.
You hadn't even thought of that before today, correct?
No, I mean,
What,
that is not correct.
okay. Are you familiar with the brief that was filed by the New Mexico Environment Department in opposition to the stay?
I am.
And you agree that there was nothing in the brief indicating that if the stay were granted, that the 2-year notice to manufacturers would have to be restarted?
Yes, I agree with that. That's not in the brief.
And if in fact the board chose not to stay section 109, well, I have 2 hypotheticals, but let me break them up. If the board chose not to stay section 109, manufacturers could attempt to develop the credits under section 109, correct?
Could you repeat that? I just want to make sure I am following all
If
your.
the board chose not to stay section 109, manufacturers could proceed to acquire or develop credits under section 109, correct?
Yes.
That would be regardless of whether or not the board chose to stay section 108 or not, correct?
I would have to go back in and read the intercorrelation between those two before I could answer that, because I've always thought of them as a pair, and I don't know what the purpose would be of developing 109 if 108 is stayed.
The purpose would be that we're waiting for an appellate decision. And so if people are handicapping that decision and trying to make business decisions and saying, well, I think I'm going to go ahead and develop the credits, but I don't have to deliver this massive amount of vehicles because 108 has been stayed. They could, until the appellate court tells me I have to, they could make a business decision to go ahead and develop the credits, but they would not have to deliver the vehicles, correct?
Right, I think he was trying to explain his question. Did you understand the question?
I do understand the question, and I'm going to go back to my because of the way they revert, especially 108 reverts back to ACC2 rules and 109 are the New Mexico specific rules. And I would really want to look at the two side by side before I made a statement about your question, an affirmative to your question.
And let me just make one thing clear. Does section 109 take effect before the waiver?
Yes, it does.
Section 108 take effect before the waiver?
No, it does not.
So they are separate in that sense, correct? One is not dependent on the waiver and one is, right?
Both are dependent on ACC2 being implemented.
Correct. But if the waiver is delayed for some reason or is ultimately not granted, or even before it's granted, 109 can go ahead and take effect.
Well, again, I want to think through that because 109 also has timelines associated with it that are related to the assumption that our first compliance year in New Mexico will be model year 2027. And given that I really am not quite sure what will happen either for the first stay. I mean, if the appellate court decides to do away with the rules, it's irrelevant. If they're upheld in the appellate court and there's a stay, I'm not ready to opine on that because of the timing issue.
Thank you very much. That's all I have.
Anything further, Mr. Knight? No.
Nothing further.
Thank you very much, Ms. Borchert. We need a break. So it's 3 o'clock on that clock. Let's break to 3:15. Ms. Miano, if you would raise your right hand. You swear or affirm that you will tell the truth?
I do.
Thank you. Go ahead, Mr. Knight, and you're going to have to get your mouth really close to the microphone.
Uh, Thank you, Madam Hearing Officer. I would call my last witness, Michelle Miano, and who has been sworn, and I will ask her at this time to introduce herself, provide a summary of her written.
Good afternoon, members of the board. My name is Michelle Miano, and I am the Environmental Protection Division Director at the New Mexico Environment Department. I'm here in support of our response to oppose the move-in's motion for stay. Our job at the Environment Department is not to follow the general consumer trends and what's happening in this quarter or next quarter. Our job is to work with the residents of New Mexico to make policy to protect human health and the environment, and be leaders for the residents of our state, and also as the second largest oil and gas producer in the nation, our country. This is not our first foray into mobile source emissions. At present, we are in the middle of two massive changes. Things change in our environment and our society all the time. There are two changes happening now that are massive. One is climate change and air pollution, and two is rapid technology changes. Is this better for people on the platform? Okay. So, of course, our first massive change is our climate. This is a hard job at the Environment Department, being the Environmental Protection Director and an employee with my colleagues, because this is pollution that you cannot see with your own eyes. So if you can't see, how do we know if the answer that climate's changing? And it's science. We know anthropogenic greenhouse gases are warming the atmosphere. We know that our air monitors are exceeding ground level ozone. And unfortunately, we know that internal combustion engines are a huge contributor to air emissions, being the second largest source in New Mexico. Our second massive change is technology. On the bright side, technology is changing too. We are developing cleaner fuels, we're developing cleaner electricity and vehicles that can run on those cleaner fuels. These are not easy changes. We know this. That's why we are taking a whole of government approach here at the state level, and the federal level is doing the same thing. These changes are hard, and this is why we are seeing unprecedented federal and state investment and government intervention in helping us all adjust with these changes. These support systems are all timed to exist now and be in place now to create the transitionary path that we need to transition from only a market of petroleum-based fuels to other fuels that we know are less polluting for the environment and public health. I'm very proud to say that the state of New Mexico has been a leader in this space. Not only has this board adopted Advanced Clean Cars 2, Advanced Clean Trucks, and the heavy duty vehicle emission reductions, our legislature has passed the Energy Transition Act requiring cleaner electricity sources and passed the transportation electrification plans that are requiring investor-owned utility investments in transportation electrification. And then in just this past legislative session, we have new credits, tax credits for new EVs, for used EVs, for new and used hybrids, and the infrastructure that those cars need in order to fuel. This is indeed huge. We also were able to pass a clean transportation fuel standard. I don't want to get too much into the weeds of this, but in Oregon, this Clean Transportation Fuel Standard program has generated $80 million of infrastructure for transportation decarbonization. This is the kind of investments that we're going to see here in New Mexico. We're working together to help all of us adjust to these changes to benefit all of us. And as my colleague so well put it, there's a lot to do, and we're all doing it at state government at the same time, working with tribal communities, community-based organizations. We're all sprinting to make this transition happen as seamlessly as possible. As my other colleague, Jerry Valdez from the Department of Transportation said, you know, there have been lessons learned along the way, but that's not going to deter us from helping to improve our air quality and helping to bring new technology to New Mexico and help address climate change, which is affecting all of us. I also want to note that the need for benefits now is huge. A question was asked earlier, what happens with all of this infrastructure that we're going to be putting in place for the next 2, 3, 4 years in order to meet the needs of these new kinds of vehicles? What we see in our biggest fears at the department is that everybody else in the country, all the big markets that are going to get these new vehicles and new technology, they're the ones that are going to be driving through New Mexico and using all of our infrastructure. It's not going to be for our residents. We want infrastructure to be used by our residents. We do not want to be left behind. We want to be first in this transition. Benefits are happening now, whether it's the EV tax credits, clean fuel tax credits that are going to be put in place now, or whether it's the grant proposals that my colleague Claudia Borchert referred to. We're applying by April 1st, and our adoption of advanced clean cars is included in the narrative of all of our grant proposals to the EPA that we're going to be submitting next week. These grant proposals are going to be bringing in infrastructures for schools, school buses, heavy duty trucks, medium duty trucks, and we're going to be part of a state, pan-state effort along I-40 to provide charging and zero emission or charging infrastructure and alternative fuels for zero emission vehicles. The reason why we believe these grants are so competitive that we're going to be submitting next week is because of this board's action in order to bring money of upwards of, we're allowed to apply for up to $500 million. We want that money to be here in New Mexico. I'd like to end by saying, let's keep New Mexico moving forward. Let's keep the momentum moving forward and work together during these changes. We're already being recognized as leaders. our council noted that we received national press on our adoption of the advanced clean cars, advanced clean trucks, and heavy duty NOx rules. I have meetings with business owners all the time, and they say, we want to come to New Mexico because you're leading the country. We know you're an oil and gas state, and you're taking steps that nobody else is taking. I'm very proud of being in those meetings and saying, yes, this is what we're doing. It has a real effect now in every meeting I go to, and I think it will continue if this board rejects the motion to stay today. Thank you.
Thank you. The witness is available.
All right, thank you. Mr. Maxwell, do you have questions of Ms. Miano?
Your Honor, I pass on questions for now. Thank you.
Thank you. Mr. Da Vinci?
Hello? Couple questions, Ms. Miano. In your role with the Environment Department, did you see the letter from President Nygren of the Navajo Nation?
Yes.
And the first line of that, he states, I am writing to you concerning the adoption of California Advanced Clean Car 2, AC2 rule adopted by the New Mexico Environment Improvement Board. Is that the same letter?
I don't have it in front of me, but I assume if it's the same as the
Exhibit 14. Yes.
yes.
And he lists several concerns in bullets in that letter. Were you aware of those when you provided testimony to the Environment Improvement Board for the adoption of Clean Cars 2? Were you aware of the bullet concerns that the president identified? So they're on page 1, there's bullets 1, 2, and 3. Were you aware that the Navajo Nation had those concerns when you testified in front of the Environment Improvement Board?
Yes, and it wasn't just the Navajo Nation. A lot of people from rural communities have concerns, and honestly, a lot of people in urban communities have concerns about what EVs are, how to charge them, what it means for rural communities, and so it's definitely been something that we've been addressing here at the department.
And I think you gave sort of a mission statement regarding transportation future related to climate. You talked about the federal government was making adjustments, the state government is making adjustments. Do you recall that, your opening statement?
Talking about my opening statement here?
Yes, just a minute ago.
Yes.
And when you were discussing those federal adjustments, were you referring to the EPA scaling back their proposed regulations for electric vehicles in the rule that they published, the promulgated rule they published on March 19th, 2022?
I appreciate your bringing that up. I disagree with the rolling back aspect. The EPA rules provide a larger glide path for the manufacturers, and the EPA has been working very closely with the manufacturers on that rule. Their end date of 2032 requirements remains largely the same. And so I disagree with the rollback. And interestingly, the timeline that the EPA has set for themselves on the federal perspective is very much in line with our timeline here in ACC2.
My question was a little more precise. you were talking about adjustments, and the EPA indicated they were making adjustments to make an easier glide path, recognizing that infrastructure needs, market conditions, customer concerns would not justify the more aggressive numbers in their rulemaking. That is the type of adjustment that I'm asking if you were supporting in your opening statement.
Again, I don't agree with your characterization of facts, and so I think we have a disagreement there. What I was referring to was the bipartisan infrastructure law, Department of Energy monies, the IRA monies, the massive amounts of federal investments that are being made available to states, local governments, and tribes in order to decarbonize all of our jurisdictions and economies as soon as possible.
But this is the most direct, on-point statement by the federal government with the sister agency to the New Mexico Environment Department, the EPA. This is the most direct, on-point statement with regard to how electric vehicles should be incorporated and transitioned. Wouldn't you agree with that?
That is the federal government's new rule that they have promulgated, which is strikingly like the ACC2 rule. Our rule as a Section 177 state is a little bit more aggressive and even more necessary now because of the EPA rule. All of the other states are going to be receiving deliveries from all the auto manufacturers of zero emission vehicles. And so for in Section 177 state, ACC2 is going to position us to be first and not last in receiving vehicles as part of that effort.
When you talk about last, but there are many states that are operating under the EPA regulation that just took effect. You're aware of that, aren't you?
It is a federal law.
And in fact, states have to opt out of that if they don't want to be subject to the federal law, which is what you proposed that this Environment Improvement Board do, is opt out of the federal law and use California's standard, correct?
Well, this rule didn't exist when we had the rulemaking. The EPA rule didn't exist. So for purposes of this board's action, I would say that the board took action not concerning this proposed rule at all. It took action to make a decision to follow Advanced Clean Cars 2 that California has set up, regardless of what happens at the federal level. And so I think that provides certainty to the auto manufacturers, a part of what's happening in federal national.
So I'm just focusing on your statement last. So are all of the states that are under the federal regulations last?
Well, according to the testimony of the auto manufacturers that I reviewed, New Mexico is a small market, and so we don't get priority when it comes to car deliveries. And so that's the basis for my statement that New Mexico is going to be left behind because the larger markets will be will have more power and have those cars delivered to them first.
When you talk larger markets, are you talking Section 177, or are you talking larger or other markets under the federal regulations?
I'm trying to recall what the testimony was from back in the rulemaking. I believe, of course, California sets the standard because of how big California is, but I believe, the Northeast corridor and Florida are also large car markets that the auto manufacturers deliver many, many cars to.
And you indicated that New Mexico is positioned based on the recent adoption by this board of not only Clean Cars 2, but ACT and the NOx rule, positioned to apply for funding from other federal sources. Is that correct? And in those applications, Do you make a distinction when you are noting for those funding entities that New Mexico has recently passed a regulation? Do you make a distinction that ACC2 is on appeal, the rest of it is final essentially, and it's not appealable?
No.
Do you consider that there is in fact a distinction between ACC2 and let's say the heavy duty trucks rule, because one actually has a right of appeal, which they are exercising, and the other one, there is no appeal?
Yes, I believe that each of the three rules is in procedural postures at this time.
And when you notify these funding entities, are you notifying them of the percentage of reduction of greenhouse gas emissions attributable to each of the three separate rules?
It depends what the grant application's for, right? So we have many grant applications. One of them is for example, school buses. And so for the school bus application, we're not talking about passenger vehicles and emissions reductions from passenger vehicles. We're applying for funding for different kinds of transportation projects, and we are evaluating the emissions reductions from those transportation projects. The way that these grant systems work is the EPA looks at how a state stacks all the different policies that are currently in place within that jurisdiction, as far as if that state is more competitive or less competitive for money. And so we include the actions of this board and other actions of other state agencies boards as indicator of, yes, EPA, we want up to the $500 million that you're offering.
And this was a question. Let me see, you may not have touched on this, so I probably won't ask. Okay, thank you very much. All the questions.
Thank you, Mr. Domenici. Mr. Bach, do you have questions of Ms. Miano? All right, thank you. Let's start on the platform. Chair Paul, do you have questions of Ms. Miano? You're speaking, I can't hear you. I'll move on, but I can come back to you. Vice Chair Richards, do you have questions of Ms. Miano?
No, I don't have any questions. Thank you.
All right, thank you. Member Galuski?
Sorry, I don't have any questions.
Okay, that was Chair Paul. Member Galuski?
No questions.
Member Armijo? Member Coleman? Member Bitzer? Moving to the other board.
No questions. Thank you.
All right, thank you. Member Ely?
No questions?
Vice Chair Trujillo?
No questions.
Chair Sweeney?
No questions.
Member Garcia?
No, thank you.
All righty. Thank you very much, Ms. Miano. Mr. Knight, are you offering exhibits or?
I would like to offer all of the exhibits in our NOI for admission for this proceeding at this time. Objections?
Do I hear any objections? All right. Thank you. They're all admitted.
This concludes our presentation. Thank you for your time.
Thank you very much. Mr. Bach, you have to take us home here. So no one on the platform can hear you unless you're speaking into a microphone. There are two mics there. No, not those.
Sorry about that.
Yes.
I like this one. We had served a demonstrative PowerPoint last night.
Guy is working on it.
We'll go ahead and call our first. Not sure where we're going to situate them.
Well, so you can sit up there and the two witnesses can sit there. Is it a panel of two?
Panel of three.
Well, there are three chairs there. We're just going to have to share the two microphones. And Mr. Bach, that microphone you can leave with them because the microphone in that chair is good. Good thing we're nimble. Okay.
Indeed.
Just a question. Should we just ask to advance the slides? For the
I think
next
that's
one?
a good idea.
Okay.
And Madai there is the one.
Great. Thank you so much.
So thank you, everyone. Our first witness panel is Kathy Harris, Aaron Kressig, Deb Kapiloff.
All right. If you would raise your right hand, please. Do you and each of you swear or affirm that you will tell the truth? Thank you. That was all three.
And why don't we go through and have each of you spell your name for the record? Deb, you want to start?
My name is Deborah Kapiloff. The first name is DEBORAH. Last name is KAPILOFF.
My name is Aaron Kressig, spelled AARONKRESSIG.
Good afternoon. My name is Kathy Harris, KATHYHARRIS.
Thank you. So I understand that you all have prepared a PowerPoint that summarizes your rebuttal testimony. Would you like to proceed with that summary?
Yes. Proceed. Okay. So good afternoon, members of the board, and thank you for taking the time to hear our presentation late on this Friday afternoon. I greatly appreciate your willingness to spend another day with us, and your commitment to be here on a voluntary basis is a testament to your passion for the state of New Mexico. So thank you. Next slide, please. Monkey. Okay. Well, we've introduced ourselves here on behalf of Western Resource Advocates, as is Deborah Kapiloff. Kathy Harris is here in her capacity with Natural Resource Defense Council. But I will note that we speak on behalf of not just our own organizations, but also a much larger group of nonprofit organizations focused on preserving New Mexico's environment. And collectively, our organizations speak on behalf of thousands of New Mexicans who are members and supporters who care deeply, as we do, about preserving a beautiful and livable New Mexico. And it's on their behalf that we speak today. So let's turn to the matter at hand. The purpose of this hearing is to consider a motion to stay of the Advanced Clean Cars 2 rule, which would put the rule on hold between now and the date that the appeal is decided. This has been discussed many times today. We are not here to relitigate the decision to adopt the rule or its merits. It has already been adopted. Movements needed to demonstrate that irreparable harm has been placed on them, and they have been entirely unable to do so. Next slide, please. Okay. So the points we're going to make today is that, again, the dealers have made no showing of harm between now and appeal, and when an appeal is likely to be decided. They have not attempted to quantify any type of economic harm. They have entirely failed to address the chaos and confusion that will ensue if a motion to stay was granted. And while this is not meant to be a discussion of merit, the movements have clearly tried to make a day about that in some fashion. We feel obliged to briefly rebut some of those points. The main points we'll be making is that policies adopted in New Mexico since the hearing have made the rule even more feasible, and that the EV transition continues to forge ahead. And the rule is needed in order to ensure New Mexicans access the benefits of the transition as soon as possible. Next slide, please. So again, the most important point that we're trying to make is that irreparable harm has not been demonstrated. It has not been quantified by the movements whatsoever. The case rests on speculation and anecdotes. ACC2, as was discussed extensively in the hearing, regulates auto manufacturers and not the auto dealers. According to the testimony of the dealers themselves, model year 2027 vehicles will reach New Mexico lots likely not till 2026. Thus, there is absolutely no explanation as to why anyone in New Mexico will be harmed in 2024 or 2025 when the earliest this
But
regulation.
I just want you guys to be able to defend these numbers because I think that's really important.
Yeah. Here, Paul, was that you?
Okay. I'm trying to see where it was. Earliest the regulation will go into become effective is 2026. On the contrary, as was discussed by MED, a motion to stay could cause economic harm and eliminate critical environmental and public health benefits by discouraging early compliance, delaying the delivery of EVs to New Mexico, and causing general confusion as to how the rule will move forward. One way to easily avoid this chaos and confusion is by rejecting the motion to stay, guarantee we stay on the track that this board voted to set us on in November. Next, although we have discussed all these things extensively, and the matter at hand is granting or denying this motion to stay, we will take the opportunity to rebut some of the substantive matters brought up by the movements of this motion. Next slide, please. So let me start with this one. EV adoption is not declining in New Mexico, or is it flat? That is proven not through speculation, anecdotes, or distorted graphs, but through verifiable data. Verifiable data and market analysis is what important policy decisions are made on. And the climate advocates are grateful that this board evaluated the data and determined to adopt the rule in November. Next slide, please. I'm going to move quickly through these. And just as a reminder, the EV market has expanded in a truly remarkable fashion over the last 5 years. Since the start of 2019, EV sales in the US are up 385%, while sales of traditional gasoline vehicles are down 14% over that time frame. And according to a study put together by the Environmental Defense Fund just this month, actual EV adoption has exceeded 85% of the expert forecasts made on the EV market between 2019 and 2022. And I'll just provide one example, which is that in 2019, Wood Mackenzie estimated that EVs, and that's plug-in hybrids and full battery electric vehicles, would account for 7% of all global passenger sales in 2025 and 14% by 2030. However, in 2023, EVs already accounted for 15.8% of all global passenger vehicle sales. We are already more than 7 years ahead of the projections made just 5 years ago. Experts have repeatedly proven to underestimate this market. Next slide, please. And despite what you've heard from the dealers about an EV slowdown, the global automotive experts, whose job it is to forecast the car market, predict continued strong growth for the EV market segment in 2020. All the ones displayed here show very strong growth in 2024. In the interest of time, I'll read just one of them from Cox Automotive. While not providing exact estimates of growth, they say, and I quote, "In the electric vehicle market, 2024 will be the year of more models, more incentives, more discounting, more advertising, more sales muscle. Demand for electric vehicles is increasing, and dealers and manufacturers know that selling more EVs will require additional." End quote. They also project continued growth in sales. Slide, please. And let's make no mistake, the global trends we are seeing are being mirrored here in New Mexico. The trend of EV adoption exceeding forecasts has occurred in New Mexico. Actual EV adoption in Public Service Company of New Mexico's service territory, which represents a large portion of New Mexico's population, has already greatly exceeded the modeling they did just back in 2020. In 2023, EV adoption was around 40% higher than PNM expected it would be by 2023. What's happening in New Mexico is mirroring trends that are occurring at the national and global level. Next slide, please. And just to reiterate, PNM, Public Service Company of New Mexico, is also forecasting strong growth in future years. With these projections, which again have proved very conservative, we are on track to reach levels of adoption that are well within reach envisioned by the Advanced Clean Cars 2 rule, given the flexibilities included in the rule. So what do we take away here? Adoption in New Mexico is surging ahead, and that is indicative of national and global trends. EV growth over the last 5 years has been remarkable, exceeding traditional vehicle sales and projections from expert forecasters. EV market is set for continued growth. These cars are coming to the dealers' lots, and as we will discuss later, they cannot come soon enough. New Mexico customers are eager for these cars, but currently can't find them. Next slide, please. And the incredible growth over the last 5 years, documented and forecasted into the future, is in no small part due to the incredible amount of private investment allocated by industry into the future of transportation electrification. $1.1 trillion has been made forward towards transportation electrification globally from private industry. Put that number in perspective, that is more than the annual gross domestic product of all but the 17 wealthiest countries on earth a year. A lot of money. And here at home, $265 billion has been made. This massive investment also indicates an incredible commitment towards ramping up electrification, which is of course critical because we need to ramp up electrification in order to address the urgent threat of climate change. The automakers here in the United States are coming around as well. You can see announcements made from Stellantis and the Alliance for Automotive Innovation. Next slide, please. This is the last one. The last that I have for you today is to rebut a claim we heard from the dealers at the November hearing. And again, it came up in the movement's testimony. And that is the claim that from Ms. Garcia that Stellantis is only providing battery electric vehicles to dealers' lots in ACC 2 states. This is discussed in our testimony at length, but let me summarize that testimony. The statement is false. Checked the inventory of several auto dealers in ACC 2 states, including several in California, where the rule originated in 2022. Here's an example on this slide. Clearly, even in California, the state that we've heard many times has the most EV sales in the country, first to adopt ACC 2. Stellantis dealers are still able to sell ICE vehicles. In fact, that is by far the majority of the inventory they have on their lot. Simply put, it is not true that adoption of this rule will mean that Stellantis forces dealers to have only EV inventory. They aren't doing that in other ACC 2 states. The rule does not require them to do that. In an announcement made on Wednesday, they reiterated that they'll be making ICE vehicles available to all dealers in all 50 states. There's no evidence in the record to support Mrs. Garcia's statement and clear-cut evidence that it is not true. And I will now pass it to my colleague, Kathy Harris.
Thanks so much, Aaron. And thank you all again for being here. I know it's been a long day, so really appreciate you spending your time on a Friday. Am I getting feedback? Okay, thank you. One point that I wanted to just also reiterate on the Stellantis announcement from Tuesday was Stellantis indicated their commitment to a hearing to Advanced Clean Cars 2. And as part of that announcement, they also indicated they're going to spend $6 million in states that have adopted ACC 2 to help build out charging infrastructure. And additionally, they're going to be providing resources to their dealerships on public education and to help ensure that the dealers are communicating the benefits of electric vehicles correctly, and that will help to further move these vehicles off of their lots. So that is a relatively recent development, and I wanted to reiterate some of the excitement that was coming from that announcement. If you can move to the next slide, please. So in addition to everything that Aaron said, I also wanted to address the concerns from the movements about rural drivers. While we've already discussed these points extensively in our testimonies in November, as well as our written rebuttal testimonies submitted this week, I just wanted to reiterate a few points. One is that, as we've heard again today, there's no requirement for any driver to purchase a zero-emission vehicle. But should rural drivers feel pure battery electric vehicles is not for them, but they still want to transition to a cleaner car, plug-in hybrids are eligible under this rule as well. And I feel as though that has been lost in the discussion today. Second, charging infrastructure continues to increase. Where the charging infrastructure has been placed thus far reflects where the largest populations are and where the largest adoption of EVs has happened thus far. But that's rapidly changing, as we heard in testimony today. Also, since rural drivers tend to live in single-family homes, those with electricity at their homes may be able to install charging at their home, which would alleviate the concerns of lack of public charging in these areas currently and can provide even more customer savings for refueling costs compared to gasoline vehicles. And for the travel that needs to happen longer distances, as you can see on the map, our corridors throughout the state are being built out to help really increase the range of vehicles traveling those longer distances throughout the state. And finally, on rural drivers, they can actually stand to benefit the most from this transition to zero emission vehicles. Given the lower maintenance needed on EVs, rural drivers won't have to worry about their vehicles breaking down as much. And if they do have an issue with, and they are needing to drive, they won't need to drive far distances anymore to repair those vehicles, as well as standing to save a lot from reduced maintenance costs. Next slide, please. So just really quickly, because I know this has been talked about a lot today, but since the hearing in November, we've continued to see EVs become cheaper and incentives becoming richer. Importantly, the incentive program we heard about that was recently passed at the New Mexico State Legislature, a large reason as to why that tax incentive was passed was because of advanced clean cars too. That was a key reason as to why there was a need for that, because we heard in the testimony in November that we needed an incentive program, and that was heard by legislators and ultimately was a reason as to why that incentive program passed. And I anticipate that we'll continue to see additional incentive programs and additional investments coming as a result of these regulations. There are also utility programs that are helping to provide additional benefits to low-income New Mexicans, which you can see here and are written significantly about in our testimony, but that includes $4,000 for new or used income qualified public service company of New Mexico customers, as well as $4,000 for new or used EV for income qualified El Paso electric customers as well. Next slide, please. But in addition to these incentives, we continue to see the upfront costs of EVs decreasing. And forecasts show that by the time these rules are in place in model year 2027, EVs will cost less than the gasoline vehicles upfront. That is even before incentives. The final point on this slide was already stated in evidentiary hearing, but bears repeating. By the time this rule goes into effect, EVs are forecasted to be cheaper to buy upfront before incentives. With incentives, they will be much, much cheaper upfront. And that's in addition to them already being cheaper today to fuel and operate. ACC2, adopted last November, will ensure these EVs are available for New Mexicans and they can capture the upfront and operational benefits of EVs while cleaning our air and reducing our impact on climate change. A motion to stay would put these near-term benefits in jeopardy. Next slide, please. You heard an awful lot about how unaffordable and how out of reach electric vehicles are, but such a statement has not been backed by facts. When we look at the actual best top selling EVs, what if we look at the actual top best selling vehicles in New Mexico? I think you'll find a different story, especially now. It's important to note that this table does not consider the utility investments for low income customers. If we factor those in, we get some truly remarkable outcomes. A Chevy Bolt could be $12,000. A Nissan Leaf, which is not indicated here, could be as low as $18,000, which seems pretty affordable to me. Next slide, please. We did this exercise in the hearing in November, but I think it's worth a quick revisit of the dealer's inventory for a recap. And without listing each of these dealers by name, just for the sake of time, let me offer you some trends. These dealers are offering very few and sometimes no vehicles under $30,000. That makes many of the models we discussed on the previous slide cheaper or more competitive with traditional vehicle options. And two, they are offering very few, if any, electric vehicles for sale. So that leads us to conclude that one, it would be helpful if we adopted ACC2 so they can have more electric vehicles available for sale. And two, their claims of EVs sitting on their lots for a long time doesn't seem to have much credibility, as there are very few or no EVs on their lots at the present moment. Next slide, please. The dealers say they represent the auto market, but customers drive the auto market. And the testimonials of over 40 New Mexicans gathered in the last week are submitted as an attachment to the testimony. But I wanted to just highlight a couple of those here. The anecdotes were collected by an email survey, and the survey respondents declared under penalty of perjury that their responses were true and correct. Now, we certainly acknowledge that these are anecdotes, and decisions like this should not be entirely based on such. But please consider them alongside our volumes of statistics, data, and market trends about actual New Mexicans' experiences trying to purchase electric vehicles here in New Mexico. I don't want to speak for these respondents, so I will just leave these up for a moment for folks to be able to read, but these are also included as an exhibit in our testimony, along with several others. I hope that was enough time to read, but if not, I encourage you to take a look later. If you could go to the next slide, please. But even in this week alone, we've seen significant announcements that reiterate that the future of our transportation system is clean. On Wednesday, the EPA announced new clean car standards, which are going to help clean up the cars on our road. However, I know we've talked about this extensively today, but just to reiterate, EPA's standards are different than ACC2. EPA sets emissions technology neutral standards, and there's no technology requirements under the EPA. Automakers have many paths that they could take to achieve compliance with the rules. It's been discussed a lot today about what actually the targets are within the EPA new clean car standards. And I know Mr. Dominici has stated that there has been a halving of the regulations, which I don't see evidence for, or that's not the full picture, which I wanted to describe for a moment. What EPA actually states is that between 35 to 56 of vehicles in 2032 are projected to be battery electric vehicles alone. This does not include plug-in hybrid vehicles, which when we consider plug-in hybrid vehicles, which again are also vehicles that are eligible under ACC2, EPA projects that there will be an additional 13 to 36% of sales. Combining these two, EPA projects that between 69 and 71% of plug-in hybrid and battery electric vehicles by 2032. Again, to reiterate, this is all based off of potential compliance pathways that automakers could utilize in order to achieve compliance. And EPA assumes that this is a pathway that automakers will choose because automakers have already invested billions of dollars towards electric vehicles, and it will likely be the most cost-effective way for automakers to achieve compliance. So again, should they choose that pathway, it's also notable to highlight that in model year 2027, EPA is estimating that between 32% and 34% of new vehicle sales will be battery electric vehicles or plug-in hybrids. But I also wanted to note that John Bozzella, the president and the CEO of the Alliance for Automotive Innovation, was present and spoke at the announcement, at the regulation announcement on Wednesday, and stated that automakers are all in on electrification. And I'll reiterate again that we've discussed in our testimony in November, no automakers have opposed this regulation in California or in any state regulatory process. Were they concerned about meeting these targets in New Mexico? They would be here. And I think it's just very clear that the future is clean vehicles and zero emission vehicles. But regardless of what is happening at the federal level, ACC2 continues to be vital here in New Mexico to ensure that EVs and the cleanest cars come to New Mexico, bringing the inventory that New Mexico drivers do want, providing stronger than federal technology standards that benefit customers, and providing resiliency against fluctuations at the federal level. The dealers stated that automakers don't care about New Mexico and they'll never be a priority for them. But ACC2 guarantees that New Mexico will be a priority for the delivery of electric vehicles. Next slide, and this is my final slide. So in conclusion, the merits of ACC2 have been argued extensively, and the joint boards have already adopted this policy. The hearing has already happened, and this is not a hearing on whether or not to adopt ACC2. It has been adopted. The question here, among other things, is whether the dealers will suffer irreparable harm before an appeal can be decided, and they have provided zero evidence of irreparable harm in that time. So sorry, there's one more slide. And so just to also, now I'll final end up, but what has changed since the hearing is that EV prices are continuing to fall. New purchase incentives from state and electric utilities in New Mexico have been in place in part as a result of adoption of ACC2. Federal incentives are available at point of sale for drivers to utilize today. The EPA tailpipe standards passed, and we heard further commitments from automakers on their commitment to a zero emission vehicle future. And the auto industry continues to promote and invest in electrification. So thank you again all for so much for your time, and I'm open to questions.
From Ms. Kaplan.
No, I'm just here to answer any questions about the New Mexico tax credit or utility incentive.
Thank you very much. Let's see, Mr. Maxwell, do you have questions of this panel?
Your Honor, I defer questions for this panel. Thank you.
Thank you. Mr. Domenici?
Hey, panel, I just have a few questions. Harris, I think you indicated that John Bozella, president of the Alliance of Automobile Innovation, was at the press conference where the EPA announced their regulation.
John Bozzella is the president and CEO of the Alliance for Automotive Innovation. And yes, he spoke at the announcement of the regulations on Wednesday.
It was quoted in the Journal as indicating the rules are a quote stretch goal. Did you hear him state that at that press conference?
The statement that he provided says this should give the market and this should give the market and supply chains a chance to catch up. But he also indicated that the future is electrification and automakers are committed to this EV transition.
All the rules a stretch goal.
I do not have the transcript of his remarks in front of me.
You all listed a number of clients, and also provided a number of testimonials. Navajo Nation is not your client, correct?
Well, I don't know that we have clients. So, but no, I guess we don't have clients or organizations, witnesses. Yeah. But I guess no is the answer.
The clients that you're testifying on as witnesses do not include the Navajo Nation.
We're testifying on behalf of organizations in a coalition. I wouldn't call them clients, but the Navajo Nation is not in that coalition.
Have any of the three of you spoken with any official representatives of the Navajo Nation regarding their position on ACC2 for New Mexico?
Do not believe so.
Now, a couple of questions out of your written testimony. These will go to you, Ms. Harris, and hopefully quick, but if you have your testimony, it'll make it quicker.
Yeah, and I do want to clarify that our written testimony is on behalf of myself, Aaron, and Deborah as well.
So this question may not be to you then. There is a chart, number of vehicles. This would be on page 16 and 17. Your testimony, maybe whoever is responsible for that chart would be the best person for my question. Let me know.
Yeah, please proceed with your question.
So you list these 10 most popular vehicles, then you have the MSRP. What does that stand for?
Stands for manufacturer's suggested retail price.
Did you do any analysis to see what the actual transaction price was for the purchase of these vehicles?
No, the way that I acquired these MSRPs is that I went to the relevant OEM website, and where there was the option to input a location specific zip code before receiving the MSRP, I used an Albuquerque zip code to procure these MSRPs. And these are also MSRPs for base models of each of these vehicles.
What do you mean by base model?
By that, I mean the most affordable model. Many vehicles have various trim levels. So, for example, for the Ford F-150 Lightning, I believe that Ford F-150 Lightning that is priced with an MSRP of $49,995 is the Pro version. There's also an XLT, a Lariat, and I believe perhaps another version of that model.
Thank you very much. This would be for Mr. Harris or Ms. Harris or Mr. Kressig. I'm not sure who. Well, let me ask you separately, and then you can defer to the other one if that's the best way. So, Ms. Harris, did the EPA soften the targets from the proposed regulation to the one that they actually implemented 2 days ago?
No, I would disagree with that.
Did they change their numerical mandates?
No, actually, well, I will say there's a slight difference. So again, EPA only provides a grams per mile tailpipe emission standard that happens annually. So what was proposed by EPA was in model year 2032, an 82 grams per mile and stringency, which again can be met by a variety of flexibilities within the rule. The final regulation that was passed is 85 grams per mile in model year 2032. So it's a slight difference in the final regulation, but it is very close.
And did the EPA propose more flexibility to allow they called a glide path for manufacturers to meet their requirements?
So I will say that the regulation that was dropped on Wednesday is over 1,000 pages. And given also needing to prepare for this testimony, I have not had a chance to dive deep into every single potential flexibility that's within the regulation. So it is hard for me to fully say that at this time.
And you haven't done, this would be for you or Mr. Kressig. Have either of you done any analysis as to the time that the appeal will take to be decided that is pending in this case?
I have not.
All the questions I have. Thank you.
Thank you.
Thank you. Mr. Knight. All right, thank you. Let's start with the State Board. Member Garcia, do you have questions of this panel?
Questions, thank you.
Chair Sweeney.
No questions.
Vice Chair Trujillo.
I have a couple of questions. Kind of follow Mr. Domenici's line of questioning. You mentioned that you represent a coalition of organizations and that you represent citizens of New Mexico. So if you could actually just kind of flesh that out a little bit.
Yeah, that was me who said that. And I think so. The Climate Advocates Group is several. It's many organizations are represented. And we have members. Those are people who are either contribute through small donations or are signed up for our newsletters, to be members of our organizations as either, in some cases volunteers, in some cases are just, okay, yeah, this is the list here. That participate in some ways through membership in our organizations. And I'll say that some of our organizations are more membership based than others. For example, Sierra Club is a well-known membership-based organization, but each of the organizations that are in our coalition have some form of membership in the state of New Mexico.
And so as you gathered the information for your presentation, and your testimonies, did you interview people in New Mexico? Did you work with local legislators? I'm just curious because it sounds like you're not based in New Mexico, so you're coming in to gather this information. Is that what I'm understanding?
So to be clear, many of the organizations that we represent in this coalition are based in New Mexico. That includes Western Resource Advocates, which has had an office in Santa Fe for decades, as well as NRDC, which has a large presence in New Mexico. The way that those testimonials that are attached as an exhibit to the testimony were gathered were through this local Sierra Club chapter. They are also represented by climate advocates and are part of this coalition. And so that email went out to a listserv of their members who then filled out the survey and allowed for their responses to be compiled as that attachment to our testimony.
Thank you. I appreciate Member Ely?
No questions.
Thank you. Member Bitzer?
I have no questions.
All right. Chair Paul?
No questions. Thank you.
Vice Chair Richards?
No questions.
Member Coleman? Member Armijo? Member Galuski?
No questions. Thank you.
All right, thank you. In that case, I think the panel can be excused. Thank you all very much.
Yeah.
All right, thank you, Mr. DeSalem. Mr. Bradley, would raise your right hand. Do you swear or affirm to tell the truth? Thank you.
My name is David Bradley, and my business address is 2511 First Street Northwest, Albuquerque, New Mexico, 87102. I'm an automobile dealer. I'm the owner of an automobile dealership.
Bradley, have you reviewed any documents in preparation for this hearing?
Indeed, I have read the testimonies of Ms. Garcia, Mr. Ortiz. I've also looked at the exhibits that were in the I forget what you call it, but yes, I did read it.
Okay, so you've reviewed the submittals that the auto dealers and Automundo Garcia submitted for this hearing.
That's correct. The New Mexico Automobile Dealers Association and Automundo.
Okay, thank you. And you prepared written testimony in response to the exhibits and the testimony middles that Automundo Garcia and the New Mexico Automotive Dealers Association presented.
Yes, I have prepared written testimony.
Okay, and I'd like to refer you to a document that has been marked as Climate Advocates D. Do you have that with you?
Yes.
Do you identify it?
Identify it? I wrote it.
Okay, so at your
Yes.
okay, prepared it yourself.
Yes, that's correct.
And do you adopt it today as your?
I do.
Now, could you briefly describe your business?
I sure can. I'm an automobile dealer of pre-owned vehicles. I've been in business just a few years with the idea to get into electric vehicles. So I started out with one. I have a very small lot. It's just me, I'm the owner and the only employee. I like to provide affordable vehicles to people, have them independently inspected before I sell them. I like to basically give all the information about a vehicle to a customer and not just sell them a vehicle, but provide the information that they need to make the most educated decision they can.
Now, Bradley, based on your experience as is it your opinion that demand for electric vehicles in New Mexico is strong?
Yes, it's my opinion that it's strong. I think since the Inflation Reduction Act kicked in with the $4,000 tax credit for used vehicles has helped out my business a great deal. That was when that first came out. It was similar to the New Mexico tax credit, where you see it the following year. It wasn't. You didn't get it at time of sale, right? They just provide the documents, and when they file their taxes, they get the credit. But yes, to answer your question, significant increase since then, yes.
Do you see demand for electric vehicles increasing or decreasing?
Yeah, increasing. I can't keep them in stock. I've never had my lot turn like this. And going forward, I'm probably just going to sell EVs. I have that opportunity now, so I'm really excited about it. The goal has been reached. And I'm at this rate, I'm selling twice as much as I have year to year. I think over twice as much right now. So I'm doing really well. I see the demand. I get calls almost every day about people that are interested in EVs. Sometimes they just want to talk, and sometimes they show up. So I'm open by appointment, and I do like to talk to my customers, whether they buy or not. I always feel that people should get the right vehicle for them. So I think a lot of it has to do with I can transfer this year. Since January, I've been able to transfer the tax credit. So if a customer comes to me and they qualify, I'm set up with the IRS to accept the transfer of cash in like a matter of a couple days, maybe 5. And I think that's had a lot to do with it, because I can advertise that $20,000 vehicle is now $16,000 if you qualify for the tax credit.
Now, do you believe that educating customers about electric vehicles is important?
Yeah, absolutely. Without educating any of my customers, I wouldn't have any business at all. If I have to explain the incentives to the customers and how they work and how they can qualify and why this vehicle qualifies and maybe another vehicle doesn't. I explain to them the maintenance issue, the lack of maintenance, really, that you can just, with an EV, there's such little maintenance on them. I mean, I explain it this way: you may not ever have to replace your brakes if you drive it right, with regenerative braking, and it. I think you know, you people's mind get blown when I tell them you can drive 250 miles. It'll cost you under $1. If you're on the PNM, if you sign up with the PNM, they will put in a new meter, and between the hours of 11 p.m. and 5 a.m., you can charge for, I think, 1 cent per kilowatt hour. I mean, that's awesome. 250 miles for under $1. I don't drive 250 miles a day, but if I did, that's a big selling point, you know. And then to not have to have oil changes and transmission fluid, you know, it adds up really quickly. You know, all those maintenance things add up. The lack of having to even stop for fuel. You park your car, charger's right there, plug it in, you go home and make dinner. I mean, it's a really easy life. So yeah, after a while, people do. I also educate people about New Mexico does have a unique transportation circumstance, right? A lot of people do travel from Los Lunas to Albuquerque or Santa Fe, or Albuquerque to Santa Fe, Berlin. A lot of commuters, and then we can talk about living way out in the country on the west or the northeast, where you travel maybe 20 or 30 miles to drop your children off at school. In a V8, that costs a lot of money. Right? That's a round trip, 50 miles. And then, another 40 miles to get to work. So at the end of the day, you're maybe looking at 150, 200 tops miles that you drove in one day. That's a lot. And when you're getting 15 miles per gallon, I can't tell you that this vehicle is going to pay for itself, really, in a matter of 10 years, I believe, between fuel and maintenance. And that's something that I think these vehicles were marketed towards the urban, right? Like you're not traveling far, because that was 10 years ago, even 8 years ago. So think about 8 years ago, we had a vehicle that only got a 60-mile range, a 75-mile range. It was definitely under 100, right? Nothing was, not much was, I think Tesla had, other than that, there wasn't a whole lot of range. So they were marketed towards urban, and it's kind of stayed that way. But if you really look at the numbers now, that the vehicles that are coming out right now this year is a minimum of 250-mile range. It's pretty good. And then, so for 8 years, we've practically tripled it, or quadrupled it. In 8 years, what's going to happen next? I mean, are we going to be at 1,000 miles per charge? I don't know. We don't know, because the technology is not there, right? It could still be at 300, but I highly doubt it. So that is, sorry if I went too long on that, but it just, life gets easier and it's cleaner, and they're a lot more fun to drive. After I put somebody in a car, after talking to them and I put them in, it's done, take it home. Thank you.
Okay, and you mentioned it. Found it.
Originally, yeah, I was a little intimidated having to sign up with the IRS and go through all the things. It took me 15 minutes. And then it took like about a couple of days. They got back to me, and I was approved to accept transfer of tax credits. And that's when everything changed. Once I could do that, and then I was a little weary that the IRS would forget about little old me, and I wouldn't get my $4,000 or 30% up to $4,000. And boom, it was there. I think in like 72 hours, maybe up to 4 or 5 business days. At time of sale with the customer, it takes about 3 minutes. it takes longer for them to sign the paperwork than it does to go through the portal and transfer the tax credit. It's pretty easy. I think I answered that right.
Mr.
Thank you.
DeSalen, pull the microphone closer to you, please.
That better? Now, Mr. Bradley, have some of your customers been misinformed about electric vehicles?
Of course, I think a lot of people are under misinformation. I mean, right now it's everywhere, right? From social media to the press. You're going to get a human interest story. My favorite was about this clown who, he was in New York. Christmas, they were going driving, and instead of stopping to plug in, he took the chance and he wound up getting his whole family stuck. So he had to call a tow truck. It was very sad, very sad story. But what we don't hear, how many people ran out of gas that same day, right? I mean, people try to push it. Those don't make the news. You never hear about that kind of stuff. So it's along the same lines. When you drive an EV after a little while, you have a different mindset. You know you're going uphill into the wind, and it's cold out. Like, make sure you have, just plug it in. Make sure you have a good charge. And I think, if you learn to prepare a little bit better. I personally do not like to charge outside of my home for several reasons. One is it's super cheap. So I do tell that to customers. But getting back to this, again, I've had several customers this year alone come to me, and they heard that there was no tax credit. Now, they knew there was a tax credit. So they said, no, really, this is a salesperson. There is a tax credit, I swear. And then the salesperson, there isn't. I'll get my manager, I'll prove it to you. And luckily, they came to me, and it was great for me. And we laughed. We had a laugh about it. And I just think that sometimes people aren't taking this seriously. That this is real, and dealers should be taking advantage of that. If there is one dealer that's not taking advantage of a $4,000 tax credit transfer, it's crazy, because it's the easiest sell in the world. There's my negotiation is like, I don't even have to negotiate anymore. I just show them the sticker price and then minus 4,000. Okay. I had an 82-year-old woman that was being shown a car by a salesperson, and he didn't.
Hold on, Mr. Bradley.
Sure.
Testing, we're going way beyond the written summary. We're just into sort of anecdotes. I would object to this continued testimony.
All right, thank you. Other than that, Mr. DeSalen, we have reached the 15-minute mark. Would you wrap up with Mr. Bradley,
Okay,
please?
we have just. Mr. Bradley, are you generally familiar with the Advanced Clean Cars 2 regulations that were adopted in New Mexico in November?
Yes, I am.
And is it your understanding that under these regulations, roughly 40% of the cars that manufacturers offer for sale in New Mexico statewide must be electric vehicles by model year 2027?
Yes, that is my understanding.
Okay, and is it, in your opinion, is it feasible to achieve that level of electric vehicle sales in New Mexico by model year 2027?
Yes, I believe it is. I think it would take a rise in technology, a lot of education, and a lot of attitude change. An attitude change would really be necessary.
Hold on, Mr. Bradley.
There's nothing about this in his testimony.
This is in his testimony, Mr. I believe the last paragraph of his testimony talks about regulations being feasible.
Right. Mr. Bradley, was that the end of your statement?
I'd just like to say, if we got on board with this, there's no reason we can't make it to 80% by model year 2032, by educating the staff, advertising,
letting customers know they need this, that it's okay if you live in rural New Mexico, you can make this work and we can make it work for future generations. I think it's important to be the leader. Again, technology is increasing every day, education and attitudes really need to change. That's a huge thing. Thank you for your thank you for having me.
Thank you. Thank you, Mr. DeSalem.
Thank you for the admission of climate advocates. If it's, I think I want to all of them. Didn't, just for the record, didn't number them, distinguish them from the exhibits that we.
All right, thank you for that. Do I hear any objections to the admission of the climate advocate
Objection from
exhibits?
Mr. Maxwell.
All right, what's your objection, Mr. Maxwell?
Your Honor, I respectfully object to the admission of Exhibit C on 4 grounds for relevance, hearsay, and 2 procedural points. Would you like me to elaborate?
Yes, please.
First, I argue the relevance of these public comments to the legal criteria for a stay is questionable. The primary legal considerations here do not directly involve individual opinions or experiences with electric vehicles, but rather whether the legal standards in a stay are met. This exhibit does not materially contribute to resolving the core issues at hand. Secondly, I believe the exhibit constitutes hearsay. These are out-of-court statements presented for the truth of the matters asserted in them, without these declarants being subject to cross-examination. This challenges the reliability and admissibility of these statements under established and recognized rules of evidence. Thirdly, I'd say the procedural manner in which these comments were collected and submitted does not align with the prescribed norms according to 20.1.1.304B NMAC and the procedural order set forth by the hearing officer at line 7 in the order. Public comments should follow a specific submission process to ensure fairness and consistency in considering public input. It appears this procedure was not adequately adhered to, and I believe compromises the integrity of these submissions. And as noted, my fourth objection is that it's labeled Exhibit C rather than numerically sequenced, and that also diverges from the rules, particularly 20.1.1.402 subsection B NMAC. On these grounds, I argue that Exhibit C should not be admitted into the record for this hearing. Thank you.
All right, thank you, Mr. DeSalem. Your response?
Let's see. A lot to respond to. I think I already addressed the numbering of the exhibit. As far as document being hearsay, the document is
Closer to the microphone.
sorry. The document is an exhibit to the testimony of the 3 witnesses that originally testified for climate advocates. It is part of the basis of their opinions. It may technically be hearsay, but the document that auto dealers introduced earlier, the letter from President of the Navajo Nation, that is also hearsay. There is an exception to the rule of hearsay, which is sort of a catch-all exemption, which I think you have applied routinely in these types of hearings, and would ask that the document be admitted under that rule.
All right, thank you. Mr. Maxwell, Mr. DeSalem is correct that hearsay is often accepted into an administrative record. Certainly, either board may give hearsay in the record less weight if they choose to, but for now, your objection is overruled and exhibits A through E are admitted. All right, Mr. Maxwell, do you have questions of Mr. Bradley?
Your Honor, I pass on questions for this witness in the interest of time.
Thank you very much. Mr. Domenici, questions of Mr. Bradley?
Madam Hearing Officer, Mr. Bradley. Have you ever owned a new car franchise dealership?
I have not. My grandfather had one.
You currently have about 9 cars for sale.
Roughly, right now, I do not.
Is that around the number you keep in inventory or try to sell?
10 is ideal. Right now, I have 1.
Do you ever had any of the manufacturers of the vehicles you sell require you to install vehicle chargers, obtain specialized equipment for yourself or your employees?
Manufacturers have not required me to do so. However, if you want to sell EVs, you should have an EV charger at your business. So,
how many cars did you sell in 2023?
I think approximately 28.
What the percentage of new car EV sales were 2022 or 2023?
I do not.
For a customer who wants to receive the $4,000 credit that you described, is there an income limitation that you tell them they must have?
Absolutely, there's an income.
Is there an age limit for that car, or age bracket for that?
Yes, there's an age bracket.
Is there a price bracket for that?
Yes, indeed, there is.
And would you agree that generally speaking, in the used car market, nice, affordable used car, gas or electric, in the $20,000 range or so is a target used car?
I usually would go for less, under 20,000. That's, yeah, I think that that's my target range.
And have you had any occasion to deal with any Ford Lightning trucks in your dealership?
I have not had any in stock. I've only driven in them.
And have you had any Toyota, Honda, or Subaru EVs?
No.
Thank you. One further thing. Would you recommend that people, members of the Navajo Nation that live on the reservation, buy electric vehicles from you?
Absolutely. I think I could sit down and have nice conversation for a long time. And I can give you an example if you'd like.
Did you review the letter from the president of the Navajo? Part of the testimony you said you
I did not read the whole letter, no.
understand the concerns. You have an understanding of what the concerns of the president were.
Absolutely. And I think with proper education and dialogue, we can work that through. I think it wouldn't be a problem at all. And I'd be happy to have that conversation. Absolutely. Thank you.
Thank you. Mr. Knight, do you have questions of Mr. Bradley? All right, thank you. Let's start with the City County Board Chair. Paul, do you have questions of Mr. Bradley?
Hearing officer, Chair Paul had to leave.
All right. Vice Chair Richards, do you have questions of Mr. Bradley?
No questions.
Right. Member Coleman? Member Armijo? Member Galuski?
No questions.
Thank you. Member Bitzer?
No questions.
Alrighty. Member Ely,
No questions.
Vice Chair Trujillo, Chair Swina. Oh, you do.
I just want to circle back around to why we're here today. So if a stay was to be granted, do you see any effect on your sales or the sales of EVs in your market?
I do have currently 2 customers that are waiting to see what happens going forward. They're, they would like that credit. So other than that, I don't think, I don't know how it would affect me personally, my business.
And you know, in the opposite, if the stay was not granted, what effect would it have on your market?
So if the stay is not granted, right, it's only more beneficial for New Mexicans to switch over to electric, right? They get another $1,500 tax credit that they can, use next year when they file, right? I mean, I think it would be good for business. I don't think that the stay would really affect me that much.
So it wouldn't have any effect on like inventory or.
I'm having a hard time keeping vehicles in stock. I'm lucky. I'm happy. I never thought that I could sell EVs and be lucrative, and it's been a great year. It really has.
Okay, thank you for speaking with us today and giving us a different perspective from a different place in the market.
Thank you for having me.
Chair Swina,
No questions.
Member Garcia.
No questions. Thank you.
Alrighty, I think then we're done, Mr. Garcia, and thank you for your testimony.
Bradley. It's a long day. A long day. Thank you for having me. I appreciate it. And you can call me Garcia as long as you call me. Thank you.
Thank you.
Thanks for having me.
Alrighty. So we would turn right now to the closing arguments. We had agreed that closing arguments would not exceed 15 minutes per party. We do need to mention something though, which is we are fast approaching the witching hour here. They start sending people into the room to escort us out, starting around 5:30 and reaching a crescendo at 5:45. So I'm going to ask for closing arguments, but I'm wondering, is it worth having a conversation before I do about whether the state board must act for some reason tonight, because we're facing the same thing we faced in November, is decamping to another location. Is there a legal reason why either board must act today? It's a sincere question on my part.
The air board has a requirement that if grant a motion within 60 days, it's denied. I don't know if that same language is in your rules. There's a 60-day time limit for the Albuquerque Air Board.
And are we up against the 60-day time?
I think they have 2 more. I think they have, I think, till April 7th calculated.
Hearing Officer Orth, this is Vice Chair Richards. I just wanted to let you know that we are planning on following up on this with a special meeting to act. So we had no, as we mentioned earlier, we were not planning on taking action today.
Okay. And then what about the state board?
Madam Hearing Officer, I was wondering if Miss Bowen, are you still on?
Can you hear me?
Yes.
Yes.
This is Council Bowen. The rule for the EIB doesn't say that it either has to be granted or denied within 60 days. It just simply states that action must be taken. That's somewhat ambiguous, meaning that the fact that you guys scheduled it for a hearing could probably fulfill that 60-day action requirement. However, regardless, as long as you take action before April 7th, you'll have complied with the 60-day if there's a different interpretation there. So long story short, yes, the EIB can recess and reconvene at a later date as long as it's before April 7th.
Sweeney, are you happy with that?
Yes, thank you, Ms. Bowen, for that input.
All right.
Board members, do you have any questions?
So my proposal would be that we hear their closing arguments because we're all here together and we still have another 40 minutes or so, which should be enough for the closing arguments. And that then you can choose at that point whether to decamp to another location or to set up a special meeting between now and April 7th.
Yes, thank you, Madam Hearing Officer. I think we'd be open to hearing closing arguments.
I think that sounds all reasonable. My only question is if we choose to move to another location, if we have one available and if it needs to be on WebEx or whatever platform we're on.
Well, you have so many people. I'm looking at a couple dozen people right there who have relied on the representation that this would be a hybrid meeting, that I would certainly encourage you to continue it as a hybrid. And the question of whether we even have another location to move to after 5 p.m. on a Friday, I could pitch to Madai here. I'm not sure the answer. Okay, so what she's okay. Okay, so I believe the answer is all right. So let's launch into closing arguments. Mr. Maxwell, do you have a closing statement to offer?
It's imperative to reflect on the broader implications of what's at stake. This hearing, while focused on the specifics of the motion to stay, taps into deeper concerns about the role in our economy and lives. Drawing parallels with other government interventions, such as the Affordable Care Act, raises valid concerns about the efficacy and outcomes of such policies. It is a reflection of a growing sentiment among Americans who question the wisdom of heavy government-driven approaches to complex issues, including our economic and environmental future. The narrative being advanced by some in Santa Fe, Bernalillo, and Washington, D.C. seems increasingly disconnected from the realities and needs of everyday Americans. There's a palpable sense of frustration with policies perceived as out of touch or overly prescriptive, particularly when they seem to contribute to broader issues of economic and moral decline. The decision before this goes beyond the mere technicalities of a regulation. It symbolizes a critical juncture in our state's approach to governance, economic planning, and environmental stewardship. Denying the motion to stay in this context can be seen as reinforcing a top-down approach that many fear will lead to further disillusionment and disconnection government and the governed. Furthermore, the process surrounding this rulemaking proceeding and this hearing has not been immune to scrutiny. Questions about impartiality and procedural fairness have emerged. A shadow over the proceedings has been cast. Such concerns do not merely affect the image of this board, but touch on the foundational principles of trust and legitimacy in our state structures. In conclusion, I urge this board to consider not just the immediate legal and regulatory questions at hand, but the broader context in which you make this decision. Granting the motion to stay is not merely a procedural step. It's an acknowledgement of the need for a measured, reasonable, and inclusive approach to policymaking, one that genuinely considers the voices and concerns of all New Mexicans. It's an opportunity to reaffirm our commitment to a government's model that respects the principles of democracy, accountability, and shared progress. Thank you.
Thank you very much, Mr. Maxwell. Mr. Domenici, for the movements.
Thank you, Madam Hearing Officer, chairs, and members of both boards. This is another chapter in this very interesting and very important rulemaking that you're involved in. I want to reiterate, the stay is limited in focus, and the request is only to the ACC2 portion of this rule. Your rule is in effect and will stay in effect with respect to heavy trucks and NOx. So you've already made a tremendous progress on the objectives that have been stated. You've also, I think, seen some mixing of the benefits of those two with the benefits of ACC2 and trying to identify some detriments to what you're doing. Based on in consultation with both of my clients, based on the testimony today, my clients are modifying their request for stay. We are not going to move to stay section 109. That is the flexible credit section of the regulations. We're not asking that that be stayed. That will continue to be part of our appeal because it's part of ACC2, but we do not ask that that be stayed. We withdraw that request. And we think that undermines most of the arguments that we heard today, because most of the arguments were that there would be uncertainty for dealers or manufacturers whether they could acquire credits. While this appeal is pending, that is gone. There's no one challenging that at this point. Now, in the sense that any appeal creates uncertainty, I want to, sort of reiterate that the idea that there's no uncertainty while your rule is on appeal is really leading you in the wrong direction. You have chosen, and you're not the only one. The California Air Board and many other air boards have chosen and have been put in the position by state statute and state regulation to be a heart and soul of one of the major transitions that was described pretty well by Ms. Miano, the transportation future, the climate piece of transportation, and how that's going to work out. That was not left to our legislature. That was sent to you to be done by regulating the car industry. So that's a fundamental issue that will be appealed. Is that really the way to do this? The second issue I already went through was, and you heard the confusion again today, is Clean Car 2, was it repealed by your last hearing? Probably, but before that, the way that I heard the testimony today, you didn't even need a hearing to repeal Clean Car 2. As soon as California adopted, Clean Car 1, as soon as California adopted Clean Car 2, notwithstanding that your counsel for NMED had advised all of you that if that occurred, Clean Car 1 would stay in effect. You just heard testimony today under oath that the fact that California has Clean Car 1 means Clean Car 2 is no equivalency, and there therefore is de facto no Clean Cars 1. You should have been told that when you were doing Clean Cars 1, because Clean Cars 2 was already in effect. All these people, dealers, all my clients, they should have been told when Clean Cars 2 takes effect in California, Clean Cars 1 is gone and you're under the federal regulations, which I think is, if you can sift through what happened today, Clean Cars 1 is repealed, but it didn't need to be repealed because California doesn't have it anyways, so it can't be in effect. Therefore, Clean Cars 2 is what applies absent an effective Clean Cars 2 in New Mexico. So we are only asking that Section 8, which is the requirement that this model year 2027, 43% of the vehicles, and yes, it might be reduced slightly by credits, but you hopefully have not been persuaded there's going to be miraculously 20-25% credits. They would have shown you some credits if they had them. So it's very likely Miss Garcia will get 35% electric vehicles. She won't be able to sell them. She'll sell her ICE vehicles to her longstanding customers to meet their needs, and she will be out of business while this matter is on appeal. The same is true of the other auto dealers, the Garcia dealers. They will receive 35% electric vehicles in a market that is flat, in a market that is selling 4% of those vehicles. There is no way 2 years from now they will be able to move those vehicles. Nothing here has persuaded you of that. Nothing has overcome the irreparable harm they would suffer. And then they suffer that harm, and then 6 months later, or 12 months, but it's not an indefinite amount of time. It's a limited window of time. The Court of Appeals will have a chance to rule on this groundbreaking piece of rulemaking for the state of New Mexico. Completely groundbreaking rulemaking. We are asking that while the court has a chance to look at that, the legal issues, the evidence, frankly, and that's the third argument on appeal. The evidence was a comparison of global, and you even heard it today, global trends, global statistics, global sales in Europe, somehow being translated to a flat 4% market in a rural environment where we lack the infrastructure. They don't translate. And we don't think the Court of Appeals will feel that there was sufficient evidence for this regulation. That's not the end of the world. That doesn't change the climate situation very much. We already heard a witness say the federal rules is pretty similar to what the state rule or the ACC2 is. So the federal rules will be in place, but they are emissions rules. They are not going to dump cars on manufacturers who can't sell them. That's the bottom line. The regulators would like to say this is a burden on manufacturers. The burden, you've heard it, you know, is on the dealers. The vehicles come to those lots and sit on those lots, and those dealers have to absorb them, sell them, try to keep their cash flow, try to keep their customers, try to keep their service departments. They will not be able to do it. And there's no reason to force them to do it because the harm is negligible. The only harm we really heard is the credits. And we've heard that and we're indicating go forward with the credits. The only thing you would have is perhaps for a model year, there would not be this forced dumping of electric vehicles on my clients while this appeal is being decided. At most, you're talking maybe the total sales you heard last time of new cars is 100,000 a year. At most, if you're talking 30%, you're talking 30,000 new vehicles wouldn't be dumped on these lots in model year 2027. You heard no one say that that's a distinguishable 1 year of those vehicles is any distinguishable adverse effect to the environment. That's all that you've heard about. If you really boil it down, that's all we're asking. Don't require that financial havoc to occur while this appeal, this groundbreaking, truly groundbreaking appeal is being heard. Clean Cars 1 was appealed by about 14 states to last I heard it was in the United States Court of Claims, Federal Court of Claims in DC, one step from the US Supreme Court. It took 2.5 years to get there. It's not even as groundbreaking as Clean Cars 2, as you all know. This rule is being challenged not just by these dealers, but by others, other states at the federal level. Is this really an appropriate use of the Clean Air Act? Is this an appropriate use of your jurisdiction under the New Mexico Air Quality Act? Was the evidence adequate to support this dramatic intrusion into the market? So let those issues be heard. The only thing we heard a concern was the credits. Let those go forward, but please stay Section 108, which is the mandatory requirement that while an appeal is pending, our car dealers could be forced to have to handle this large inventory that they would not be able to move and would not allow them to turn over their inventory and bring in more ICE vehicles for their customers. You've heard one entire segment of our community is going to be affected and opposes this. The entire Navajo Nation is speaking through their president. This does not work for them. That alone should be enough to say, let's let the appeal be heard. But unfortunately, their voice really wasn't made present at the last hearing, but you've heard it now for purposes of a stay. So I think you should give that some weight and certainly say for the dealers that might be servicing their customers, let's not force them out of New Mexico for cars. Let's not raise the used vehicle price. Let's not manipulate the market. Let's not undermine the market. Let's let things flow along the way they are. Let the manufacturers acquire credits, which should bring vehicles here that people elect to buy. And then let's let our Court of Appeals study this extremely important decision that you all had to make. You know how close the vote was on this board. I understand the Air Board had the benefit of seeing your vote and didn't have to deliberate long, but you know how difficult this decision was. And you can imagine it's not a slam dunk. It's something a higher court should take a look at the record and decide that record. And so we request a narrow stay of Section 108, which is the mandatory delivery to dealers in model year 2027. If there's any reason we don't have a decision by model year 2028, it would apply. The chance of that are very slim. There's probably only about a 50% chance we won't have the Court of Appeals decision before model year 2027. You may be bailed out. Even if you grant the stay, it may not have any effect. So with all that in mind, we think we've met the elements. We have a likelihood of success. We have irreparable harm. We haven't seen the public interest, particularly if we allow the credits to move forward. The amount of impact from that limited amount of vehicles not being forced to sit on lots as opposed to let ICE vehicles being sold for that small amount of time. We haven't heard anything showing that that is some type of irreparable harm to the public interest or the interest of the parties. Thank you very much for your attention and for listening to the dealer's position and the Garcia family's position. We really appreciate it.
Thank you very much, Mr. Domenici. Mr. Knight?
Thank you. So we're here today under 20.1.1.501. And 501C says that to determine whether a good cause is present to justify a stay, the EIB, with a 2/3 vote of the members voting, must consider 4 factors. Those factors are the likelihood that the movement will prevail on the merits, whether the moving party will suffer irreparable harm. So those first 2 factors deal with the movements. And the second 2 factors deal with everyone else. The second 2 factors are whether substantial harm will result to other interested persons. The last factor, whether harm will ensue to the public interest. So it's not really a matter of the movements having to meet these 4 factors, but the board must consider all 4 of these factors. Again, the first 2 factors relating to the movements, their likelihood of success and irreparable harm to them. The second 2 factors having to do with everyone else. All 4 of those factors must favor a stay. And If any one of those factors does not, in your opinion, then the motion fails. Regarding likelihood of success on the merits, the appeal of this matter to the New Mexico Court of Appeals is limited to a record review and will not consider any new evidence. In addition, the Court of Appeals will be applying a deferential standard, deferring to this board's interpretation of the Air Quality Control Act as long as it is reasonable. Given that there is a very solid legal technical foundation for the rule and that the hearing itself complied with all public notice and public engagement requirements, there's simply no basis, in our opinion, for the dealers to succeed on the merits of this appeal. If a stay is granted, substantial harm to other parties and to the public interest will result. And I think you heard extensive testimony today. It certainly is a lot more than the early action credits, the harm to public health, the air quality, and especially, well, not especially, but in addition to the manufacturers and the uncertainty, the possibility of resetting the 2-year notice period. There are a lot of ways that granting a stay could mess up this rule, far beyond the time required to decide the appeal. And in the meantime, again, the damage to the public interest will be significant. So all 4 of these factors need to support a stay, and in our opinion, none of them do. And in addition to that, I was waiting to hear some citation to authority about whether or not you can stay just part of a rule. I didn't hear any citation to authority for that proposition, and frankly, I've never heard of staying just part of a rule or one section of a rule. So I'm not even sure that as a legal matter that this board can even do that. Clearly, the dealers and NMEDA are asking you to undo the rule by granting a stay, even though they say, it's just temporary. We've heard the testimony today about what the implications for that are and how the risk that all of the work of this rule could be undone, even if that's not what the board is intending by the granting of a stay. It creates tremendous legal risk far beyond just the time between now and when the appeal is decided. So in short, you've heard all the evidence today. I certainly have full confidence in your ability to digest all that and come to the right decision. So I'll keep it short and let the board get on with deliberation if there's time.
Thank you very much, Mr. Knight. Mr. Bach, would you like Mr. Kressig to say what the security guard said? All right, thank you. Mr. Bach.
Madam Hearing Officer, Chair Sweeney, Vice Chair Trujillo, members of the board, members of both boards, thank you again for all of your time today and for your careful consideration of the evidence. The dealers have a very difficult showing to make today. They have to show that each of the 4 equitable factors supports putting this rule on hold. If any of the factors is missing, their motion fails. Based on the argument and evidence we heard today, the dealers cannot establish any of the stay elements. The most obvious gap is irreparable harm. The rule doesn't impose any obligations on the dealers directly. And even the indirect impacts of the rule are years away. The dealers admit that they won't start seeing model year 2027 vehicles, the vehicles subject to this rule, until 2026 at the earliest. That's a long lead time. This long lead time prevents the dealers from establishing irreparable harm for two reasons. First, the Court of Appeals could clearly resolve this appeal for 2026, especially if the parties ask for expedited consideration. I've litigated numerous appeals that have been resolved within a year. It can be done. If the dealers win their appeal and the rule is set aside before 2026, there is no harm at all. Carlos Garcia admitted this in response to a question from member Ely. So given this fact that the appeal can be decided before there's any on the ground negative impact to the dealers, there's simply no irreparable harm. The long lead time is relevant for another reason. The dealers have plenty of time to adapt. We have 2 or 3 years to build out new charging stations and continue educating consumers. EV technology will continue to improve. EVs will continue to become more affordable. And we have at least one other legislative session to consider additional incentives. So there's plenty of time to adapt and make sure that the Advanced Clean Cars 2 program is a success in New Mexico. The dealers can't establish the other state factors either. There just is very, very little likelihood of a success on this appeal. The Court of Appeals applies a very deferential standard in reviewing EIB regulations, as long as there's some evidence that supports the finding and it wasn't completely rational. The Court of Appeals will uphold it. And here there was ample evidence in the record that Advanced Clean Cars 2 is achievable and likely to deliver substantial benefits for New Mexico. And this distraction about the legal intricacies of Section 177, it's just a pure distraction. You all know why you adopted the rule. You adopted Advanced Clean Cars 2 because you thought Advanced Clean Cars 2 was good policy. You thought Advanced Clean Cars 2 would produce benefits for the state of New Mexico. Nobody told you you had to do it. No one told you you had to, that you would lose out on any other benefits of regulating heavy duty trucks or anything like that. The record is clear that Advanced Clean Cars 2 was adopted based on its own merit. Finally, the evidence is clear that a stay would cause substantial harm to the public and other interested parties. We heard from Ms. Harris that Stellantis announced earlier this week that they're going to invest $7 million to build additional charging infrastructure in ACC 2 states. And it makes perfect sense for manufacturers to start making those investments. Car manufacturers are in the business of selling cars. If they know ACC 2 is going to apply in New Mexico, they're going to invest money in New Mexico to make sure that they can sell the EVs and plug-in hybrids they need to sell. If a stay were to be granted here, it's going to muddy the waters, and more likely they're going to divert that money somewhere they know ACC 2 will apply than to put it here when there's uncertainty. We also heard testimony about the early action credit, and we just heard now, and I have 2 or 3 paragraphs left, so I'll be done. We just heard now that Mr. Domenici and the dealers are no longer seeking a stay of the early action credit program, but for practical purposes, they might as well be. Manufacturers are not going to send additional EVs to New Mexico if they don't even, if the rule is on hold, and they're not even going to, they're not even certain what path we're on. They're going to instead invest, again, send the investments to states that are sending a stronger signal that they're on board. So if there's a stay, consumers who want to purchase EVs or plug-in hybrids in New Mexico will lose out. Manufacturers that want to get ahead of their compliance obligations will lose out. New Mexicans who are harmed by tailpipe pollution will lose out. Tailpipe pollution contributes to heart attacks, asthma attacks, and premature deaths, among many other health problems. Those are irreparable harms. If you have a heart attack, that is an irreparable harm. having a few extra EVs on your lot is not irreparable harm. The longer we wait to transition to zero emission vehicles, the longer we're going to continue to see these public health harms. Why would we want to disrupt or delay action to increase EV sales and increase investment in New Mexico? There's just no reason to do so. Finally, we heard some questions about what would happen if the rule was stayed but ultimately found. I think this is a really complicated legal question, frankly, and I don't think any court has ever addressed it. But whatever, regardless of what happens, we're going to lose out as a state. You know, some people might argue that we have to delay the applicability of the rule until 2 years after the stay is lifted, or others might say, no, the rule goes into effect immediately, and then everyone's rushing to scramble at the last minute to meet those deadlines. So a stay is going to cause significant concrete harm. It's going to create confusion and reduce the benefits that have been amply demonstrated in the record. So all of these harms far outweigh the speculative concerns the dealers have raised. And just a couple points about the Navajo Nation, because that was brought up quite extensively by Mr. Domenici. I think it's really important to remember that ACC 2 does not apply on tribal lands. The tribes are sovereign nations and can have dealers sell the vehicles they want there. Moreover, the president of the nation did not say that he opposed ACC 2. He didn't say he wanted the rule stayed. He just said he had concerns that he'd like to discuss with the governor. I think that climate advocates certainly believe that it is incumbent upon the administration to engage in appropriate government-to-government outreach with the nation so that they can reap the benefits of the electric vehicle transition. But it's no reason to stay the rule. It's no reason to create the confusion and lose the benefits that we have chosen as a state to move forward with. So the party should move forward with the appeal, and they should frankly ask the court to expedite the process so we can get a decision in this year or early next year. But there's just no reason to stay the rule. It would just send a wrong signal to all the stakeholders and delay the progress we need as a state to improve air quality and fight the climate crisis. So again, thank you very much for your time. Very much appreciated.
Thank you, Mr. Bach. Thank you to all counsel for keeping your closing statements expedited. The security force here has graciously extended our time in this room another 30 minutes. So we will, unless I hear a reason not to adjourn the hearing and turn the discussion over to the chair of the state board for the question of whether you'd like to move into deliberations or set another meeting.
Thank you, Madam Hearing Officer. I just want to check, is legal counsel Owen still on the line?
Can you hear me?
Yes.
Can you hear me?
Yes.
Yes, Madam Chair.
Yes. I just wanted to double check with you if you had any time constraints on your end.
I do, but I can make it work if you folks want to continue. If you choose to recess, you just need to pick a date and a time and a location for when you'll reconvene today. So
Sorry,
those are your only considerations.
Hold on, Ms. Bowen. The court reporter couldn't hear you. Would you speak up?
I can try to be louder. Can you hear me now? Is that
It's
better? I just wanted to note that if the EIB chooses to recess and reconvene, you do need to pick a date, a time, and a location for when you'll reconvene, and you have to do that today so that we can post notice.
Thank you, Ms. Bowen. So I'm looking at the board. What's your feel? Do you want to continue? You want to deliberate right away? We only have really 20 minutes, maybe, in order for us to vacate.
Yeah, it's not a lot of time. I'd be okay deliberating today since we're all here. I would like to go into closed session for a little bit before we would do that.
Thank you, Member Ely. Is that okay with everybody else?
Yes.
Vice Chair?
Were we going to reconvene or I'm sorry, I don't know. We're going to deliberate and then go into closed session?
I think what the suggestion was, like, let's go into closed session and discuss the logistics and some of the things, because and then we can come back. Is that a possibility?
Your counsel, I think, should expressly bless the notion of going into closed session. Ms. Bowen? Ms. Bowen?
Yes, can you hear me?
Yes.
Thank you. Yes, I've spoken with the chair. The board can go into closed session to discuss the stay because this is a matter of pending litigation as well. I'm not sure, is the purpose of going into closed session here to discuss the logistics of reconvening the meeting, or is it to make a decision on the motion?
I believe if we can just discuss a couple of points, then I think we might be able to deliberate
Today.
today.
Okay. Great. Then yes, you're welcome to go into closed session. And Chair, just please utilize that language that I sent earlier.
Okay. So what legal counsel Bowen mentioned was a motion that we can enter where and I can voice that motion that I move that the board enter into closed session to discuss the motion for stay in EIB 23-56 pursuant to the Open Meetings Act, specifically NMSA 1978, Section 10-15-1, H7. I hear a second.
Second.
Thank you, Member Garcia. And Ms. Corral, would you please do a roll call vote for us to enter into closed session?
Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Carcelina?
Yes.
Vice Chair Trujillo?
Yes.
Thank you, Ms. Corral. The motion to enter into closed session passes. The board will now go off the record and will return in open session to take any action after the closed session. Thank you. Okay. Can you hear us, Barry? All right. Wonderful.
Yes, indeed.
So I think we have to move to come back into open session. Is that correct, Ms. Bowen? Hold on. Okay. The board is back on the record and is in open session. The matters discussed in closed session were limited to those stated and listed on the agenda. No action was taken during the closed session. Thank you. And so we're still on this agenda item and we are looking at setting a date for deliberation. Members, we are looking at our calendars. What would that date?
I wonder if that's enough notice.
I can't do Monday.
Yeah, and I think we need 72-hour notice for an
Well,
Today's
so-
Friday.
So it wouldn't technically be a special meeting. It would be a continuation of this meeting. And so the rule doesn't say that it requires 72 hours, but to your point, it's probably helpful for people, but not technically required.
Could we do April 5th?
In the morning.
In the morning.
I'm flying out.
Okay.
In the afternoon.
We could do the morning. April 5th. Okay, Barry, can you do April 5th? All right, see thumbs up. All right, so I would like to move that we set deliberations at a arranged location and hybrid, just like we have it today, and on 9 a.m. on April 5th. Member Ely, does that work for you? Yes, Ms. Bowen?
And Chair, we do need to specify the location, so I believe it would still be the same room.
Okay, can we just?
Or you can say the Capitol building.
Okay. I'm gonna amend my motion to say that the deliberation will occur at the Capitol building on April 5th at 9 a.m.
I second your motion.
Thank you, Vice Chair.
Madam Chair, we're trying to make sure a court reporter can be there too. I don't know if you could check her schedule.
Okay. Oh, yes. What? Well, she's gonna have to. Okay.
I'll get a different court reporter to cover that.
Okay, thank you, Mr. Domenici, and thank you, Madam Court Reporter. No worries. So we do have a motion on the floor and a second. Ms. Corral, would you mind doing a roll call vote on that motion?
Mr. Bitzer, how do you vote? Mr. Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Chair Suina?
Yes.
Vice Chair Trujillo?
Yes.
Thank you, Ms. Corral. And then with that, we're on the next agenda item, which is, I believe, next meeting, which we just talked about.
Can I
And
get that location just so I can pass it on?
it will be here at the Capitol building. The room
Same room?
will be to be determined. Yes, we will notice it within for the appropriate notice requirements. With that, we're on meeting agenda item number 8, which is adjournment. May I have a motion?
We adjourn. Second that.
Thank you. Ms. Corral, would you mind doing a vote on that on Member Garcia's motion to adjourn?
Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Chair Suina?
Yes.
Vice Chair Trujillo?
Yes.
Thank you. We're adjourned.